Business laws in CSEET is one of the subjects which you might not have studied in +1 and +2. But business laws is also the subject which gives you the foundation for all the subjects in CS Executive and CS Professional. That is why at Ekcel Academy, we are giving you this complete syllabus for free. Yes, you heard me right. In this video on YouTube, we have Elements of Business Laws, which is a subject in CSEET. The complete coaching is free for you. So make sure you watch this video till the end. If you don't know me, I am Company Secretary Alok, and I really help students to make sure they become Company Secretaries soon. And in this video, we have Hiral ma'am from Ekcel Academy, who has done a great job by teaching the students relating to CSEET. In fact, we also have the entire CSEET syllabus for free in English. Yes, all our classes are in English because some students say that they cannot understand classes in Hindi. So we do all our classes in English, and it helps every student who does not know Hindi or who wants to study in English. Everything is free. We also have a playlist where all the subjects are available. In this video, the complete video of the business laws is there. The complete syllabus is there. Hiral ma'am has done a great job. Watch this video. And to make it more interesting, if you go to our website excelacademy.com, the link is in the description also, you will get free mock test for CSEET. You can watch the free mock test and you will get a very good practice. Our students have passed CSEET with 100% result, all our students. And now we want to give it to you for free. If you want to practice more, we have extra test, and that is also free. You just have to go to our website excelacademy.com, EKCEL academy.com. You can see it on the screen also. Now let us get into the lesson 1 where Hiral ma'am will teach you this subject.
Hi all, welcome to Ekcel Academy's Legal Aptitude and Logical Reasoning classes. So this video is going to be about studying all the 8 chapters that form a part of Legal Aptitude and Logical Reasoning. So before we proceed, let's understand why this particular subject is important from a company secretary point of view. So being a CS, the field that will in which we'll be working the most is the legal field, or the field wherein law is applicable, and that's why it is very important for us to understand the basics of law, what constitutes any given law, and also logical reasoning. How is it that the knowledge that we have, how do we apply it, how do we use it in application in our daily lives? So firstly, we'll be starting with the first chapter, that is Indian Constitution. So to begin with, we have Indian Constitution, wherein we'll be understanding the basis on which the foundation of the law of India has been set. That is the Constitution, which is the document which contains all the provisions with respect to the functioning of the country. So without further ado, let's begin. Yes. So coming to the introduction to the Constitution lays down the basic structure of any nature's polity. That is how the nation is going to work, and what is it that the nation will abide by, what is the law with which the nation will abide by. So it consists of fundamental values, that is the vision of the founding fathers. It consists of 3 major things. So firstly, we have the preamble, which sets the tone for the Constitution. Second one, we have fundamental rights, that is the rights that the citizen of the country must have. And directive principles, they are in addition to the fundamental rights. What is it that the people of the country will be helped with? Then so preamble, fundamental rights, directive principles, and fundamental duties. So fundamental duties is something that the citizens are required to perform. So the first 3 is from a nation point of view, and the duties is from a citizen point of view. These form the soul of the Constitution. So 4 things. And it also reflects on the vision of the socio-economic change. So as we all know, Constitution was set in the year 1950 on 26th January 1950. That is the day that we celebrate as Republic Day. So this was the founding day for the Constitution of India. And this is the document wherein a difference was made between the pre-independence India and the post-independence India. That is, after commencement of Constitution, what is it that will be applicable to the country, to the functioning of the nation as a whole. So when we talk about the vision and the socio-economic change, so preamble expresses the ideals and aspirations of a renaissance India. So when we talk about renaissance, it means something that is rising, so something that is developing. So the preamble focuses on how India can be developed further. So there was a lot of struggle for dignity, and hence the constitution acts as a hope post independence, that is independent India, how it can flourish, how it can develop going forward. The scheme includes justiciable fundamental rights and non-justiciable directive principles of state policy. So justiciable basically means that it can be run in the court of law. So if any person is denied of fundamental rights, then this can be taken up in the court of law. However, when it comes to the directive principles of state policy, that is not justiciable, which means that it cannot be taken up for trial in the court of law. So when we talk about justiciable, it is whether trial in the court of law can be taken up or not. So fundamental rights can be taken up. Directive principle of state policy cannot be taken up. Judicial contribution is crucial for realizing the socio-economic rights. So when we talk about judicial, it is like there is a framework and there should be an enforcement of the framework. So without enforcement, nobody is going to take the framework to action. And that's why judicial contribution is very important for realizing any socio-economic rights. Yes, the Constitution also provides an emphasis on liberty and justice. So, Constitution emphasizes liberty, justice, equality before law, rights of the minorities and oppressed. It is established by the we the people forming the Republic of India. So, whenever we are talking about a republic, it is a people-centric approach. So, the preamble begins with we the people. So, anytime we see the word we the people, it means that it is promoting a republic idea. So it is a people-centric constitution. Republic nature fosters linguistic, ethnic, cultural, and religious diversity. Indian Republic upholds dignity and integrity despite occasional fissures. Now, when we talk about broad framework, how the constitution is set. So firstly, like we were discussing, it came into force on 26th of January 1950, which we now celebrate as a national holiday of Republic Day every year. It is a comprehensive document, that is, it consists of the government structure, that is, what will be the structure of the government as a whole, the rights of the citizens, and directive principles. So when we're talking about rights, it's the fundamental rights that we are talking about. All public authorities derive power from the constitution. So it means that any authority which is being set up, constitution is the foundation for that particular authority, and constitution will list down as to what are the powers that any given state authority or a public authority will have. So coming to preamble and its significance. So just like in any book, we have the index. So it will help us in understanding what the book consists of. Similarly, preamble is like an index to the constitution, wherein it sets the tone of the constitution. The main ideologies of the constitution are included in the preamble itself. So preamble sets the aims and aspirations of the constitution. It declares India as sovereign, socialist, secular, and democratic republic. So sovereign is for the people, socialist is welfare of the people, looking after the welfare, secular is where the state is differentiated from religion, it is not dominated by any religion, and democratic republic is where people have the power. So these words are very important when it comes to the preamble of the constitution. It secures justice, liberty, equality, and fraternity to the citizens. It affirms republican character and sovereignty of the people. So this is why preamble is so important, because it sets the tone of the entire Indian constitution. Coming to sovereignty and democracy. So sovereignty is basically there should be internal and external independence, and political sovereignty distributed between union and states. So a little later in the chapter, we'll also be understanding whether our constitution is federal or unitary. So federal basically means that the power is concentrated at the central level, and federal means that the power is distributed between the state and the center, and unitary means that the power is concentrated at a central level. So there is a bifurcation between union and states. And last, it is democratic character, wherein there is a right to vote given to major citizens, that is, citizens who have obtained the age of 18 or above, elected representatives, executive responsibility to the register, so legislature. So this is how the constitution promotes all of these ideologies and how the preamble has set the tone for the constitution. Yes. Next up is the Socialist and Democratic Republic. So socialist is something that was added by the 42nd Amendment. So this is important to remember. So if we are talking about the idea of a socialist constitution, this was added by the 42nd Amendment. So when we talk about amendments, why are amendments so important? So as we all know, the constitution was set in the year 1950. And now so many years post setting of the constitution, it is continuously evolving, that is continuous amendments. And these amendments become very important because with the changing time, with the changing rules, the constitution also needs to be amended from time to time to make sure it is in line with the developing times. So socialist was added by way of the 42nd Amendment to the constitution. Directive principles aim for socialistic goals, and democratic republic signifies government by the people. Basically, it says that the citizens have a right to vote. Federal or unitary, so like I was discussing earlier, constitution is federal with unitary features. So it means that there exists a concept of dual government. So when we are talking about dual government, it means both. So central also has the power, as well as state-wise powers are also distributed to the state governments with certain unitary features. So certain places is where the central government will have complete power, and that's why our constitution is neither entirely federal nor entirely unitary. So Supreme Court's view, federal features form the basic structure. So basically it is federal, but certain places there is also unitary structure that comes into place. Dual government, distribution of powers, supremacy of the constitution, independence of judiciary, written constitution, and a rigid amendment procedure. So if you see here, dual government, distribution of power, supremacy of constitution, these are all something that comes under federal. But independence of judiciary, written constitution, these all come under unitary. So that's why our constitution is both federal as well as it contains unitary features also. So federal features, what features in the Indian constitution make it a federal constitution? Authority derived from constitution for union and state governments. So there is a bifurcation between both union as well as state governments. Legislative and executive power division. So legislative is somebody who creates the laws, and executive is somebody who enforce this and administers it. Supreme Court guards constitutional provisions, decides union-state disputes, and interprets the constitution. So Supreme Court is the head of the judiciary, wherein it guards the constitutional provision. So if anybody is challenging the constitution, if it is challenging anything that is provided in the constitution, Supreme Court will be the one defending it. It decides on the union and state disputes, because something above both of these is the Supreme Court, and anything that is challenged in the constitution, interpretation of constitution, that is something that the Supreme Court will be doing. So here we have the preamble. So let's quickly go through this and understand. So the preamble reads as follows: we, the people of India. So this is what we were talking about. It begins with a we, the people of India. So this is a democratic approach. Democratic and a sovereign approach. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic. So these are the 5 words wherein preamble has placed its emphasis on: sovereign, socialist, secular, democratic, and republic. So these 5 words are extremely important when it comes to the preamble. And to secure to all its citizens justice. What form of justice? Social, economic, as well as political. Liberty of thought, expression, belief, faith, and worship. Equality of status and opportunity, and promote among them all. Fraternity, assuring the dignity of the individual and unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give ourselves this Constitution. So 2 days here, 26/11/1949, when we adopted the Constitution, and 26/1/1950, where the Constitution came into force. So these two dates are very important when it comes to understanding when the Constitution was adopted and when it came into force. So yes, when we were talking about the soul of the Constitution of India, there were three things. So first one was preamble, second one fundamental rights, and third one is the directive principle of state policy. So preamble is the introduction to the Constitution, which we just had a look at. Fundamental rights are rights that are guaranteed to the people of the country, and this is something that can be tried for in the court of law. That is, if any citizen or any person is denied of the fundamental rights, they can approach the court of law. However, when it comes to directive principles of state policy, it is not justiciable, which means that it cannot be taken up. It is like advisory, but it is not something that if denied or if not followed, it will be taken to the court of law. So understanding the second part of the Constitution, first one being the preamble, second one is the fundamental rights. So when we talk about fundamental rights, there are articles in the Constitution which talk about fundamental rights. So firstly, these rights secure liberty, equality and fraternity. It is envisaged in part 3 of the Constitution. So this is very important. So just to remember, the word socialist was added as a part of 42nd Amendment to the Constitution, and fundamental rights form a part of part 3 of the Constitution. So these are important when it comes to scoring marks in exams. So these are something that are frequently asked. So now there are 6 categories of fundamental rights. So we have equality, freedom against exploitation, freedom of religion, cultural and educational rights, and right to the constitutional remedies. So under each of these categories, there are multiple articles that talk about what exactly this right provides for. So without further ado, let's quickly understand these. So yes, firstly, classification. So now there is a difference between when the Constitution refers to persons and when the Constitution refers to citizens. So we will also be understanding who classifies as a citizen and what all classify as person. So under citizens, it is 15, 16, 19, 30. These are exclusively for the citizens of the country, not necessarily residents or corporations for that matter, only citizens. Rights for all persons, any type of person within the country. 14, 20, 21, 22, 23, 25, 27, 28. These are for all the persons, and absolute limitations are for these 5 articles. So as in when we understand what these articles stand for, we'll also be able to understand whom it is applicable to. State and fundamental rights. So fundamental rights are available against the state. So Article 12 defines state government as government, the Parliament of India, government, legislature of states and local authorities, which is within the territory of India or under the control of government of India. So even if it is outside the territory of India, but within the control of government of India, then it can be classified as a state. Now, what determining state instrumentality. So basically it is to understand that when is a corporation or when is a body said to be government owned. So there are a few pointers that have been listed out as the result of this case, that is Ajay Hasia versus Khalid Mujib. So this gives us a criteria for state instrumentality. So the name of the case is very important. Again, Ajay Hasia versus Khalid Mujib. So let's have a look at what is the criteria for any corporation to be known as a state. If the entire share capital of the corporation is held by the government, it would go a long way towards indicating it is an instrumentality or agency of the state. So first one we have is the share capital. So if entirely the share capital is held by the government, then this is definitely an instrumentality or agency of the state. Where the financial assistance of the state is so much as to meet the almost entire expenditure of the corporation, it would afford some indication being impregnated with the government character. So major expenditure is being provided for by the government. Whether the corporation enjoys a monopoly status which is conferred or protected by the state. So it has been given a monopoly status, and this is specifically given by the state. It is not self-declared, but something the government has declared. Existence of deep and pervasive state control may afford an indication. So again, control by the state. So far we've had share capital entirely, majority of the expenditure, monopoly, which is conferred by the state, and major control by the state. Then, if the functions of the corporation are of public importance and closely related to government functions, it would be a relevant factor in classifying a corporation as an instrumentality. So functions are of public importance. public importance is something that also determines whether the corporation is an instrumentality of the state or not. If a department of a government is transferred to corporation, it would be a strong factor interference of corporation. So earlier it was a department of the government, but then it was transferred to the corporation. This still gives us an indication towards this being a instrument of the state. So 6 things. First one, we have share capital, major expenditure covered by the state, monopoly, the control, it is of public importance. The functions are of public importance. Even though all of this is not present, if the functions are focused on public importance, then it will be a instrument of the state. And lastly, if the government department is transferred to corporation, there will be still factors which determine this as an agency of the state. Now, coming to justiciability of the fundamental rights. So when we were talking about this, whether it is triable in the court of law. So whether court of law can interfere when these rights are being denied. The answer is yes. That is why fundamental rights are justiciable. So Article 13 ensures fundamental rights enforcement. So when we talk about enforcement, why is enforcement so important? So now in a country, if there are fundamental rights that are present, but there is no enforcement, that is, there are no actions against actions against people not following fundamental rights, then it is as good as having no rights in place, because rights become enforceable only if there is certain check in place whether these rights are followed or not. So that is what Article 13 of the Constitution ensures. It ensures fundamental rights enforcement. So this is very important. Now, when we talk about laws, there are two types of laws, existing laws and future laws. So existing laws were the laws which were there prior to the commencement of the constitution. But with existing laws, if it is against the provision of the constitution, then the existing laws will become void. This is what Article 13 sub-article 1 provides, that existing laws are void if inconsistent with the fundamental rights, because fundamental rights came with the constitution, and if the laws existing as on enforcement of constitution are inconsistent with these rights, then the law will become void. Future laws will be void if they abridge fundamental rights. So future laws are something that came in after the commencement of the constitution, and they will be void if they go against the fundamental rights. So this is 13 sub article 2. The word law, according to the definition given in Article 13 itself, includes an ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India by the force of law. By the Constitution 24th Amendment Act, a new clause has been added to 13, which provides that nothing in the article shall apply to any amendment of the Constitution made under Article 368. It came up for judicial review in a number of cases, and the courts have evolved doctrines like doctrine of eclipse, severability, prospective overruling for interpreting the provisions of Article 13. So Article 13 basically says that since the Constitution is providing for fundamental rights, there also needs to be an enforcement in place, and it provides for the definition, it provides for the meaning of your existing laws, whether or not they'll be void or valid. Similarly, future laws, whether or not they'll be valid after commencement of the constitution, and the validity will be determined on basis of whether they are against the fundamental rights or they are for the fundamental rights. So this is what Article 13 talks about, that is the justiciability of the fundamental rights. So the first article when it comes to the fundamental rights is Article 14, that is right to equality. So Article 14, or the right to equality. Article 14 of the Constitution states that the state shall not deny to any person equality before law or equal protection of the laws within territory of India. So when we are talking about equality, it focuses on the fact that all the people will be treated equally, and if protection is being given to the one person, the same level of protection will be given to all. So this is what Article 14 focuses on, that is right to equality. It guarantees equalities before law and equal protection of law to every person. So not only treating them as equals, but whenever the matter of protection comes in, the protection has to be equal to all. Now, equality before law implies no special privileges, and all persons are subject to jurisdiction of ordinary courts. So it means that no person will get privilege over the other. And when it comes to trying in the court of law, it will be ordinary courts that everybody will fall under the jurisdiction of. Equal protection of the law. So there are two terms here. First one, we have equality before law, and second one is equal protection of laws, which means that it ensures the rights and privileges without favoritism or discrimination. So this applies to all persons, including corporations. So when we were talking earlier, so it is not only restricted to citizens, but applicable to all persons. It is recognized as a basic feature of the Constitution. So example, a law, sorry, a law granting financial assistance to women below 14 for education can be valid if based on reasonable classification and intelligible differentia. So when we say right to equality, it is not absolute, it is not rigid that everybody has to be treated equally. In case of exceptions, the exceptions have to be valid. Like when we are saying, if there's a financial assistance being provided to women below 14 for education, then this is not a privilege, this is the constitution being considerate towards a particular section of the society. So in this way, this right is not rigid, but there can be certain reasonable exceptions to it, provided there is a justification for the same. Next, Article 14, right to equality. Article 15 is prohibition of discrimination. So, the Article 15, sub-article 1, it prohibits discrimination based on religion, race, caste, sex, and place of birth. When it comes to Article 15, sub-article 2, no citizen shall be subjected to any disability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or use of wells, tanks, public baths, roads, and places of public resort maintained wholly or partially out of state funds or dedicated to the use of general public. So again, no denying of any of these facility on the basis of these criteria. So earlier, what used to happen, depending on the classes, the wells used to be separate. So in villages, the common public would have wells that are separate, and say we know the concept of untouchables, right? So in case of untouchables, the access to wells would be denied, which is wrong, and that is something that the Article 15 prohibits. It prohibits discrimination. So Articles 14 spoke about equality. Article 15 talks about prohibition of discrimination. So yes, there are certain exceptions. Like I was saying, it is not rigid. There can be certain reasonable exceptions as long as they are justifiable. So when I talk about Article 15, sub-article 3, the state can make special provisions for women and children. So this, why is emphasis given to women and children? Because these are certain groups of people that are in the developing stage. That is we have to ensure that the rights are being enforced and applicable to this set of people as well. And that's why Article 15.3 says that if there are any special provisions for women and children, it is not going against Article 15. Article 15, sub-rule 4, the state can make special provisions for advancement of socially and educationally backward classes, scheduled caste, and scheduled tribe. It means that if you are making any provision for any of these categories of people, it will not be a discrimination. Article 15 sub Article 5 added by the Constitution 93rd Amendment. So this is added by the 93rd Amendment to the Constitution, which says that it allows the state to make special provision for socially and educationally backward classes, scheduled castes, scheduled tribes. This is nothing but our SC/ST for admission to educational institutions except minority institutions. So in this case, if you are giving any special privilege to backward classes, SC or ST, it is not going to be discrimination. Article 15, sub-article 6, it is added by the Constitution 103rd Amendment, allowing special provision for advancement of economically weaker sections, including reservation up to 10% in educational institution, excluding minority institution. And economically weaker sections, when we talk about this, these are basically defined by the state, and this will be based on family income and economic indicators, because these specifically focus on economically weaker sections. So coming to Article 15, when we talk about Article 15, we say that there have to be no discrimination on the grounds of religion, caste, race, sex. But when it comes to exceptions, these exceptions will be valid in case of women, children, socially backward classes, educationally backward classes, SC and ST, and this will not amount to going against the Article 15 of the Constitution. So far we saw three articles. So the first one being Article 13, which spoke about the justiciability of fundamental rights. Then we spoke about Article 14, which is right to equality. And then Article 15, which talks about being against discrimination. So moving on to the next article, that is the Article 16, which is equality of opportunity in matters of public employment. So Article 16(1) guarantees all citizens equality of opportunity in public employment. So let's focus on the fact that this is exclusively to citizens. So 15, 16 is exclusively for citizens, but when it came to 14, it was applicable to a corporation as well. Article 16(2) prohibits discrimination in public employment on grounds of religion, race, caste, sex, descent, place of birth, or residence. So something that we have to understand, and which is very important here, it matters of public employment, that is state-owned employment opportunities only. What are the exceptions? So Article 16(3) talks about where Parliament can require residence within a state or union territory for certain classes of employments. So in this case, if you are saying, if I want if the opportunity is available in a particular state and the state demands that residents should be in the same state itself, then it is not a violation of Article 16. Article 16(4) talks about reservation of appointments or posts for any backward class not adequately represented in state services. So again, this is a reasonable restriction because it is firstly talking about a backward class, and secondly, it is some class which is not adequately represented in state services. So this is an exception which is available in case of Article 16. Further, Article 16(4)(a) talks about reservations and promotions with consequential seniority for SC, ST, again not adequately represented. Article 16(4)(b) talks about unfilled reserved vacancies can be carried forward and filled in succeeding years without affecting the 50% reservation ceiling. Article 16(5) says that laws requiring office holders in religious or denominational institutions to belong to a particular religion or denomination are valid. So when we talk about equal opportunities in public employment, however, if it is related to any specific religion and the opportunities are given to people from that religion, then it will not be a violation of this Article 16. And then we have Article 16(6), which talks about reservation of up to 10% for posts for economically weaker section in addition to existing reservations. So when we talk about economically weaker section, it is based on their income and other economic factors that are there. So we spoke about 13, 14, 15, and lastly 16, that is equal opportunities in matter of public employment. Coming to Article 17. So when we were talking about access to public baths or wells or public places, we spoke about how untouchables earlier were treated as not a part of the common citizens. They had facilities that were exclusively only for them, and they couldn't access the facilities that were being availed by the rest of the people. So Article 17 is something that squashed untouchability. There is abolition of untouchability. So it is abolished, and in practice in any form is forbidden. Enforcement of any disability arising from untouchability is an offense punishable by law. So this is very important. This is how we define that fundamental rights are justiciable. Untouchability does not include an instigation to social boycott. Punishment for violation is provided by Article 35. So the Article 35 of the Constitution provides for the punishment in case untouchability is still practiced. Next up, Article 18 talks about abolition of title. So title basically is like a honor or like a tag that is given to represent seniority, to represent a higher status or class in the society. And this is something that was prominent during the British era. Like if you see the name of any rulers or any governors in the British environment, there would always be a word sir before the name. So sir is a title, and this title have been abolished with the advent of the Constitution. So Article 18 is a prohibition rather than a fundamental right. So no title except military or academic distinction shall be conferred by the state. Further, not only Indian citizen cannot accept a title from a foreign state also. Non-citizens holding office under the state cannot accept titles from foreign states without the president's consent. So, Indian citizen cannot accept foreign state titles at all. Non-citizens but holding office which is under the state, if they have to accept a title, then they have to get the president's consent. Persons holding any office of profit or trust under the state cannot accept presents, emoluments, or offices from foreign states without the president's consent. Now, coming to the rights relating to freedom. So, all this while we were talking about rights based on equality, that is 14 to 18. Now, we have the rights relating to freedom. Article 19 to 22 guarantee certain fundamental freedoms. So, let's have a look at that. So, now 19 talks about six freedom of citizens. So, Article 19(1) of the Constitution guarantees to the citizens of India six freedoms, which is freedom of speech and expression, assemble peacefully and without arms. Please ignore this. Yeah. Forms association or unions or forming association, union or cooperative societies, move freely throughout the territory of India, reside and settle in any part of territory of India. And there was a freedom to property also, which has been omitted by the 44th Amendment. Practice any profession, any occupation, trade or business. So this is something that is available to all the citizens. So if you see, Article 19 focuses on citizens of the country specifically. So these freedoms are fundamental rights recognized as natural rights inherent to citizens. None of these freedom is absolute. They are subject to reasonable restrictions. So again, absolute or rigid, these are not absolute or rigid. These can have restrictions. So again, restrictions, what are the restrictions? It has to be imposed by law. It must be reasonable and it must aim to achieve one or more objectives as specified in Article 19 with respect to that particular clause. Article 19(2) allows the legislator to impose reasonable restrictions on freedom of speech and expression under specific heads. So when we are talking about the six freedoms, they are not absolute in the rigid sense, but there can be certain exceptions as long as it is imposed by law and as long as the restrictions are reasonable. So what can be the permissible restrictions? So these are the factors that can be taken into consideration while imposing restrictions for Article 19. So we have the sovereignty and integrity of India, security of the state, friendly relation with foreign states, public orders, decency or morality, contempt of court, defamation, and incitement to an offense. So reasonable restrictions under these heads can be imposed only by a duly enacted law and not by executive action. So this has to be a part of law and only then that restriction will be reasonable and valid. So for example, a certain class of persons were denied to form cooperative societies. They contended that this is their fundamental right. So is the contention correct? Yes, because we are saying the so we have one, right, where it says formation of any unions, associations, or cooperative society. So if any citizens are being denied of this, then they are being denied of their fundamental right. So it is the fundamental right of citizens to form cooperative societies. Next, coming to the next one, that is protection of life and liberty, Article 21. So Article 21 guarantees the fundamental right to life and personal liberty. That is, no person shall be deprived of his life or personal liberty except according to procedure established by law. So basically, it means that you are allowed to move freely throughout the country, but if you are being deprived of this right, then there has to be a procedure established by law. So in case of arresting any person, their liberty is being curbed, but because this is a part of a procedure that is established by law, and hence this will be valid and this will not be a violation of Article 21. So the right to life includes aspects that make life meaningful and guarantee the right to live with human dignity. Right to live free from noise pollution is also protected by Article 21. So free from noise pollution, this is important. Right to travel is included within personal liberty, and denial of a passport without proper legal procedure is an unauthorized deprivation. So right to travel is liberty, and if you want to travel, say, outside of the country, you need a passport. So if you are being denied passport without any procedure, if there's a procedure, if there's a valid reason, absolutely fine, but without any of this, if you're being denied a passport, then this is an unauthorized deprivation of personal liberty. Next, Procedure established by law means a procedure laid down by the statute or as prescribed by the state. There must be a law justifying interference for life or personal liberty. The law should be valid, and the procedure laid down by the law must be strictly followed and be fair, just, and reasonable, not arbitrary, fanciful, or oppressive. So, in the name of law, if you're detaining any person, if you're arresting any person without providing valid grounds or valid justification, then it will be a violation of Article 21. So, it has to be within the procedure that is established by the law, and it has to be within the power that the law confers upon them. So now coming to right to education, Article 21A, the state shall provide free and compulsory education to all children aged 6 to 14 years as determined by the law. So this is free education provided by the state. So when we talk about these articles, they are mostly focused on a state. Like when we spoke about matters of employment, it was public employment. When we are talking about education, it is the state that will provide for free education. So these are not privately owned bodies. These talk about when the state is providing these opportunities. Next, protection against arrest and detention, Article 22. So this is again a matter of liberty. So let's have a look at this. No arrested person shall be detained without being informed of the grounds of the arrest and has a right to consult the legal practitioner. Two things here. If you're detaining someone, tell them why they're being detained, and secondly, give them an option to appoint a legal practitioner to defend them. Every arrested person must be produced before the nearest magistrate within 24 hours. So what is 24 hours? 24 hours, if there is a travel time of say 30 hours, then it does not mean that 24 hours is expired. It means excluding traveling time and cannot be detained beyond this without the magistrate's authority. So if you're arresting someone, produce them with the magistrate within 24 hours, excluding your travel time, and then whether or not they should be detained further is something that the magistrate will decide. Protection is not available to enemy aliens and persons detained under the preventive detention law. So this is very important. Article 22 is not applicable to enemy aliens and the persons detained under preventive detention laws. Right against exploitation. So, Article 23 prohibits trafficking in human beings, beggar, and similar forms of forced labor. These are all punishable by law. Article 14 talks about prohibits employment of children below 14 years in factories, minor hazardous employment, because this will lead to a safety of their a risk of their safety and risk of their well-being as well. Yes. Moving to the next part of it. So we understood rights of equality, right to freedom, and next one, as a part of right to freedom, we have the right to freedom of religion. So which are the articles that focus on this? Articles 25, 26, 27, and 28. So when we talk about right to freedom of religion, freedom of conscience and free profession, practice, and propagation of religion. That is, any citizen of the country can follow any religion of their choice. Freedom to manage their religious affairs. Freedom as to payment of taxes for promotion of any particular religion, and freedom as to attendance at these religious instruction or religious worships in certain educational institutions. This is something that cannot be denied by the Constitution, and the Constitution does not deny it. Right to constitutional remedies, Article 32. So Article 32 does not, it is remedial, not substantive, which means that it does not specifically provide for any right. It just says that all these fundamental rights that the Constitution mentions, these are enforceable. That is, there will be corrective action in case any person is being denied of the fundamental right that is available to them. So Article 32 provides for the right to constitutional remedies. And then there are supplementary articles, that is 33 to 35, that are again supplementary matters relating to the articles that we just discussed, and they do not create or guarantee any additional rights. So yes, these were right from Article 14 to Article 32. We discussed on the articles that are available as a part of the Indian Constitution. And now we will talk about, when we say Article 32, that is enforcement of the constitutional rights, fundamental rights, what are the remedies that are available? So it is a fundamental principle of jurisprudence that where there is a right, there must be a remedy. So this is important. The terminology is ubi jus ibi remedium. Wherever there is a right, there must be a remedy. Otherwise, there is no point of a right if it is not enforceable. Article 32 makes it a fundamental right to move the Supreme Court if a right is violated. So this is the right that Article 32 gives, that if any of your aforementioned rights are violated, you can move to the Supreme Court for it. This means a person can directly approach Supreme Court without exhausting other remedies. So Supreme Court is the authority in case of the ultimate fundamental right being violated. The Supreme Court can issue directions, orders, writs to enforce the fundamental rights. So we will be discussing these writs a little later in the chapter in detail. Parliament can assign this power to other courts without affecting the Supreme Court's authority. So now so to enforce fundamental rights, the Parliament has the power to assign this right to other courts, but it does not mean that Supreme Court's authority will be compromised. Supreme Court will be the highest deciding authority. The right to move to Supreme Court itself is a guaranteed right. This is provided under the Article 32. The Supreme Court is seen as a protector and guarantor of fundamental rights, and the court must protect these rights zealously and vigilantly. That is, if any case of any matter of any violation, then the court must practice this matter with the utmost care and importance, because this is a matter of violation of the fundamental right that the Constitution guarantees. Next, coming to the next part of it, directive principle of state policy. So in the beginning of the chapter, we understood that the Constitution consists of three main parts: preamble, fundamental rights, and directive principles of state policy. So now we are in the third part, that is the directive principles. So these principles are basically like advisory or guidelines, which are not judiciable. These are not enforceable in the court of law, but this is guidelines as to how the state can function. The subcommittee on fundamental rights suggested two types of fundamental rights. One is enforceable in courts and one is not enforceable in courts. So enforceable in courts, part 3, Constitution as fundamental rights. Then we have non-enforceable, which is part 4, that is directive principles of state policy. Articles 36 to 51 in part 4 contains the guidelines for the government. So we'll have a look at this from the module. Article 37 states that provisions in part 4 are not enforceable by any court of law. So part 4 is nothing but our directive principles of state policy. So part 3 is the fundamental rights and part 4 is directive principles. These are not enforceable by any court. These principles are fundamental in the governance of the country. It is the duty of the state to apply these principles in making any given law. The directives differ from fundamental rights in part 3 and ordinary laws. So we have an explanation as to how directive principles are different from the fundamental rights. So let's go back to our module to understand the difference. Yes. So now our module says that the directives, however, differ from the fundamental rights, and in which respect these are differed is here. So the directives are not enforceable in the courts and do not create any justiciable rights in favors of the individual. The first and the foremost difference is not enforceable. The directives require to be implemented by legislation, and so long as there is no law carrying out the policy, neither the state nor the individual can violate any existing law. The directives do not confer or take away any legislative power. The courts cannot declare any law as void on the ground that it contravenes any of the directive principles. So what happens is, if your law contravenes fundamental right, then that law can be declared void. But if it goes against the directive principles, the law cannot be declared void. The courts are not contempt to compel government to carry out any directives. So again, as the name suggests, these are directives, these are advisories. States are not compelled to follow these. Though it is the duty of the state to implement the directives, can only do subject to the limitations imposed by different provisions of the Constitution upon exercise of the legislature and executive power of the state. So this way, directives is only guidelines that the state can follow at their choice. If they are not following, then there is no enforceability that is available in the court of law. Okay. Yes. So important directive principles. So to be specific, the important directive principles are enumerated below. State to secure a social order for promotion of welfare of the people. So welfare of the people is something that the state should focus on. The state must strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political should inform all institutions of the national life. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, opportunities. So strive to minimize. If you are saying it is not a mandate, but the constitution encourages if the state wants to do this. Certain principles are followed to be followed by the state. The state in particular must direct its policy towards securing the citizens, men and women, equally have the right to an adequate means of livelihood. So again, this is directive that the ownership and control of material resources of the community are distributed as to best serve the common goods. That is, it has to be distributed in a way wherein everybody is getting a portion of it. That the operation of the economic system does not result in concentration of wealth and means of production to the common detriment. It means that concentration of wealth should be avoided and reduced as much as possible. However, this being said, it does not mean that if there is a concentration of wealth, then this will be a violation of the directive principle. No, this is just advisory. Equal way for equal work for both men and women. The health and strength of workers and children is not abused, and citizens are not forced by the economic necessity to enter avocation unsuited to their age or strength. So it shouldn't be like the economic situation of the state is so bad that even though you are not allowed to work, you are working. So we were also discussing in an article wherein any children below the age of 14 cannot be employed in any hazardous environment. It cannot be employed in like any factories. So again, this has to be made sure by the state, and this is one of the directive principles. The childhood and youth are protected against exploitation and against moral and material abandonment. Yes. Next part talks about how the state shall secure that the operation of legal system promotes justice on a basis of equal opportunity, and in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that the opportunities for securing justice are not denied to any situation by reason of economic or any other disabilities. The next directive principle is that the state must take steps to organize the village panchayats and enable them to function as units of self-government. So village panchayats are basically governing bodies that help in governing the village. So there will be like a chief that will be appointed, and there will be other ministers that will be appointed to the panchayat. So this is like the gram panchayats that we've all learned about before. So this is the responsibility of the state. Within the limits of economic capacity and development, the state must make effective provision for securing right to work, to education and public assistance in case of unemployment, old age, etc. Provision must be made for just and humane conditions of work and for maternity leave. The state must endeavor to secure living wage and good standard of life to all types of workers and must endeavor to promote cottage industries on an individual of cooperative basis in rural areas. So why are we saying all types of workers? Because especially in villages, there will be a lot of manual labor work that is involved. So a good standard of life is essential for all types of work, no matter what the work is. Next, the state should take steps by suitable legislation or in any other way to secure participation of workers in the management of undertaking, establishment, or other organizations engaged in any industry. The state must endeavor to provide a uniform civil code for all citizens. Provision for free and compulsory education for children up to the age of 14 years. So this was also Article 21A, that is the right to education. The state must promote educational and economic interests of scheduled caste, scheduled tribe, and other weaker sections. The state must regard it one of its primary duties to raise the level of nutritional and standard of living and to improve public health, and in particular it must endeavor to bring out prohibition consumption intoxicating drinks and drugs which are injurious to health. Unless this is for medicinal purposes, then in that case it will be fine. So nutritional and standard of living both are something the state should focus on. The state must organize agriculture and animal husbandry on modern and scientific lines and improve the breeds and prohibit slaughter of cows and calves and other milch and draught cattle. The state shall endeavor to protect and improve environment and to safeguard the forests and wildlife of the country. Protection of monuments and places and objects of national importance is obligatory upon the state. So again, this is not a fundamental right that the citizen is being guaranteed, but this is a directive that is issued to the state saying it is their responsibility to protect the monuments, places, and objects of national importance. The state must separate executive from judiciary in public services of the state. So judiciary is the deciding authority, executive is the administrative authority. In international matters, the state must endeavor to promote peace and security, maintain just and honorable relation and respect of international law between nations, treaty obligation, and encourage settlement of international disputes by arbitration. So, what is arbitration? Arbitration is a way of an amicable settlement wherein, without actually going to the court of law, you appoint an arbitrator, a party that is independent to, I mean, a person that is independent to both the parties that are involved as a part of the dispute, wherein an amicable settlement is reached out. Next, coming to the fundamental duties. So, all this while we were seeing what the constitution and the state guarantees to the citizen. Now, what is it that the citizens have to do as a part of being a part of the state? So, this is something that is defined in the fundamental duties. So, Article 51A imposes the fundamental duties on every citizen of India. These fundamental duties are to abide by the constitution and respects its ideals and institutions, national flag and national anthem, to cherish and follow the noble ideals which inspire our national struggle for freedom, to uphold and protect the sovereignty, and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, or sectional diversities, to renounce practices derogatory to the dignity of women, to value and preserve the heritage of our composite culture. So, as we all know, India is rich with its heritage and culture, and as a citizen of India, it is our duty to uphold and maintain it going forward and throughout. To protect and improve the natural environment, including forests, lake, rivers, and wildlife, and to have compassion for living creatures. To develop the scientific temper, humanism, and the spirit of inquiry and reform. To safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity. So it is so this with this what happens is the citizens can focus on their individual growth as well as the growth of the nation as whole, so that the nation constantly rises to higher levels of endeavor and achievement. Who is a parent or guardian to provide opportunities for education to his child as may be necessary for any ward between the age of 6 to 14 years. Since these duties are imposed upon citizens and not upon states, legislation is necessary for their implementation. So, fundamental duties cannot be enforced by writs. So, fundamental duties is something that is conferred upon the citizen, not upon the state. So, when we were talking about fundamental rights and directive principles, it was to the state, but fundamental duties is something that is conferred upon the citizens. So now coming to citizens, when we say citizens, let's understand the concept with starting with Aristotle's quote. So state is a compound made of citizens, and this compels us to consider who should probably be called a citizen and what a citizen really is. The nature of citizenship, like that of the state, is a question which is often disputed. There is no general agreement on a single definition. A man who is a citizen in democracy is often not the one in oligarchy. So, national citizen is crucial for politics, elections, welfare benefits, and overall integration. So, when we're also seeing about fundamental rights, we saw that certain rights are guaranteed only to citizen of the country. So, let's see what an Indian citizen is. So, Article 5 to 9 of Constitution determine who are Indian citizens at the commencement of the Constitution. Article 10 provides for their continuance as citizens. Article 11 empowers Parliament to regulate the right of citizenship. The acquisition and termination of citizenship along with related matters are left to the parliament. So if in case any person's citizenship has to be terminated, that is something that is up to the parliament. The Citizenship Act 1955 is the governing is the legislation that is governing these matters. So now we saw that Article 5 to 9 define a citizen. So Article 5 says that at the commencement of the Constitution, that is in the year 1950, every person who has his domicile in the territory of India and who was born in territory of India, either of whose parents was born in the territory, so either of the parents who has been ordinarily resident in the territory for not less than 5 years immediately preceding such commencement shall be a citizen of India. You have to be born, either of your parents have to be born, or prior to the commencement of the constitution, you should have lived in India for 5 years, then you will be considered as a citizen of India. So next, moving on. So now Till now, let's have a quick recap of what we have understood and gone through so far. So we understood the basis of constitution. What are the key ideas that our constitution promotes and upholds? Then we saw the three souls of the constitution. We saw preamble, fundamental rights, and directive principles of state policy, wherein preamble gave us the words like sovereign, socialist, secular, democratic, and republic. Then we saw various fundamental rights which covered rights like equality, right to freedom, right to constitutional remedies. Then we saw directive principles of state policy and how this is different from fundamental rights. That is how one is justiciable, other is not justiciable. And then lastly, we saw fundamental rights, which are responsibilities of citizens as a part of being a part of the country. And then finally, we understood the meaning of citizen. And as per Article 5, we understood that citizen is someone who was born in India. Either of the parents are born in India or has been a resident in India for 5 years prior to the commencement of the act. So next is moving on to the next part of the chapter, that is the structure of the parliament, the structure of the judiciary. So we will be looking into these one by one. So to begin with, first one, we have the parliament. So what is the structure of the parliament? It consists of president, council of states, and council or the house of the people. So council of state is nothing but Rajya Sabha, and house of the people is nothing but Lok Sabha. So why do we say house of the people as Lok Sabha? Because here the members are elected by the people directly. So now, president is elected by an electoral college comprising elected members of both houses of the parliament and legislative assembly of the state. So when we are talking about houses of the parliament, it is nothing but the Rajya Sabha and Lok Sabha. So these are the two houses of the parliament, and president is elected by members which comprise of both the houses of parliament and the legislative assembly of each of the states. Now, coming to powers of the president, so Article 53 of the Constitution states that the executive power of the union is vested with the president. So union is the central level of the government, and this is vested in the president. The president of the India is the head of the executive power. Executive power is defined as the power of carrying on business of the government. So who is responsible for the business of the government? It is the president, or the administration of affairs of the state, except for functions vested in authorities by the constitution. So what exactly does the executive power include? So it includes administrative power. So basically creation of these laws, execution and administration of the department. So first one is administrative power. Secondary, military. So president has the command over the armed forces and also for the conduct of the war. Third one is legislative power, where you can summon any person to the court of law, summon any authority to the court, prorogation, etc. of the legislature. And then we have judicial power, that is granting pardons, reprieves to convicted persons. That is basically deciding authority is also the president. So these powers are vested in the president, subject to the constitutional limitations. Now, power to promulgate ordinance. So what happens is any bill has to be passed in both the houses of the parliament, and only then the president will give assent and that will be passed as an act. But the president also has the power to promulgate ordinance. That is in case of a legislative action is not possible on an immediate basis, then the president can use this power. So, Article 123 provides that the president can issue ordinances when immediate legislative action is not possible. So, you cannot follow the formal procedure that is set by the law. So, in that case, the president can use this power. This ordinance making power is a unique feature of the Indian Constitution. Again, this is very important. The scope of the ordinance making power is the same as the Parliament's legislative powers. Ordinances may relate to subject Parliament can legislate on and are subject to the same constitutional limitations as the Parliament's legislation. So this is something that is vested solely with the President of India, and this is given in the Article 123 of the Constitution. Next, coming to both the houses of the parliament, so we have Rajya Sabha, that is Council of States, and Lok Sabha, that is the House of People. So let's understand what Rajya Sabha consists of. So Rajya Sabha consists of 12 members that is nominated by the president. So first one, we have 12 members who are nominated by the president. These are experts in literature, science, art, and social service, and up to 238 representatives from various state and union territories. So first we have 12 members who are nominated by the president, and then we have 238 representative of the state and union territory. So allocation of seat is determined by the fourth schedule of the constitution. Election of state representative, it is elected by elected members of the state legislative assembly. So when we were talking about Lok Sabha, House of People, it is directly elected by the people. But here in case of Rajya Sabha, it is elected by the elected members of the state legislative assembly. It follows the system of proportional representation using single transferable vote, and election of union territory representative is chosen in a manner as prescribed by the parliament. So what is important to remember here is the number of members. So 12 was nominated by the president and 238 comes from the state and union territory. Coming to Lok Sabha, which is the House of the People, here they are elected directly by the people. So this is something directed by the people, and that is why the name rightly suggests is as the House of the People. The maximum strength is 552. So when we spoke about Rajya Sabha, it was 12 plus 238, which is nothing but a 250 member in total as a part of Rajya Sabha. In a part of Lok Sabha, the maximum that you can appoint is 552, of which 530 are for states. So 530 represent states, 20 represent union territory, and 2 is for Anglo-Indian community. And this is something that can be nominated only by the president, also only if it is underrepresented. So in Rajya Sabha, we had 250 members, of which 12 were nominated by the president and 238 were representative of states and union territories. And when we come to Lok Sabha, 552 is the maximum, 530 representing states, 20 representing union territory, and 2 representing the Anglo-Indian community, who can be only appointed by the president if they are deemed to be underrepresented. Next, distribution of elective membership. Seats are allocated among states to maintain a proportional ratio between seat and state population as far as practicable. Next, coming to Council of the Ministers. So as we all know, the cabinet consists of various types of ministers. So say, for example, our railway minister, food ministry, health ministry, women and education ministry, women and children development ministry. So these are all the council of ministers, and this is headed by the prime minister of the country. So prime minister is appointed by the president again. The ministers which are appointed by the president on the prime minister's advice. Total number of ministers, including prime minister, shall not exceed 15% of members of the Lok Sabha. So again, we saw Lok Sabha 552 members. The max members allowed in the council of ministers is 15% of whatever strength your Lok Sabha actually is. Ministers hold office at the president's pleasure. Council of Ministers is collectively responsible to the Lok Sabha. Ministers take oath of office and secrecy administered by the president. Salaries and allowances of ministers determined by parliament and specified in the second schedule. The total number of ministers shall not exceed 15% of the total number of the House of the People or the Lok Sabha. Next, talking about constitution of legislatures in state. So state legislature, each state has a legislature consisting of governor and either one or two houses. So again, there are certain states which have two houses and most of the other states have just one house. So which are the state with two houses? So we have Andhra Pradesh, Bihar, Madhya Pradesh, Maharashtra, Karnataka, Tamil Nadu, Telangana, Uttar Pradesh. So if you see here, most of the South Indian states are covered here. So we have Andhra Pradesh, we have Karnataka, we have Tamil Nadu, we have Telangana, and then we have the other states as well, Bihar, Madhya Pradesh, and Uttar Pradesh, Maharashtra. So when we say two houses, we have Legislative Council, which is Council of the State, and Legislative Assembly, which is House of the People. And the other, all the states have just the Legislative Assembly, which is House of the People. So there is no Council of State in this case. Next, constitution of legislation in states. So when we talk about legislative assembly, so with the states with one house have only legislative assembly. The state with two houses has both assembly as well as council. So when we talk about legislative assembly, House of the People, It composes of around 600 to 500 members. Members are elected directly from the territorial constituencies, and the term is 5 years. This is for the legislative assembly. When it comes to legislative council for states with two houses, maximum members is one third of this. Minimum members has to be 40. It is not subject to dissolution, and one third of the members retire every 2 years. So this is what the legislative assembly and legislative council in a state looks like. Yes, coming to government, so governor. So governor is the equivalent of president, but at a state level. So governor has executive powers, wherein it holds the executive power of the state, similar to the president of the union. So for union, it is the president, and for state, it is the governor. Appointment. So he is appointed by the president, not elected, and can be governor for more than one state. The term will be at the pleasure of the president. Scope should be to possess executive, legislature, and judicial power. And when it comes to comparing it with the president, the diplomatic and military power is something that is not available with the governor, just like how it is available with the president. Ordinance making power. So again, the governor can promulgate ordinances with the state legislature is not in session. So this is similar to the power of the president. Purpose is to take immediate action. So whenever we are talking about promulgating ordinance, in that case, immediate action is mandatory. Only then you can exercise this right. The ordinances have the force of an act and the state legislature. It must be acted upon with the aid and counsel and the advice of the minister. So this is what the government of state does and what is the position of the government of state. Now, coming to limitations, it cannot promulgate ordinances without presidential instruction in the following cases. If a bill requires presidential sanction, if a bill should be reserved for presidential consideration, if an act with similar provision has been invalidated despite presidential assent. So wherever there is a requirement of approval from the president, in that case, promulgating ordinance is not possible by the governor. Duration. Ordinance must be laid before the state legislature and it ceases to have effect after 6 weeks. 6 weeks is the timeline that is given to any given ordinance. So before we move ahead, to quickly summarize, we had a look at the powers of the president, both the houses of the parliament, that is Rajya Sabha and the Lok Sabha. And then we also saw how governor of the state is similar in a way the president is to the union. Moving on to the next part. So as a part of the judiciary of India, the first component that we have is the Supreme Court. So Supreme Court is a common term that all of us are familiar with. We know that this is the highest authority of a court in India. That is, no judgment can be ruled against a Supreme Court. So let's understand the factors involved in creation of Supreme Court. So first one, the establishment, it is created by the Constitution of India, and the predecessors were the Privy Council when British India was there in existence, and until the Government of India Act 1935, it was the Federal Court. So first we have the Privy Council, then it was the Federal Court until 1935, and then we had the Supreme Court come into picture. So what is the jurisdiction of Supreme Court? So appeals in civil, criminal and other cases from high courts and certain tribunals. So like say for example, for dealing with matters of companies, we have the National Company Law Tribunal. Against that, you can appeal to the National Company Law Appellate Tribunal, and against the Appellate Tribunal, you can go to the Supreme Court. So not only High Court, but also certain tribunals wherein the appellate authority is the Supreme Court. With jurisdiction for enforcing the fundamental rights. Advisory rules, it advises whom? The president on questions of fact and law. And special jurisdiction, there are various other additional powers. So it not only deals with appeals, but also has advisory roles when it comes to advising the president. Next, coming to the next court, High Court. So High Court is one level below the Supreme Court, wherein it is for every state in India. So again, it is established under the Indian High Court Act 1861, and some existed before the Constitution and new ones were created post 1950. That is the Constitution coming into effect. So appellate jurisdiction over lower courts in civil and criminal cases, writ jurisdiction to enforce fundamental rights and other purposes. ordinary original civil jurisdiction. So it is held by Bombay, Calcutta, Delhi courts for the respective cities. Income tax references can hear references from income tax appellate tribunal and other tribunals. And pre-constitution jurisdiction. So writ jurisdiction was previously vested in high courts of Bombay, Calcutta, and Madras only. So this is prior to constitution. After that, it is with all the courts. So after Supreme Court and High Court, we have other subordinate courts. So these are the ones that are created under laws of the competent legislature, not directly by the constitution. Civil courts under the civil court of each state, and criminal courts under the CPC or the CRPC or the Code of Criminal Procedure. So again, in civil courts, we have district court and subordinate court. So district court is again presided by the district judge, as the name suggests. Additional district judges also may be appointed. Subordinate courts are courts of judges below the district court. So we have Supreme Court, High Court, District Court. Under that, we have subordinate courts. Then in criminal courts, these are magistrate courts and courts of session. So these two form a part of criminal courts. Now, executive magistrate. So, executive magistrate does not try criminal prosecution. They handle cases important for public tranquility and similar matters. They issue restrictive orders rather than convictions or acquittals, because as we know, they do not try criminal prosecutions. And in some states, local amendments may grant them power to try certain offenses. Next, coming to judicial magistrate. So, executive magistrate, then we have judicial magistrate. So again, there are two classes here. First class, which is the higher grade, and second class, which is the lower grade. And the control is subject to control the court of session. The court of session can try all offenses and award any legal sentence. Death sentence require confirmation by High Court. So it's not like court of session cannot give a death sentence, but you need the confirmation of High Court. Metropolitan magistrates are found in big cities, no internal gradation. And then city session courts exist in some large cities, again in Ahmedabad, Hyderabad, and function similar to how session courts function in districts. So these are the various types of court that form a part of judiciary. So we understood Supreme Court, High Court, then we had District Court, and then we have the magistrates who are there in picture, and then again the Court of Session. So now, moving to the next part of it, that is writ jurisdiction of the High Court and Supreme Court. So we will be learning about a few writs at a later point in this chapter, saying what are the powers that are available, whether you can enforce a particular court to follow their jurisdiction or to stay within their jurisdiction or not. So these powers are available both with the High Court and Supreme Court. Let's have a look at them. So High Court powers, they can issue directions, orders, or writs. The types of writs include habeas corpus, mandibus, prohibition, quo warranto, and certiorari, and it exercised throughout the territory under its jurisdiction. So, say for example, if it is Bangalore and there is Karnataka High Court, so it will be able to exercise the power only within Karnataka, matters originating out of Karnataka. It does not have jurisdiction to try out matters arising in, say, Kerala or Maharashtra. Supreme Court powers, they can issue directions, orders, writs for enforcing fundamental rights. Article 32 itself is a fundamental right, providing a constitutional remedy for fundamental right violation. So Article 32 is the one where we saw that it does not provide for any specific right, but it says that whatever other fundamental rights are there, it is the duty of the state to provide the citizen with that particular right. Yes. So now having a look at all the writs that we were talking about. So first one is habeas corpus. So habeas corpus basically aims at protecting personal liberty, and it is used when someone is confined without legal justification. So when we were talking about arresting of a person, like when we were talking about freedom of movement, but if you have arrested, firstly you need to produce them within 24 hours. Firstly, you need to tell them the reason and give them a chance to appoint a legal practitioner. And secondly, you have to produce them to the nearest magistrate within 24 hours of their arrest. And 24 hours does not include the journey time to the magistrate. So now, habeas corpus, what is the literal meaning? The literal meaning is to have the body, which means that court issues a rule necessary to the relevant authority to explain why the writ should not be issued. Authority must show grounds for detention. If unjustified, the person must be released. So now if any authority has detained any person, then court will issue a habeas corpus, which means that it will ask the authority who has arrested, what are the grounds of detention, and if the authority is not able to justify, then the person will be released. To have the body basically signifies a freedom of movement. It can be moved in Supreme Court or High Court. The applicant can be prisoner or someone acting on their behalf, because if the person is confined within the limits of the prison, then they will not be able to approach the courts for this. Rights. No one can be deprived of liberty except according to law, and it is possible to appeal to the Supreme Court as well. And it is punishable as a contempt of court under the Contempt of Courts Act. So habeas corpus basically means to have the body. So a writ will be issued on the court will issue a writ on the authority who has detained the person and ask them why this writ should not be issued. And if they're not able to justify the reason of them detaining the person, then the person will have to be released. So this is our first writ, that is the writ of habeas corpus. Coming to the next writ, it is mandamus. So the literal meaning is we command. So habeas corpus was to have the body, and mandamus, the literal meaning is we command. So purpose, it commands a person, corporation, inferior court to perform a specific public duty. So basically, if the courts are not performing their duty, if they are not exercising their jurisdiction, then writ of mandamus is something that will be issued to them. So it is issued when an inferior tribunal declines to exercise jurisdiction, and it commands activity and ensures judicial enforcement of public duties. It can be used only against a public authority, and the condition is used for enforcing directive principles. The application must have a legal right to performance of the duty, and it is not assured if the authority has discretionary power. So high courts and Supreme Court can issue mandamus. So basically, mandamus means that it was in your jurisdiction, but you have not exercised it. So we command you to exercise it. Yes. Coming to prohibition. So prohibition is exactly the opposite of mandamus. So mandamus is wherein you have not utilized your jurisdiction entirely, and prohibition is where you are exceeding your jurisdiction. You are going beyond your jurisdiction. So prohibition, it prevents an inferior court from usurping jurisdiction not legally vested in it. So if the jurisdiction is vested and the inferior court is taking it up, there is no issue. But if it is not vested and the court is still taking it up, then the writ of prohibition will have to be issued. Next, issued when a tribunal acts with or in excess of jurisdiction or violates rules, it is generally issued before the trial of the case. So it commands inactivity, unlike mandamus, which commands activity. Why does it command inactivity? Because you're stepping outside your jurisdiction. In mandamus, you are well within your jurisdiction, but not enough jurisdiction. It is available only against judicial or quasi-judicial authorities, not available against a public officer without judicial functions. And it can be a matter of right, not discretion, if the power of abuse is apparent. So far we saw habeas corpus, mandamus, and prohibition. Habeas corpus to have the body. Then we have mandamus, wherein we command, and thirdly we have the prohibition, wherein if anybody is exceeding their jurisdiction, then they can be prohibited. So next writ is the certiorari, which means that so this is available to any person, and again it is issued to any body with legal authority to determine questions affecting rights. It squashes a decision made beyond its jurisdiction. So when we were talking about prohibition, even before it happening, you are prohibiting it. But in case of certiorari, you have you quash a decision which is made beyond the jurisdiction. Next, issuance conditions. So when authority acts with or in excess of jurisdiction in contravention of rules of natural justice, commits an error apparent to the face of the record. So jurisdiction, high courts can issue writs of certiorari with their territorial jurisdiction. Supreme Court can issue writs under the Article 32 of the Constitution. So this is right for constitutional remedies. Timing, prohibition is issued at an earlier stage to prevent action. Certiorari is issued at a later stage after the authority is excessive. So prohibition is basically like a preventive measure, and certiorari basically becomes a corrective measure. So prohibition is even before the activity has been done. Certiorari is once the activity has been done. Last one, we have quo warranto. So quo warranto, the purpose is inquiry into legality of a person's claim to an office or franchisee outside individual from the position it had found to be usurper. So holder of the office must show authority under which they held the office. So if you are holding the office, you need to show what is the authority and who has provided you with this authority to hold the office. Next, so what are the conditions for issuance? The office is public and of a substantive nature. The office is created by the statute or the constitution. The respondent has asserted a claim to the office even if they haven't assumed charge. Next up, fundamental basis, public interest in ensuring a lawful complaint holds a lawful office. Discretionary remedy, the court may grant or refuse it. So we saw various types of writs. Habeas corpus to have the body, and then we saw mandamus wherein we command, and we saw prohibition wherein excess jurisdiction should not be used, and then we had certiorari, that is, once the jurisdiction has been used, you realize that it was not under their control, and then we had quo warranto, wherein you are claiming, inquiring into the person's legality of any given claim. So yes, we have reached the last part of the chapter, that is major constitutional amendments. Let's quickly go to our module and go through these. Yes. So there are certain major constitutional amendments right from the year 1951 to 2022. So we'll quickly go through this and understand what exactly are the amendments and why are they so major. So the first amendment, it added 9 schedule to protect land reform. So first amendment focused on land reform. It added 3 more grounds of restriction on freedom of speech and expression. That is, free public order, friendly relation with foreign states, and incitement to an offense. Also made the restrictions reasonable and thus justifiable in nature. Empowered the state to make special provision for advancement of socially and economic backward classes. Then we had the second amendment, wherein the scale of representation in Lok Sabha by providing that one member could represent even more than 7,50,000 persons. So it is like if one person attends and they are representing 7.5 lakh people, it means those 7.5 lakh people are a part of the Lok Sabha. Next, Constitution 42nd Amendment. So this is the mini constitution. So here, as we all know, we had discussed earlier, so socialist word was added by way of the 42nd Amendment. So this is important. 42nd Amendment is known as the mini constitution. So added 3 new words as a part of it: social, socialist, secular, and integral. Added fundamental duties by the citizens. Made the president bound by the advice of the cabinet. Added 3 new directive principles, that is equal justice and free legal aid, participation of worker in the management of industries. Shifted 5 subjects from state list to concurrent list, that is both the authorities will have control over it. That is education, forest, protection of wildlife, animals and birds, weights and measures, and administration of justice. Empowered the center to deploy its armed forces in any state to deal with the grave situation of law. Next, coming to, so far we saw the 42nd Amendment. Now we are looking at the 52nd Amendment. So again, this amendment is known as anti-defection law, and it provided for disqualification of member of parliament and legislature on the ground of defection at the 10th schedule. Next, 61st Amendment reduced the voting age from 21 to 18. So earlier it was 21 years where you could vote, but now it has been reduced to 18. 69th Amendment accorded a special status to the Union Territory of Delhi by designing it as the National Capital Territory. Then under the 70th Amendment provided for inclusion of members of Legislative Assembly of National Capital Territory and the Union Territory of Pondicherry in the Electoral College. 84th Amendment, the number of seats and in the Lok Sabha and assemblies are to remain the same till 2026. Constitution 86th Amendment, it is made elementary education a fundamental right. Added Article 28, which declares that the state shall provide free and compulsory education to all the children of the age of 6 years to 14 years. Change the subject matter of Article 45 in Directive Principle. It now reads that the state shall endeavor to provide early childhood care and education for all children until they obtain the age of 6 years. And then there is a fundamental duty under 51A, which says that it shall be the duty of every citizen of India who is a parent or guardian to provide opportunities for education to his or her child, especially for wards between 6 to 14 years of age. Next, coming to the Constitution 91st Amendment. So total number of ministers, including Prime Minister in the central, shall not exceed 15%. So we saw this example. The total number of ministers, including chief minister, council of ministers, shall not exceed 15% of legislative assembly of that state. So when we are talking at a union level, it is the Lok Sabha. When we are talking about at a state level, it is the union legislative assembly itself. The provision of the 10th schedule pertaining to exemption from disqualification in case of split by one-third member has been deleted. It means that the defectors have no longer protection on grounds of splits. Last three amendments before we close the chapter. So 101st Amendment, GST has been included, and there were three new articles that were added to the Constitution. Then 102nd Amendment, constitutional status to National Commission for Backward Classes, inserted Article 342A, which empowers President to notify the list of socially and economically backward classes of that particular state or country. Next, Constitution 103rd, or the latest amendment, it changed two fundamental rights, 15 and 16. It provides that for the advancement of economically weaker sections, 10% of all government jobs and seats will be reserved for people outside the high income bracket. So these are certain notable amendments that has come into the Constitution, which we just had a look at the module. So with this, we've come to the end of the chapter. So to quickly revise, we saw the purpose of the Constitution. What does it mean? Where does it derive its ideas from? Then we saw what is the preamble of the Constitution, what are the various fundamental rights that a citizen can avail, directive principles of state policy. Then we had a look at the fundamental duties of a citizen of the country. Then we understood president, Lok Sabha, Rajya Sabha, and the whole parliament structure, even the governor of the state. And then finally we had a look at the major amendments that have come in since the inception of the Constitution till date. So with this, we come to the end of chapter 1. Thank you so much for being a part of this class with me. I hope it is all clear. If you have any doubts, please feel free to ping in the comment section below and we will get back to you as soon as possible. Thank you so much.
Yes, after a lesson, I'm back. I'm here to remind you that if you want free mock test, if you want practice test to ensure that you get 100 out of 100 in CSEET, just go to Ekcel Academy website. It is there for all the subjects, not only for this subject, it is there for all the subjects. So go there and get the best benefit. And if you still have some doubts, we have free counseling also. Just call 973-973-3400 and we can help you with any subject. And all of this is free for you.
Hi all, welcome back to another class of CSEET Legal Aptitude and Logical Reasoning. In today's class, we will be understanding chapter 2, that is elements of general laws. So this chapter is divided into two parts, wherein the first part we will be understanding Indian Contract Act and the various provisions under the act. And as a second part of the chapter, we will be understanding what is torts and what are the various provisions when it comes to the law of torts in India. So without further ado, let's begin. So when we talk about Indian Contract Act, so what is it that the Indian Contract Act covers? So Indian Contract Act mainly covers all the provisions relating to a contract. So what is a contract? So to understand a contract is an enforceable agreement between two or more parties involving rights and obligations. So if you see here, the highlight of contracts is that it has to be enforceable. It has to be between two or more parties and involving rights and obligations. Indian Contract Act lays down the rules for contract formation, enforceability, and breach. So that is, how can a contract be formed? And once it is formed, how can you enforce it if it is not performed? And if there is any breach of contract, what is the remedies that are available to the parties? So contract includes indemnity, guarantee, bailment, pledge, and agency. So we'll also be understanding all of these terms as a part of this chapter. Contracts are crucial in commerce, affecting trade, industry, and everyday transactions because, say, for example, if two businessmen get into an agreement with each other, but if it is not enforceable, then there will not be any responsibility on both the sides, because even if one of the person doesn't fulfill the terms and conditions of the contract, the other will not be able to take action against them because it is just an agreement and it is not a contract. So when we talk about contract, contract is a agreement that is enforceable in the court of law. So this is the basic understanding we need to have of contract, that is, contract is an agreement enforceable in the court of law. Yes. So it came into force on September 1st, 1872. So the Indian Contract Act, so if we have to state the year, it is 1872. And mainly to define and amend aspects of contract law. It does not encompass all contract related laws because there are separate laws. Like if there is a partnership, there's a Partnership Act, Sale of Goods Act. For insurance, there is a separate act. So it does not encompass all the laws, but it works in collaboration with it. So now there are two parts to the Indian Contract Act. So if we see the first part, that is section 1 to section 75, it is general principles which are applicable universally. And second part, 124 to 238, special contracts like indemnity, guarantee, bailment, pledge, and agency, the ones that we were looking at here. So let's understand the word contract. So Indian Contract Act has defined contract in section 2H. So this is important. Section 2H defines contract as an agreement enforceable by the court of law. So it has to be agreement and it has to be enforceable. So if you have to write it in a formula manner, so contract is agreement plus enforceability. So this is what a contract is, and this is defined in section 2 subsection H of Indian Contract Act 1872. So firstly, there has to be an agreement. Secondly, such an agreement must be enforceable by law. To be enforceable, an agreement must be coupled with an obligation. So like I was saying earlier, if two businessmen have entered into an agreement, there is no responsibility cast on either one of them. But in case of enforceability, it has to be with an obligation. So your agreement has to come with an obligation. So a contract, therefore, is a combination of two elements, that is agreement as well as a obligation. So now, if we are saying contract is a agreement enforceable in the court of law, then we also need to understand what exactly is an agreement. So to understand agreement, every promise and set of promises forming consideration for each other constitutes an agreement. So basically, agreement is a promise made by one person to another and which also includes a consideration. So if we say agreement, it is a promise or a set of promise forming consideration for each other and it constitutes an agreement. So again, this is section 2E. So agreement is defined in section 2E of Indian Contract Act. And contract is defined in section 2 subsection H of the Indian Contract Act. An agreement is based on a promise. So the first step is a promise, then is an agreement, and the third one is a contract. When the person to whom a proposal is made signifies assent, the proposal becomes a promise. So now we are breaking down contract further into the tiniest of the bits. So we had contract, then contract consisted of an agreement. Agreement consisted of a promise, and promise arised out of a proposal. So if one person is making a proposal to another and the other person accepts it or gives their assent, then that proposal will become a promise. An agreement forms when one party makes a proposal or offer and the other party accepts it. An agreement consists of an offer made by one party and its acceptance by another. So again, in simple words, you can say agreement is offer plus acceptance. Offer is nothing but proposal. So if you see, we have proposal. So once the proposal is assented to by the other party, it becomes a promise. And once there is a consideration also added to this promise, it becomes a agreement. And if enforceability is added, this becomes a contract. So this is important because this will form a base of all the topics of discussion in this chapter. So we need to understand what is the difference between contract and agreement, agreement and promise, promise and proposal or offer. Yes. So agreement, so there are two parts. Plurality of persons. So like we were saying, there must be two or more persons. So I cannot make an agreement with myself. So there has to be at least two or more people. So there must be two or more persons to make an argument because one person cannot enter into an agreement with himself. Consensus addendum. So this is a very important topic, a very important term that we need to understand. Consensus addendum, it means the meeting of the mind. So that is both of them have to understand the agreement in the same sense and the same time. So the meeting of the minds is called consensus addendum. So if we are saying consensus addendum, it is meeting of the minds. It means both the parties to an agreement must agree about the subject matter of the agreement in the same sense and at the same time. So now, say for example, A offers B to sell his car for rupees 5 lakh, and B has understood that A is offering the car at rupees 2.5 lakhs. And if at 2.5 lakhs B has agreed, then there is no concess addendum, because they have not understood the agreement in the same sense and at the same time, because A has offered it for 5 lakhs and B has understood it as 2.5 lakhs, and based on the 2.5 lakhs, B has accepted the proposal and made it a promise. So here it is very important that there has to be two or more people. Firstly, you cannot enter into an agreement with yourself. Second one, there has to be concess addendum, that is meeting of the minds. Coming to obligation. So an obligation is the legal duty to do or abstain from doing what one has promised. So when we saw earlier that contract was nothing but agreement plus obligation or agreement plus enforceability. So we are looking at the next part of contract, that is the obligation. So we saw the first part of contract, that is agreement, and now we are looking at the second part of it, that is obligation. So an obligation is the legal duty to do or abstain from doing what one has promised. So why are we saying to do or abstain from doing? Why are we using the word abstain? So say for example, let's take the example of the car itself. So now if I am saying that I will sell the car to you at 5 lakh rupees, the other person has accepted it, then it is my responsibility to sell the car. But if I am saying I will not sell the car until it completes 1000 kilometers, then in that case, I have to abstain from selling the car until it completes 1000 kilometers. In that way, obligation is not necessarily something that has to be done. It can be something that is abstained to be done from. A contractual obligation arises from a bargain between the parties to the agreement, known as the promisor and the promisee. So there are two parties here, that is promisor as well as the promisee. Section 2B of the Indian Contract Act states that when a person to whom a proposal is made signifies assent, the proposal becomes accepted and thus a promise. So now, as per section 2B, so proposal plus assent becomes a promise. So proposal is the person who is offering, making the offer, and assent will be given by the opposite party. In a broad sense, a contract involves an exchange of promises between two or more persons. This exchange results in an obligation to perform or abstain from a specific act recognized and enforceable by law. So now if I am saying, why is it saying recognized and enforceable by law? This is very important. So if I am saying that A offers B rupees 10 lakhs for the murder of C, then that is something. Murder of C is something that is not enforceable by law, that is not legal, which is not allowed, and hence the obligation will not be created, neither will an agreement or a contract be created, because the act has to be recognized and enforceable by the court of law. Yes. So where parties have made a binding contract, they have created rights and obligations between themselves. So now if if A is saying to B that I will give you the car for rupees 5 lakhs, then it is the obligation of A to provide the car to B, and it is the right of A to receive the money from B. Similarly, it is the right of B to receive the car from A, and it is the obligation or duty of B to pay the amount to A. So the contractual rights and obligations are correlative. Now, let's take an example. A agrees with B to sell his car for rupees 10 lakh to him. In this example, the following rights and obligations have been created. A is under an obligation to deliver the car. B has the right to receive the car. B is under an obligation to pay 10 lakh, and A has a correlative right to receive the 10 lakh. So this is the example that we just discussed. Now, there are certain agreements which cannot be any contract. So what are they? So there are two bifurcations here. So we have social matters and domestic arguments. So if we are talking about social matters, agreement between two persons to go to a cinema or for a walk, there is no legal obligation on their part to abide by it. So if a group of friends decide to go out for dinner, and if one of them does not show up, then in that case, there is no agreement here, because this is based on a social matter. Like if you want to go out, if you're going for cinema or for a walk, there will be absolutely no legal obligation on their part to abide by it. Second one is domestic arrangements between husband and wife. So there is a case law of Balfour versus Balfour. In that case, the husband who was working in Ceylon had agreed in writing to pay a housekeeping allowance to his wife living in England. So the husband and wife were living in two different places. So husband had agreed to pay a housekeeping allowance. On receiving information that she was unfaithful to him, he stopped the allowance. He was held to be entitled to do so. Sorry. Yeah. So this was a mere domestic arrangement with no intention to create legally binding relation. Therefore, there was no contract. So now, here the husband has found out that the wife is unfaithful to him, and that's why he stopped the allowance. He was under no legal obligation to give this because this was just a arrangement between the husband and the wife. So this is something that cannot be a contract because there is no intention to create legally binding relations. Okay, so now when we are saying, like we discussed that an agreement must be between two or more people, there has to be consensus. So now if we are saying agreement is a contract is an agreement which is enforceable in the court of law, we need to understand what are the essential elements of a valid contract. What is it that needs to be there for any given contract to be valid? So this firstly is provided for in section 10 of the Indian Contract Act. It says that all agreements are contracts if, so here it starts, if they are made by the free consent. First one is free consent. That is, the parties should be willing by themselves to enter into the contract, of parties competent to contract. That is, they should be in a position to understand the terms and conditions of the contract for a lawful consideration. So third one. So first one we had free consent, lawful consideration, competency to contract, and a lawful object as well. So consideration and object both has to be lawful and hereby not expressly declared to be void. So there are certain contracts which are void ab initio, that is void from the beginning. So except those, all the other can be contracts. So again, therefore, to form a valid contract, there must be an agreement because it's an agreement enforceable in the court of law, genuine consent or free consent, supported by lawful consideration, lawful objects, and between competent parties. So this is something that is very important for us to remember because basis this only we will be able to understand if any given contract is valid or not, and any given agreement if enforceable in the court of law, whether it's a contract or not. Now, to understand it further, so first one is consensus. We saw this, that there has to be a meeting of the minds. So an offer or proposal by one party and acceptance of that offer by another party resulting in an agreement, an intention to create legal relations or an intention to have legal consequences. When we were talking about the arrangement between husband and wife, that the husband will pay housekeeping allowance to the wife, there was no intention to create any legal relation, and hence that cannot be subjected to a contract. The agreement is supported by a lawful consideration. The parties to the contract are legally capable of contracting. So we will also be understanding who is not capable of contracting. Genuine consent or free consent between the parties. The object and consideration of the contract is legal and is not opposed to public policy. So like I was saying, if I am paying B for the murder of C, then in this case, this cannot be a contract. It cannot be a valid contract because the object itself is not legal and it is opposed to the public policy. The terms of the contract are certain. So even if we see there will be a lot of terms and conditions on a usage of any particular tool, any particular website, any particular product. So here the terms are predefined, which will help the consumer in understanding what is it that the company will be responsible for. The agreement is capable of being performed, that it is not impossible of being performed. So if I am saying that A will pay B rupees 10 lakhs if B goes to the moon. So this is something that B goes to the moon and say for example, anything that is not possible, then in that case, it cannot be a valid contract because what you are asking to perform is something that actually cannot be performed. Yes. Now understanding from the basics of what is offer, a proposal, and acceptance. Before that, let's understand what is a valid contract. First of all, two or more people. There has to be genuine or free consent by both. The object and consideration both have to be lawful, and two or more people have to be involved for it to be valid, and there has to be an intention to create legal relations as well. Next, offer a proposal and acceptance. So when we saw that when a proposal was accepted or an offer was accepted, it became a promise. Then we added consideration to that, it became an agreement, and we added enforceability or obligation to that, it became a contract. So let's understand offer and acceptance. So one of the early steps in the formation of a contract is arriving at an agreement between the contracting parties through offer and acceptance. Now, when the offerer makes a definite proposal to the offeree and the offeree accepts it entirely and without qualification, there is a meeting of the mind. Meeting of the mind is what is conses edidem. Conses edidem. So this is very important to remember, that there has to be a meeting of the minds, and a contract comes into being assuming all the other elements are present. A proposal is also termed as an offer. So proposal is nothing but offer. Next, an offer is a proposal by one person expressing willingness to enter into a contractual return or contractual obligation in return for a promise, act, or forbearance. Now, coming to Section 2A of the Indian Contract Act, this defines a proposal or an offer as when one person signifies to another his willingness to do or abstain to do. Again, we have both options. That is, you can either do or abstain to do from doing anything with a view to obtaining the assent of that to act as obstance, he is set to make a proposal. So firstly, if I am making a proposal, then I have to express my willingness to do something or to abstain from doing something, and only then that will qualify as a proposal. Next, the person making the proposal or offer is known as proposer or offerer. So this is evident from the name itself, that the person who will be offering is the proposer or the offerer, and the person to whom it is made is known as the offeree. So we have proposer or offerer, and then we have offeree. Now, even when it comes to offer, there are certain rules that govern offers. So let's understand that. A valid offer must be clear, definite, complete, and final. It must not be vague. So now, if I am saying that I will sell you my car at the end of August in a good condition at a good price, there is no clarity here because it is very vague. So if I am saying I will sell it to you at a good price, so we are not sure what the good price is and what will the price be. So this is something that is vague, and hence offer will not be valid. So an example is A promises to pay an increased price for a horse if it proves lucky to the promiser. So again, first of all, you are saying increased price. You are not saying what is the exact amount of increased price. And the second one is you are saying to the horse, if it proves lucky to the promiser. So this is too vague and it is not binding on anyone. The communication of an offer may be made expressed by words, oral or written, or even implied by conduct. Implied by conduct is, it is very obvious that this is their responsibility. The communication of the offer may be general or specific. A specific offer is made to a specific person and can be accepted only by that person. A general offer is addressed to an uncertain body of individuals, the world at large, and can be accepted by any member of the general public by fulfilling the conditions laid down in the offer. So again, what we understood, that how rules are supposed to be. First one, it does not have to be vague. It has to be clear and definite. And second one is that this could be either in the form of oral or written. Both are possible. So we've understood what an offer is, but when will an offer lapse? So Section 6 of the Indian Contract Act deals with various modes of lapse of an offer. It states that an offer lapses if it is not accepted within the specified time, if any, or after a reasonable time, if none is specified. So say, for example, if A has said that I will sell you this car at rupees 10 lakh, and you need to give me your accept. If you want to accept, you have to accept it within 1 month. So if the offeree accepts it after a period of 1 month, then the offer would have lapsed. Secondly, if there is no time specified, then it has to be a reasonable time. So say, for example, if a milkman is saying that I will sell you this milk at rupees 50 per liter. But if you are accepting the offer after 1 week, then it is not a reasonable time because the milk would have perished by then. So if there is a specified time, then the offeree needs to accept the offer by then. Or if there is no specified time, then it has to be a reasonable time within which the offer has to be accepted. It is not accepted in the mode prescribed, or if no mode prescribed, in some usual and reasonable manner. So now, say for example, if the offeree says that please convey your acceptance by mail, then you have to accept by mail, and only then the offer would have said to be accepted. So example, by sending a letter by mail when early reply was requested. The offeree rejects it by distinct refusal to accept it. So now offer is very clear that I am not going to accept this offer. So then it will be a lapse of the offer. Either the offerer or the offeree dies before the acceptance. So as we all knew, there will be two parties. And if one of the party dies, then the offer is going to be lapsed. The acceptor fails to fulfill a condition precedent to an acceptance. So if there was certain condition that the offerer had set while offering, and if the acceptor fails to do that, then the offer will also lapse. The offeree makes a counter offer. It amounts to rejection of the offer, and an offer by the offeree may be accepted or rejected by the offerer. So again, instead of accepting the offer, if you are making an offer against it, then that will become a counter offer, wherein the first offer will be lapsed and the second offer will come into picture. So these are circumstances and cases wherein an offer will lapse. Now, revocation of offer by the offerer. So now first one we saw wherein the offeree is rejecting the offer, but here it is by the offerer itself. So now an offer may be revoked by the offerer at any time before the acceptance. Why is acceptance important here? Because if you have accepted the offer, then it becomes a promise. And if you are revoking it, it has to be before acceptance by the offeree. So revocation must be communicated to the offeree, as it does not take effect until it is actually communicated. So now, say for example, the offerer has offered to sell the car to the offeree, and the offerer decides that he does not want to sell the car, he wants to continue using it. But if the offeree is not aware about it, then the offer is not said to be revoked, because there has been no communication to the offeree. Before its actual communication, the offeree may accept the offer and create a binding contract. The revocation must reach the offeree before he sends out the acceptance. So if he has already sent out the acceptance, like if he has sent out his acceptance by say courier, and in that case after that you are revoking the offer, then your revocation will not be valid. An offer to keep open for a specified time is not binding unless it is supported by a consideration. So if you are keeping an offer for a certain period of time, then there has to be a consideration along with it. Now we understood the first part, which is an offer. Let's understand the second part, which is the responsibility of the offeree, which is acceptance. So when we talk about acceptance, a contract emerges from the acceptance of an offer. Acceptance is the act of assenting by whom? By an offeree to what? To the offer. Under Section 2B of the Contract Act, when a person to whom the proposal is made signifies his assent thereto, the proposal is said to have accepted. A proposal, when accepted, becomes a promise. So again, this is very important. So a proposal, what is proposal? Proposal is nothing but an offer. When accepted, becomes a promise. Now, rules governing acceptance. Acceptance may be expressed, that is by words spoken or written or implied from the conduct of the parties. If a particular method of acceptance is prescribed, the offer must be accepted in the prescribed manner. Acceptance must be unqualified and absolute and must correspond with all terms of the offer. So here in this case, wherein we saw in lapse of offer, that if you are making a counter offer, the offer is going to lapse. So this is similar to that your acceptance must be unqualified and absolute. Now, a counter offer or a conditional acceptance operates as a rejection of the offer and causes it to lapse. Example, where a horse is offered for ₹1,000 and the offeree counter offers at 990, the offer lapses by rejection. So it is not like they will no longer sell the horse, but it just means that the original offer of ₹1,000 will no longer be applicable. Next, coming to the further rules, acceptance must be communicated to the offerer. For acceptance is completed when the moment it is communicated. So when we were talking about revocation of offer, we understood that it has to be revoked before the offeree sends out his acceptance. So even in case of acceptance, it is very important that it must be communicated to the offerer. For acceptance is complete the moment it is communicated. Where the offeree merely intended to accept but does not communicate his intention to the offerer, there is no contract, because the offerer will never be aware that the offeree is actually communicated his acceptance. Mere mental acceptance is not enough. So if I am the offeree, if A has offered me to sell his car and I want to buy it. So I have decided that I'm going to buy this car for rupees 10 lakhs. But if I'm not going to tell A, then it will not be a valid acceptance because I have not communicated it to A. Mere silence on the part of offeree does not amount to acceptance. Ordinarily, the offerer cannot frame his offer in such a way as to make silence or inaction of offeree as acceptance. In other words, the offeree can prescribe the mode of acceptance, but not the mode of rejection. So your rejection cannot be silence. So just because you are silent, the offeree is silent, it does not amount to acceptance. So silence does not amount to acceptance of an offer. If the offer is one of which is to be accepted by being acted upon, no communication of acceptance to the offerer is necessary unless communication is stipulated for in the offer itself. So say for example, if a reward is offered for finding a lost dog, the offer is accepted by finding the dog. So in this case, the condition of acceptance that it has to be communicated is not required because you are giving them the lost dog. After reading over the offer, it is unnecessary before beginning to search for the dog to give a notice of acceptance to the offerer. So now say, for example, this is something that the offerer would have given at large. So say the offerer at large is saying that if anybody brings me my lost dog to me, I will pay them rupees 10,000. So now before I start searching, so if I am the offeree and I start searching, since this was a general offer that was given to the public at large. So if I decide to look for his dog and give it to him, if I find it, I don't have to communicate that acceptance first, because if I am finding and I found the dog and I give it to the offerer, then in that case, I have said to have accepted the offer, and communication here is absolutely not required. Communication of acceptance is not required. Again, acceptance must be given within a reasonable time and before the offer lapses or is revoked. So lapses are the conditions that we saw earlier, Section 6 of the Indian Contract Act, and is revoked is when the offerer himself revokes the offer. An offer becomes irrevocable by acceptance. That is, an acceptance never precedes an offer. So first there has to be an offer, only then there will be an acceptance. There can be no acceptance of an offer which is not communicated. So now say for example, while two people are conversing, so A and B are conversing. Now A is saying that listen B, I think I am going to sell my car, I am planning to sell my car. Now if B is accepting the offer saying okay, I will buy your car, it is not going to be valid because A did not say that I want to sell my car at so and so amount. A just said that I am planning to sell my car. So there can be no acceptance. So B, even though he is willing to buy the car, he cannot buy it because A has not specifically communicated the offer. Similarly, performance of conditions of an offer without the knowledge of the specific offer is a no acceptance. So let's say in case of the dog owner. So now a dog owner published an advertisement saying and made an offer saying, if you find my dog, I'll give you 10,000 rupees. And the public in large is aware about this. But A's friend itself was not aware about this offer, and he knew that this dog belongs to A. So that time, if the friend gets the dog to A, this cannot be acceptance of the offer because the friend was not aware at all that there is a reward that A has set for finding his lost dog. So any person who is in the position to accept an offer must have received the communication of the offer first. Only then the acceptance will be valid. So next, we will understand about specifics, that is the contracts over telephone. So contracts over the telephone are treated similarly to those negotiated in person. An oral offer is made and oral acceptance is expected because it's over telephone. So it's very obvious. Acceptance must be audible, heard, and understood by the offerer. So why is it that specifically there is a provision for telephone? Because there are chances of the person not understanding entirely what the other person is saying, or maybe there would be some network connectivity issues because of which the offerer and the offeree have not understood it. So firstly, it must be audible, it must be heard, and it must be understood by the offerer if you are accepting. If the telephone line goes dead during the conversation and the offerer does not hear the acceptance, no contract is formed because it is not communicated to him at all. If the conversation is repeated and the offerer hears and understands the acceptance, the contract is complete. So after the line goes dead, if then the contract, the offeree gives his acceptance again, then the offer is said to have been accepted. So yes, the next element of a valid contract is the intention to create legal relation. So what exactly does it mean? It says that it requires the party to intend that their agreement will have legal consequences and create legal obligation. That is, if the performance of the contract is not done, then there will be a enforceability in the court of law that will be there. So the parties must be willing to let this particular agreement create legal consequences and also obligations that follow because of these consequences. Coming to social and domestic agreements, so this is the one that we saw, that wherein two friends are planning to go for a movie or dinner, and a domestic arrangement between your husband and wife. So these generally do not involve legal relationships and therefore are not considered contracts. So this is very important. Coming to offer and acceptance, both must be made with the intention of creating legal relations. So now say I am the offeree, I am offering something to B with an intention to create a legal relation, but B is not accepting with an intention to create a legal relation. Then in that case, the this part of the contract, this essential of the contract will not be satisfied. So the intention is assessed objectively by the court, which considers the conduct of the parties rather than subjective intentions, and conduct over mental intentions. So courts look at what a reasonable person would infer from the circumstances, not the internal thoughts of the party. So now conduct over mental intention. What is it that would usually be expected of a situation like this is something that the court will have a look at and not what the person is thinking. Next, commercial agreements generally presume to create legal relation, but this presumption can be rebutted by showing the parties did not intend to be legally bound. So generally commercial discussions, commercial agreements are subject to enforceability by the court of law. But there can be a presumption that the parties did not intend to create a legal relation. So in this case, it has to be specifically mentioned. Yes. The next valid element is essential of the contract is consideration. So we saw that it has to be for a lawful consideration. So let's understand what a consideration is. So now if we talk about consideration in contract, so it is essential for a valid contract, reflecting the law's policy to enforce mutual promises. So what is the enforceability? A mere promise isn't enforceable. Consideration must be provided for the promise to become legally binding. So when we saw proposal becomes a promise when there is acceptance, promise becomes an agreement when there's a consideration, and agreement becomes a contract when there is enforceability. Now, example, if A promises to gift rupees 500 to B without anything in return, B cannot legally enforce the promise because there is nothing that B will be doing. There is no consideration that B is providing A with. Now, there is a definition by Sir Frederick Pollock which says that consideration is an act or forbearance by one party in exchange for the promise for another. There's another case law which talks about this, that is Theory versus Missa. That is, consideration involves some right, interest, profit, or benefit to one party, or forbearance, detriment, loss, or responsibility by the other. So why is it saying detriment or loss? Because one person will be paying that amount, so it will be a loss for them. Section 2D of the Indian Contract Act 1872 defines consideration as an act, absistence, or promise done at the promiser's desire by the promisee or another person. So there has to be something in return that the promiser will be getting, and only then it will be a valid consideration. What is the fundamental principle behind this? That is, consideration is essential in every contract with specific differences in nature and extent under different systems. So now consideration must be at the desire of the promiser. So if I am offering you something, then I will tell you what am I offering it at. it at. So now say for example, if I'm saying I'm going to sell my car, then I will be deciding the amount for which I'm going to sell it. Must move at the promiser's request. Voluntary acts or acts done at the request of the third party do not constitute valid consideration. That is, if A helps B, whose house is on fire, without B's request, it's a voluntary act. If A helps at B's request, it's valid consideration. So if while there is fire, if A says that please come and help me, I will pay you this much money, then it's a consideration. But without A requesting for help, if B helps voluntarily, then there is no consideration here. Next, consideration from promisee or any other person. So what we saw it has to come from the promiser. But what happens? It comes from the promisee or any other person. The English law requires consideration to move from the promisee. Indian laws allow consideration to move from the promisee or any other person, permitting a stranger to the consideration to sue on the contract. So let's have a look at the case law here. Chinnaya versus Ramaya. A lady gifted a property to her daughter with a directive to pay an annuity to her brother. The daughter agreed in writing but later refused to pay, claiming no consideration moved from the uncle. The court held that uncle could sue as the consideration from the mother was sufficient. So, although there is no direct contract between the daughter and the uncle can sue because uncle is also entitled to the amount. One more example, a contract where A sends goods to B at free of cost without any obligation on B's part is not valid as it lacks consideration. So A is sending the goods, but what is it that B is doing? B is doing nothing, and hence there is no consideration. Next, stranger to a contract. He cannot sue under both English and Indian law due to lack of privity of contract. So there is one case law that is available here. Dunlop Pneumatic Tire Co. versus Selfridge Limited. So D supplied tires to the wholesaler X with the condition that the retailer should not sell below D's list price. So they supply the tire saying that if you are selling it further, you cannot sell it below my list price. Now X resupplied tires to the S with the same condition, but S sold below the list price. D had a contract with X, X had a contract with S. D could not sue S as there was no direct contract between D and S, and D had not provided the promise. So now there was a contract between D and X, and then X and S. There was no contract between D and S in their individual capacity. So that's why D cannot sue S, although X had sued the same condition that X had imposed the same condition that D had imposed on X. Next, coming to beneficiary contracts, a person not party to a contract cannot sue even if the contract benefits them. That is, A indebted to B sells the property to C. C promises to pay A's debt to B. If C fails to pay, B cannot sue as there is no privity of contract. So this is a similar situation that we are looking at here, that there is no contract between both the parties and hence they will not have the right to sue. Now, what are different kinds of consideration? So consideration may be executory or future, promise to be performed in the future, example, an engagement to marry someone. Executed or present. So for first, what we saw is future. Then we are saying that it can be present as well. That is an act of forbearance made or suffered for a promise. That is, example, A pays ₹100 to a shopkeeper for goods to be supplied on the next day. A has executed his consideration while the shopkeeper's consideration is executory. So now A has already paid the amount. So A's this thing becomes present and the shopkeeper is yet to supply the goods. That becomes an executory or future. Next, if both price and goods are exchanged simultaneously, consideration is executed by both the parties. And past, a past or forbearance that is complete before the promise itself is made. Example, an act constituting consideration that occurred and was completed before the promise was made. So these type, we have three types of consideration. We have future or executory, executed or present, and the last one is past. Now coming to the rules that are governing consideration. So as we all know, every simple contract must be supported by valuable consideration. Otherwise, it is formally void. Void means invalid with certain exceptions. So consideration may be an act, subsistence, or a promise. So it doesn't always have to be money consideration, but it is some act or subsistence or promise. So basically, it could even be abstaining from doing something. There must be mutuality, meaning each party must do or agree to do something, a gratuitous promise. Example, a charity subscription is not enforceable because this is something that is voluntary, and to whom you are donating to will not have anything in return that will be given by them. So consideration must be real and not vague, indefinite, or illusory. Example, a son's promise to stop being a nuisance is vague and is not a valid consideration because this is something that cannot be defined. This is very vague and hence this cannot be a valid consideration. Consideration must have some value, but it need not to be adequate. So inadequate considerations also fine. That is a full return for the promise. As per section 25, an agreement is not void merely because the consideration is inadequate if the promisor's consent is freely given. So now, if the promisor is promising something, then the promisee will be giving the consideration. And the consideration, if it is being given by the promisee, is inadequate. It is fine as long as the promisor's consent is freely given. Then consideration must be lawful and not involve illegal acts. So example, we were also discussing that how if A is offering B amount to commit a murder, then that would not be a valid consideration. If the consideration is unlawful, the agreement is void, which means it is invalid. Consideration must be something more than what the promisee is already bound to do for the promiser. An agreement to perform an existing obligation owed to the promiser is not made for consideration. So if in the part of the agreement, if the promisee is already bound to do that, then that cannot be the consideration. It has to be something in addition to that. So now, what are the cases where consideration is not necessary? So we saw in the beginning that in all agreements, consideration is important with certain exceptions. So let's have a look at this. The general rule is that the agreement made without consideration is void. But Section 25 of the Indian Contract Act lays down certain exceptions which make a promise without consideration valid and binding. Thus, an agreement without consideration is valid. So what are the scenarios in which agreement will be valid even if there is no consideration? If it is expressed in writing and registered and is made out of natural love and affection between parties standing in a near relation to each other. So in this case, there could be an agreement without a consideration as well. So first one we have is the natural love and affection. If it is made to compensate a person who has already done something voluntarily for the promiser or done something which the promiser was legally compatible to do. So now, if say the promisee has already performed something for the promiser, already done something for the promiser, and the promiser is doing this particular act to compensate the promisee, then in that case also consideration is not required. If it is a promise in writing and signed by the person to be charged therewith or by his agent to pay a debt barred by the law of limitation. So even in this case, there will be no consideration because there is an agent involved, and in this case, the agreement is going to be valid. Besides, according to Section 185 of the Indian Contract Act, consideration is not required to create an agency. So when we talk about agency, there are two parties that are involved. So there will be a principal and an agent. So agent will be someone who will be carrying on the business of the principal or representing the principal. So in that case also, what happens is the agent is supposed to get business for the principal, and the principal does not have to necessarily pay separately because the agent earns as a part of the sale itself. In case of gift actually made, no consideration is necessary. There need not be nearness of relation, and even if it is, there need not be any natural love and affection between them. So in the first case, we saw that there was an agreement and it was purely out of natural love and affection. But in case of gift, the relation requirement is not mandatory. So in that case also, consideration is not required. Now, coming to flaws in contract. So far we understood what are like the essentials of a valid contract. So we saw that there have to be two or more people. It should be for a lawful purpose. There should be lawful consideration, and there needs to be an intention to create legal relations. So now let us understand flaws in contract. So there may be circumstances where a contract made under standard rules is flawed, resulting in the apparent agreement not being a real agreement. So what happens is, on the face of it, it might look like there is an agreement that is established, but such agreement is an apparent agreement and not a real agreement. So where there is no real agreement, the law provides for three remedies. So there are three remedies in case of no real agreement. The agreement may be treated as of no effect, making it a void agreement. So now since it is not real, you can declare it to be void. So the first one is to make it a void agreement. The law may give the aggrieved party the option to exit the bargain, making the contract voidable. So voidable is at the option of. So void, it says it is invalid, but voidable here is at the option. So there is an option to invalidate it. And lastly, the party at fault may be compelled to pay damages to the other party. So three things that can be done. Altogether, you declare the agreement to be void. Secondly, if the aggrieved party wants, they can make this contract voidable. And thirdly, the party at fault can pay the damages. So the party aggrieved can make it a voidable contract, and the party whose fault it was can be compelled to pay charges to the other party. Now, coming to void agreement. A void agreement has no legal effect, cannot be enforced, and confers no right to either party. So, void is something that is invalid. So, it has no legal effect, it cannot be enforced, and confers no rights on either of the party. It is not considered a contract at all and is essentially non-existent, such as a minor's contract. So, firstly, it is not a contract, and secondly, it is actually non-existent entirely. So according to section 2 subsection J of the Indian Contract Act, a contract that ceases to be enforceable by law becomes void when it is no longer enforceable. So when we were understanding the meaning of contract, we saw that agreement plus enforceability is a valid contract. Now, if the enforceability itself goes away, then the contract will cease to exist because it will not be enforceable by the court of law. Next up is a voidable contract. According to the Contract Act, is enforceable by law at the option of one or more parties, but not at the option of another. So there is one party to whom option is given. So we saw in the previous one also that in case of any breach, the aggrieved party can make the contract voidable. Next, a voidable contract can be ended by the party if their consent was not free. So we also know that there has to be free consent that is required for any agreement, and a voidable contract can be ended if the consent was not free. Next, the contract remains binding if the party does not exercise the option to avoid it within a reasonable time. So if the party, what we're talking about here is at whose option it is voidable. So if the party does not avoid it within reasonable time, then the contract will remain binding itself. Next, consent is not free if it was given due to misrepresentation, fraud, coercion, undue influence, allowing the party to avoid the contract. So, as we all know, free consent is one of the essentials of a valid contract. And if any of these are present, that is your misrepresentation, fraud, coercion, undue influence, then in that case, your consent is said to be not free. And in that case, an agreement could be void as well. Coming to illegal agreement. So illegal agreement, like a void agreement, has no legal effect. So again, illegal agreement has no legal effects. The transactions collateral to an illegal agreement also become tainted with illegality and are not enforceable. So now, say for example, let's take the example of the murder that we're seeing. If A is paying B rupees 10 lakhs to commit the murder of C, then there is a contract between A and B, and now B ties up with another person, D, to fetch all the materials required to kill C. Then in that case, the contract, or the agreement between B and D also becomes illegal because it is supporting an already existing illegal agreement. So parties to an unlawful agreement cannot seek help from a court, as the court will not support polluted hands. So if the parties were aware that the purpose is unlawful, then they shouldn't have entered into the agreement. So now if there was an unlawful agreement and if the parties want to take the help of the court will not take their help because this was for the purpose of an unlawful activity. Next. In contrast, a collateral transaction can be supported by a void agreement. So issues such as deception, lack of genuine consent, mistake, incapacity to contract, illegality or physical immobility are flaws or vices in a contract. These flaws or vices render an agreement unenforceable or void. The chief flaws in contract are incapacity. So basically, you don't have the capacity to get into an agreement. Mistake, that is, you did not understand the terms and conditions. Misrepresentation, the promiser or the offerer misrepresented certain data just to get the contract executed. And last one is fraud, wherein with a guilty mindset, you want to cause harm to another person and you will be charged of fraud. Now, Flaw in capacity. So we were talking about how uh, uh, the party should be competent to contract. So we will begin with this. Flaws in capacity of persons. So persons in law are either natural or artificial, like we all know. So in the law, if there is a word of the use person, it is not related to an individual alone. So if it is individual, it means a human being, but person can include all the living creatures. So in this case, person in law are either natural, which are human being, which is a natural person, and or artificial, which is corporations as well. Contractual capacity or incapacity is linked to personality. The general rule is that all natural persons have full capacity to make binding contracts. So all natural persons. Now, exceptions under the Indian Contract Act include minors, lunatic, person disqualified from contracting by any applicable law. So, if, for example, a contract between A and B, where A will steal a diamond from a museum and B will pay 5 lakh rupees for its delivery, is not valid because the consideration is illegal. That is, you are asking them to steal a diamond, and hence this will not be valid at all. No. Persons not competent to contract include minors. So basically people who are less than 18 years of age, lunatics, and those disqualified by law. Section 11 of the Indian Contract Act states that a person is competent to contract if they are the age of maturity greater than 18 years, they are of sound mind, and they are not disqualified by law. So if we are saying somebody is a lunatic, the opposite will be somebody of a sound mind. Next. A valid agreement requires both parties to understand the legal implication of their actions, necessitating mature minds. So the law presumes immaturity in minor and lunatics, thus barring them from contracting. Example, S, a nurse, and H, a seriously ill patient, enter a contract where H transfers a flat worth 50 lakhs to S for rupees 500. This contract involves undue influence and is voidable. So here there was an advantage that the nurse had over the seriously ill patient, and hence this involved undue influence and is voidable. So at whose option it is going to be voidable? At H's option it is going to be voidable. Next is person of unsound mind. So a person who cannot understand a contract or make rational judgments about its effects or interest. Contract validity, contract made by a lunatic or person of unsound mind are generally void. Lucid intervals. If a person is of a sound mind during lucid intervals, they are bound by the contract made during such period. So it means that probably not all the time they are of unsound mind. Probably they have intervals wherein their mind is working and functioning correctly. Then in that case, in lucid intervals, if there was any contract that was entered into by the person, then the person will be liable. Then we have benefit contracts. So contracts that are part of the benefit of a lunatic or person of unsound mind can be enforced against the other party, but not by them. So this way, lunatics agreement is something that is being discussed in the chapter. Next, flaw in consent. So as we all know, there is a requirement of a free consent for any contract to be essentially valid. So let's have a look at flaws in consent. Basis of contract. The foundation of a contract is mutual consent, meaning both parties must agree on the same terms and willingly. Consensus additive. This term means the meeting of the mind. So when we were discussing about the chapter earlier, we saw what exactly is consensus additive. That is the person, the parties to any given agreement have to understand the law in the same manner, the same sense, and also the contract in the same manner, in the same sense. Free consent. For a contract to be valid, consent must be given freely. Consent is not free if influenced by coercion, threats, or force. So if somebody is forcing you to forcing that they will pay you some amount if you kill a person, then that is a threat or force. Undue influence, abuse of power or influence. So we were just seeing how the nurse and the seriously ill patient. So how the nurse got the 50 lakh a house transferred for rupees 500. So there was an undue influence because the nurse is taking care of the patient. Misrepresentation is basically stating false facts. So you are stating facts, but they're mostly false. Fraud is intentional deceit. So this will come under mens rea. Mistake is incorrect understanding of the terms of facts. Contract validity. So void contract, no consent or mutual mistake renders the contract void. Voidable contract is that consent was free but influenced by any of the above factors, making the contract voidable at the option of the defected party. So this is the flaw in consent. That is, what are the scenarios and cases wherein men also like how flaw in consent. So basically, if any person entering into a contract, if they have not given their consent freely, that is, if it is due to like coercion, undue influence, misrepresentation, fraud, then in that case, how the consent will not be free, and hence the contract will also not be valid because an essential element of a contract is missing. Next up is willful misrepresentation or fraud. So, as the name suggests, there is some information that is being given, but it is not correct. It is misrepresented. So, in that case, as per Section 7 of the Indian Contract Act, fraud means and includes any of the following acts committed by a party to a contract or with his convenience or by his agent with the intent to deceive another party. Again, this is very important, intent to deceive another party, where there to or his agent or to induce him to enter into the contract. The suggestion as a fact of which is not true by one who does not believe it to be true. The active concealment of a fact by one having knowledge or belief of the fact. So you know something, but you are still hiding it. A promise made without the intention of performing it. And any other act fitted to deceive, that is, any such commission or especially laws that are declared to be fraudulent. So under all of this, that will be a willful misrepresentation or fraud. So when we talk about fraud, fraud involves making a false statement knowingly, recklessly, or without belief in its truth with the intent to deceive. Now, what are certain key elements of fraud? So first one is false representation. The statement must be false. Second one, fact-based. The false representation must be about a fact, not about an opinion. Intention to deceive. The statement must be made with the intent that it will be acted upon later. Inducement. The false representation must actually have caused the other party to enter into the contract. Then we have indemnification, that is, the deceived party must suffer damage due to fraud. Knowledge or recklessness, the statement must be done with the knowledge of his falsity without belief in its truth or recklessly caring about its truth. So this way, willful representation and fraud is something that is very prominent in the Companies Act 2013. In the Indian Contract Act 1872. Now, coming to the effects of fraud. So, a party defrauded can avoid the contract. So, defrauded is the person who is affected. The affected party can avoid the contract. The defrauded party can also claim damages. Next, silence and fraud. Mere silence is not considered fraud unless silence acts as if it were a statement or the person had a duty to disclose the information, such as in contracts requiring utmost good faith. So this way, fraud is something wherein the opposite party, the person who has suffered the fraud, will be able to claim damages, and they can also avoid the contract. So the next type of contracts are contract uberime fide, which means contract of utmost good faith. So these require full disclosure of material information to ensure that all the parties are fully informed. Failure to disclose relevant information renders the contract voidable. So certain examples of this will be insurance contract, that is, the assured must disclose all material facts truthfully to the insurer. So here in this case, say for example, there is a health insurance, then it is the responsibility of the assured to inform the insurer of all medical conditions, if any, that he has. Then in that case, this contract will be of contract at most good faith, because it is the duty of the assured to keep the insurer informed. So this is the first one, that is insurance contracts. Coming to the next one is the company prospectus. So prospectus is basically like an offer document wherein say for example, if the company is going for an IPO, then in that case they'll have to issue a prospectus which contains all the details of the company, especially which are relevant to making informed decision making. So a company must truthfully disclose information when inviting public subscription for shares. Failure to disclose material facts can lead to liability for damages and make the share purchase contract voidable. So the share purchase will be done on the basis of the prospectus, and that is why it is the duty of the company to mention accurate and adequate information in this. Next up is the sale of land. That is, the seller must provide a clear title to the land being sold. That is, the title should not be challenged, and they should make sure that the land that they are selling has a clear title. Next up is family arrangements. Member must fully disclose all material facts in property settlements. So why are we saying that these are contracts ubere me fide? It means that they are in good faith. That is, all the information necessary should be disclosed to the other party. So now coming to coercion. So coercion is something that we learned under the concept of free consent, wherein free consent is an essential of a valid contract, and coercion is something that may resign that. So definition of coercion. So as per section 15 of the Indian Contract Act, coercion involves committing or threatening to commit an act forbidden by the IPC or the Indian Penal Code, or unlawfully detaining or threatening to detain property with the intention of causing a person to enter into an agreement. So in simple word, it means to threaten someone so that they agree to enter into a contract or an agreement with you. So nature of coercion, it includes action forbidden by the IPC even if committed in the jurisdiction where penal code is not applicable. For example, if A threatens B with a pistol to force B into signing a promissory note, B can avoid the agreement as his consent was not freely given. So basically, if you will be like, if A tells B that please sell your house to me at half the price, if not, I will kill your family member. Then in that case, B is signing this agreement under coercion, which means that under the threat of another person. So threats directed at third parties also qualify as coercion. So for example, if A threatens harm to C unless B signs a document, this constitutes coercion. So this is a similar example that we just discussed. So now, simply threatening to prosecute someone does not constitute coercion unless it is tied to a contract made under such threat. So when we are saying coercion, why is it so important? Because coercion stops free consent. So if you have not given consent out of your will and it is out of coercion, only then it will be said to be coercion. That is, there has to be a contract that is made under such threat. The threat must be directly related to the contract being contested. So if you are saying, I will kill your family member if you do not sell this house to me, and the person agrees to sell the house, then it is said to be a coercion. Coercion can be directed against any person, including strangers, and can involve unlawful detention of goods. So coercion is not only related directly to the party, but can be any third party or a stranger as well. The next one which stops free consent is undue influence. So under section 16. So we have section 15 which talks about coercion, and then we had section 16 which speaks about undue influence. So under section 16 of the Indian Contract Act 1872, undue influence occurs when dominant position. So one party is in a position to dominate the will of the other due to their relationship. So this could be maybe a boss and a servant, or a teacher and a student, or a doctor and a patient, wherein one party holds the superior authority as compared to the other. So there has to be a dominant position in existence. Unfair advantage. This dominant position is used to obtain an unfair advantage over the other party. That is, you know you are in power and you are making use of the power to your advantage, which is unfair to the other person. So there has to be unfair advantage as well. The term unfair advantage encompasses more than just transactions that appear obviously unfair. It includes any situation where the influence is misused or confidence is betrayed, regardless of how obvious the unfairness be. So basically, if any situation wherein influence is misused or confidence is betrayed, the confidence that is shared as a part of having this superior inferior relationship, that is when undue influence comes into picture. Now, legality of object. So this is when we were discussing that one of the essential of a valid contract is that it must be for a lawful object and for a lawful consideration. So in order to ensure that the contract is valid, the object and consideration must be lawful. According to section 10 of the Indian Contract Act, all agreements are considered contracts if they are made with free consent, and then competent parties. So we were discussing competent parties is someone who is a major, who is of sound mind, and who is permitted by law to enter into a contract, supported by a lawful consideration for a lawful object. So now section 23 outlines when consideration or object of an argument is deemed unlawful. So when is the object of an agreement deemed to be unlawful? So forbidden by law if it is contravening any legal provision. So if law forbids you to do so, so say for example, law forbids and penalizes anybody who commits a crime, say intentionally harm someone or murder someone. So if your contract involves your murdering as the object, it will contravene your legal provision. Defeats legal provision if permitting it would undermine legal provisions. Fraudulent if it involves deception. Deception is basically like cheating. Injury to others if it causes harm to a person or property. Immoral or opposed to public policy. It is immoral or opposed to the public policy by the court. Agreements with unlawful considerations or objects are void and not enforceable. So they're not even voidable, they are void, which means that they're completely invalid. So now we have both these terminologies. We have void as well as illegal contract. So let's have a look at them. So void contract lacks any legal effect and is non-existent. So basically it is invalid. It does not create any legal obligation or right between the parties. For example, a contract with a minor is void, but it does not taint a related transaction. So we know that it cannot exist at all, any contract with a minor. Coming to illegal contract, also lacks legal effect between immediate parties but has additional consequence of tainting any collateral contracts. Basically, void contract, only that particular contract is void, but in case of illegal contract, if there are any collateral Yes, so we were discussing the difference between void contract and illegal contract. So void contract is something that can never come into existence. And illegal contract is not only that contract is illegal, but anything collateral to that also becomes illegal. So thus, all illegal contracts are void, which means all illegal contracts are non-existent, but not all void contracts are illegal. Void contracts do not necessarily have unlawful objective. So if you see here the example of the contract with a minor, so this contract was not enforceable because it was with a minor, not with an unlawful object. So all illegal contracts are void and not all void contracts are illegal. So this is something that is really important to remember. Now, understanding the consequence of illegal agreements. So an illegal agreement is entirely void. No action can be brought by a party to an illegal agreement. The maxim is extirpe cause non written action. From an evil cause, no action arises. So if your object itself is illegal, then there is no chance that there will be any action arising from it. Money paid or property transferred under an illegal agreement cannot be recovered because firstly, you shouldn't have transferred because it was an unlawful nature. The maxim is party delicto porietis condition defendatis. In case of equal guilt, more powerful is the condition of the defendant because in the first place, you shouldn't have performed something that was illegal. Where an agreement consists of two parts, one part illegal and other part legal, and the legal part is separable from the illegal one, then the court will enforce the legal one. So now it could be that in case of any agreement, there are two parts, and if those two parts are not separable, then entirely that particular agreement is going to be illegal. But if the two parts are separable, then in that case, the legal one will be enforceable. So if the legal and illegal parts cannot be separated, then the whole agreement itself is illegal. Any agreement which is collateral to the illegal agreement is also tainted with the illegality and is treated as being illegal, even though it would have been lawful by itself. So, say for example, we were discussing how void agreements are always illegal, but illegal agreements are not always void because in case of void agreement, the collateral agreement probably could be enforced. So, say for example, there is one there is one agreement between person A and a minor that the minor will purchase the car from person A. So in that case, this agreement is illegal. But if person A actually had to get the car from person B, so B is selling it to A, that is not necessarily illegal. That is completely valid. That could be enforced as well. But in case of illegal contract, so if A is paying B to kill C, and for that B is entering into an agreement with D to purchase the equipment, then in that case the contract of B and D also becomes illegal. So it taints the collateral agreements as well. So next is agreements void as being opposed to public policy. So in this case, it encompasses various concerns such as prejudice to the states, agreements that could harm national interests during wartime. That is, say, for example, if you enter into a contract with the enemy country to supply material to them, be it a raw material or be it any supplies essential for survival, then that will be you are harming your national interest, especially during wartime. Abuse of justice, agreements that obstruct the course of justice. Unreasonable restrictions, agreements that impose undue limitation on personal freedom, such as in marriage or trade. Common law doctrine, public policies are common law principles shaped by precedents. Courts must adhere to the established classes of cases and cannot create new ones arbitrarily. This principle is cautious as it is considered risky and potentially inconsistent to base legal decisions solely on public policy. Next is last one is the judicial caution, which says that the application of public policy must be done carefully and only in clear cases where there is undeniable harm to the society. So now, even if you are taking up public cases, you have to make sure that there is no harm to the society. Courts should not extend or create new public policy principles without a substantial justification. So even if you are bringing any new policy into picture, you need to have a justification as to why that particular policy was introduced. Now, the following agreements are void as being opposed to public policy, but they are not illegal. Agreement in restraint of parental rights. An agreement by which a party deprives himself of the custody of his child is void. So there is nothing illegal that is happening here, but that is public policy because the party is depriving himself of the custody of his child, which is actually his duty. So this will be void because it is against public policy. Agreement in restraint of marriage. An agreement not to marry at all or not to marry any particular person or class of person is void as it is in restraint of marriage. So basically you are curbing your personal right. Next, marriage brokerage or brokerage agreements. An agreement to procure marriage for a reward is void, where a purohit was promised rupees 200 in consideration of procuring a wife for the defendant. The promise was held void as opposed, and the purohit could never recover the promised sum. So, if you are working for marriage brokerage and that agreement cannot be valid, it is always going to be void. Agreements and restraint of personal freedom are also void. So where a man agreed with his money lender not to change his residence or his employment or a part of any of his property or incur any obligation of credit without the consent of the money lender, it was held that the agreement was void. So here there is personal freedom involved. So this person is saying that I will not change my residence or employment or any property unless I pay you the money or unless I have the consent of the money lender. Then in that case, this is void because he is depriving himself of his personal freedom. Agreement in restraint of trade. An agreement in restraint of trade is one which seeks to restrict a person from freely exercising his trade or profession. So say for example, A and B, A is entering into a contract with B and asking B that B cannot sell this particular product below this price. So in this case, B's freedom to choose the price and set the price according to the market is being curbed, and hence this will be void because it is opposed to public policy. So next up is wagering agreements. So let us just quickly recap what we have learned so far. So as a part of this chapter, we understood the reason for establishing the Indian Contract Act. We had a look at the meaning of contract. Then we came to agreement. Then we understood promise and proposal. Then we saw offer and acceptance. What constitutes a valid offer? What constitutes a valid acceptance? Then we saw the various essentials of a valid contract, wherein we saw consideration, free free consent, lawful purpose, and the consideration also should be lawful. And we also saw the difference between illegal agreements and void agreements. And lastly, we also saw contracts of good faith, wherein we had the insurer. And then we saw examples and terms which restrain your free consent. So it could be your coercion or your undue influence. So now let's move on to the next part of it. So the next part is wagering agreements. In simple terms, wagering agreements are nothing but gamble or betting agreements. So a wager or betting agreement involves a bet on an uncertain event where one party's gain is the other party's loss. So, say for example, if A is entering into an agreement with B saying if India wins the World Cup, then B is supposed to pay A rupees 50,000. So, here the uncertain event. So, the uncertain event here that we are discussing about is winning the match. So this is something that is not under the control of either A or B, and hence this is an uncertain event. Example, if A bets rupees 100 on the outcome of a cricket match with the condition that if England wins, A will pay B rupees 100, and if England loses, B will pay rupees 100, this constitutes a wagering agreement. So now, the agreement is based on an event whose outcome is uncertain at the time the contract is made. So this is not something after the outcome is there. So if you are saying after the World Cup that, okay, since England has won, please give me 100 rupees. No, this should have been said prior to the event occurring itself. The parties are essentially gambling on the event. So this is basically nothing but betting or gambling. Legal standing, wagering agreements are typically unenforceable in court. If a party wins, they cannot claim the amount from another party. So you cannot go to the court and say that you had promised to pay me rupees 100 if England wins, so please pay that. That is not possible. So generally, what's the practice in India when it comes to wagering agreements? Let's understand that. So wagering agreements are considered void in most parts of India. This means that they are not enforceable by law. However, there's a special case in Mumbai. In Mumbai, the Avoiding Wages Amendment Act has declared wagering agreements as illegal. It is not even not enforceable by law, but it is illegal. As a result, such agreements are not only void, but also taint all collateral agreements related to them. So all over India, they are not enforceable by law, which means that they are void. However, in Mumbai, it is also void and illegal. Yes, in Mumbai, it is also void and illegal. So now, implications in Mumbai. So if A bets with B and loses, and C pays B on A's behalf, C cannot recover the money from A because the transaction itself is illegal. So C is making payment for a transaction that is illegal, and hence C will be in no position to recover the amount. Conversely, if the same betting transaction occurs outside Mumbai, where wagering is only void, C could recover the amount from A because the capacity of C is outside of the initial contract, that is void. Now, wagering agreements which are void. So agent principal scenario. So if the agent loses, so in Mumbai, an agent who loses a bet on behalf of the principal and pays the amount to the winner cannot recover it from the principal, because now say for example, there would have been a bet between A and B, wherein A is the principal, and instead of the principal, the agent C is representing. So ideally now C and A will be the parties to the gamble. So now if C has lost a bet on behalf of B, it cannot recover the amount. So although the initial agreement was between A and B, the collateral agreement is between B and C, and hence as a part of this, C cannot recover any amount from B if C is paying anything to A. In other parts of India, the agent could recover the amount. So in that case, C could have recovered the amount from B, and B would be the person ultimately making the payment to A. If the agent wins, the agent must pay the winnings to the principal as the money was received on the principal's behalf. So if you see here, there is a risk involved even for the third party, that is the agent. That is, if they win, the money has to be given to the principal, but if they lose, they cannot recover money from the principal. Understanding commercial contracts versus commercial transactions versus wagering contracts. So to distinguish between a commercial transaction and a wagering contract, consider the intent, valid contract. So if the transaction involves actual delivery and recipients of the goods, it is generally valid. Wagering contract is if the transaction involves only settling differences without actually delivery of goods, it is a wagering contract. Mutuality, wagering contracts, there must be mutuality where one person's gain is other party's loss. So this is very important, that is one person's gain is the other party's loss. So here what happens is, if England wins, A will pay B rupees 100. So A is losing, B is gaining. If England loses, B will pay A rupees 100, wherein B is losing and A is gaining. So one party's gain is the other party's loss, especially based on an uncertain event, something that is not under the control of the parties. Next. Understanding void agreements. So this is in continuation of what we had learned earlier when we were seeing the difference between void and illegal agreements. So let us see for certain types of agreements which are void under the Indian Contract Act. So agreement by or with a minor or a person of unsound mind or a person disqualified to enter into a contract. So kindly excuse this, please. Yes. So agreement with a minor or a person of an unsound mind or someone who is not qualified to enter into a contract. Agreement made under a mistake of fact material to the agreement on the part. So if there's a mistake of fact, so say for example, let us take the example of a car itself. So wherein A agrees to sell his car to B. B thought that the car is a SUV, but it was actually a sedan. So there was a mistake of fact itself. That is, your subject itself was not understood properly. So in that case, this agreement will become void. An agreement of which the consideration or object is unlawful, like the agreement to murder someone. If any part of a single consideration or any one of the several consideration is unlawful, the agreement is void. An agreement made without consideration subject to 3 exceptions that are provided in section 25. So if any of these conditions are satisfied, then in that case, the agreement is going to become void. Next is agreement and restraint of marriage, wherein you're stopping the marriage, restraint of trade, restraint of legal proceedings, the agreement, the meaning of which is not certain or capable of being made certain, agreement by way of wager, agreement to enter an agreement in the future. So what happens is your agreement has to be entered at the moment. Any future agreements will be void. An agreement to do an act impossible in itself. So like say for example, A promises to go to the moon and come back, then in that case, pick a piece of the moon and come back, then this is something that is impossible, and hence this agreement is going to be void ab initio, that is void from the beginning itself. So now, when does a contract become void? So now, an agreement which is not enforceable law is void ab initio. Void ab initio basically means void from the beginning. So void ab initio, nothing but void from the beginning. So a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So it would have been, allowed in the beginning, but later point it has become not enforceable by law, then it becomes void at that time. Next. A contract becomes void when, by reason of some event which the promiser could not prevent, the performance of contract becomes impossible. Example, by destruction of the subject matter after formation of the contract. So we'll take the example of the car only, wherein A had agreed to sell the car to B and there was a contract, but A met with the accident and the car got damaged and without a condition to repair. So in that case, promiser could not prevent the event because this was an accident and the performance of the contract. So now that the car is completely crushed, it is not possible to sell the car at all. So in this case, subject matter itself is destroyed and hence this contract becomes void. A contract becomes void by reason of subsequent illegality. That is, A in India agrees to supply goods to B in Pakistan. After the formation of the contract, war breaks out between India and supply of goods to Pakistan is prohibited. So the contract becomes void. So if you see, when A had agreed to enter into an agreement with B to sell goods, it was all fine. But then later, before performing the contract, any transactions with Pakistan became illegal. Then in that case, from that time, the contract is going to become void. A contingent contract to do or not do anything if an uncertain future event happens becomes void if the event also becomes impossible. So say for example, the match example, if the match itself is not happening, the match has been cancelled due to rain, then in that case, we will never be able to understand the outcome and hence the contract becomes void. Where a contract is voidable at the option of the aggrieved party, the contract becomes void when the option is exercised by him. So there will be certain contracts wherein outright it does not become void, but it becomes void at the option of the aggrieved party. So in that case, it will become void the minute the aggrieved party makes it void. Next, coming to contingent contract. So as the name suggests, contingent contract can be something that is depending on something uncertain. So Section 31, a contingent contract is dependent on the occurrence or non-occurrence of a specified event. Example, selling 10 bales of cotton for rupees 20,000 if the ship returns safely. So here, say for example, there were heavy tides and the chances of the ship returning are very less, or the chances are not predictable. Then in that case, this is the event. So the ship returning safely is the event, and a contract which is dependent on occurrence or non-occurrence of that, this becomes a contingent contract because you are not sure if this ship is actually going to return safely or not. Common examples, insurance contracts, that is, if there is a fire, we will insure you for the goods, contracts of indemnity, contracts of guarantee. So in all of these cases, if the event happens, only then the contract will be valid. Next, coming to quasi contracts. So quasi-contracts resemble contracts but lack traditional elements like offer, acceptance, and consensus. Basically rest on the principle of preventing unjust enrichment. So it is not actual contracts but obligations imposed by the law. So now one example we can take to understand this is money paid by mistake must be returned. So actually there was no offer, no acceptance, but say for example, like a basic example, like if you're making a UPI transaction and you have made it to the wrong phone number. So in that case, the amount has gone to a different account. So that account holder has to transfer back the money to the this account holder. Although there was no contract between them, but this is an established or an implied rule. So this, the purpose is to ensure fairness and prevent one party from unfairly benefiting at the other person's experience. So what happens in this case is that party to whom the money did not have to go to will gain the money, and the person to whom the money had to go to will lose the money because they would have not received the money actually. So quasi contract is something that is to prevent any unjust in the court of law. Next, coming to discharge or termination of contract. So we understood how to enter into a contract. When will a contract be void? When will a contract be illegal? Now, when will the contract discharge or terminate? Basically, end. So a contract is said to be discharged or terminated when the rights and obligations arising out of the contract are extinguished. So basically, it means that they have been fulfilled. Contracts may be discharged or terminated by any of the following modes. Performance of contract. So now if your whatever was required of the contract, if I'm saying I wanted to sell my car, I sold my car, got the money, everything is settled, then performance of contract, that contract will be discharged. So in this case, it will be discharged. Mutual consent or agreement, that is if the parties itself decide that they do not want to go ahead with the contract, then it will be terminated. Lapse of time. So like we were saying, even for acceptance, there will be time within which acceptance has to be sent, or there should be a time within which the contract is supposed to be performed and it was not performed, then in that case, the contract is terminated. Operation of law, like if there is any change in the legality and post that the contract is no longer enforceable, then the contract will be terminated. Impossibility of performance and breach of contract. Breach of contract basically is that any condition required to fulfill the contract is not being fulfilled, then in that case, the contract will be terminated. Next, discharge by impossibility or frustration. So doctrine of frustration is covered by sections 32 and 56 of the Indian Contract Act. It basically says that on a relief basis, it is granted when an unforeseen event frustrates the contract's purpose. So say for example, relief requires showing that the frustrating event was unforeseeable or could not be reasonably anticipated. So again, these are void because these are impossible acts. Contracts to perform inherently impossible acts of void, that is say for example discovering your treasure. Subsequent impossibility, contracts become void if performance becomes impossible or unlawful. So example, illness preventing a singer from performing. So in this case, say the event was supposed to happen on Sunday and the singer falls sick, then in that case, this contract will not be enforceable because no day apart from Sunday can the singer perform. So in that case, this also becomes an impossible act. Now, in case of compensation for non-performance, so like say for example, where the singer is unwell and they're not able to fulfill their contract. So in this case, if the impossibility is not obvious and known only to the promiser or reasonably should have been known, the promiser must compensate the promisee for the loss despite the contract being void ab initio. So it is the responsibility of the promiser to make good the loss for the promisee. Interpretation of impossibility. So it's not very literal, that is, it does not literally mean, but can include impracticability or substantial change in your circumstances. In the case of Satyabharta Ghosh versus Mugnura, A's contract to sell to land to B was affected by temporary requisition during war. So the court held that Section 56 did not apply because requisition was temporary and did not fundamentally alter the contract's foundation. So here, if you see, it was affected due to war, which means post the war it is going to be fine. It is not altogether squashed. So this way, it's not literal impossibility, but impossibility at that particular time to fulfill the contract. So coming to understanding the breach of contract. So breach of contract is when occurs either when performance is due or during the performance itself. Anticipatory breaches occur before the performance is due. That is the act making performance impossible. A clear intention not to perform. Action or breach. So immediate action, the promisee can sue immediately after repudiation. That is the promiser was supposed to perform certain action but he did not do. Waiting for the performance date. The promisee can wait until the performance date to sue, keeping the contract alive. So say the performance is due next week and today I get to know that this could not be possible because say the singer is not well, then in that case I can wait until the performance date also to sue. Hence, until then at least the contract is going to be live. Now, there are a few case law examples here. So, Hochester versus Delator. B was entitled to sue immediately after A's repudiation, even though the performance was not due until June 1. So, here there is an option. That is, you either wait for the performance day and then sue, or you can sue prior to that as well. Avery versus Bowden. A lost the right to sue for damages due to delay in action. Contract was frustrated by war. So, there was lack of action from A's side, and hence their right to sue for damages was squashed. Frost versus Knight. The promisee can wait to sue and keep the contract alive, but must adhere to all obligations and allow the other party to take advantage of supervening circumstances. So if you're waiting until the contract performance date, then you should make sure that until then you have to adhere to all the obligations and allow the other party to take advantage. Rescission of contract. When a party to a contract breaks the contract, the other party may treat the contract as rescinded. The party resigning the contract is absolved from all obligations under the contract because the contract itself no longer exists. So there will be no subsequent obligations as well. Restoration of benefits. If a party treats the contract as rescinded, they are liable to restore any benefits received under the contract to the other party. So now if you are cancelling the contract, then until then if you have received any benefits. So say for example, the same car example where A agreed to sell the car to B for 10 lakhs and B has already paid rupees 2 lakhs. Then A proceeds to resign the contract saying I no longer want to sell the car. Then in that case, it is the responsibility of A to pay the balance, to pay the advance of 2 lakhs back to B. Yes. Compensation for damage. If a person rightfully resigns a contract, they are entitled to compensation for any damage sustained due to the non-fulfillment of the contract by the other party. So they can claim damages. Consequences of rescission of voidable contracts. So now voidable contracts is something where there is an option that is available. So this section deals with the contracts that are voidable due to a flaw in the consent of one party. When a person resigns a voidable contract, the other party is not required to perform any promises contained in the contract because the contract itself is rescinded. The residing party must restore any benefits received under the contract to the person from whom they were received. So this is again similar to the advance payment example. Now, we understood what is a breach of contract, when is anything said to be a breach of contract, but let's also have a look at what are the remedies available to the injured party. So the injured party can resign the contract and refuse further performance. So instead, the injured party can only do this. They can sue for damages. They can sue for specific performance. So damages is where you will be paid instead of performance, but you can also sue for specific performance. Sue for an injunction to restrain the breach of a negative term. So basically, injunction is like a stay order, and if there's any negative term and you want to prevent the breach, then you can sue for an injunction for that, and sue on quantum meruit, that is on the possibility of performing the scenario, of performing the agreement. Depending on that also, you can claim damages on the breach of contract. Next, contract of indemnity. So contract of indemnity is provided for in section 124 of the Indian Contract Act. In this case, contract of indemnity involves one party promising to save the other from loss caused by the promisor's conduct or the conduct of any other person. So A contracts to indemnify B against proceedings that C may take against B for a sum of 300 rupees. So here one party, so A is promising to save the other from loss. So here they are saving B, and for the conduct of C. So A is the person who will save, B is the person whose loss will it be, and C is the person whose conduct because of which this indemnity is built in. So express indemnity is clearly stated terms of indemnity. Implied is inferred from circumstances such as actions done by A at the request of B. If A incurs expenses, A can recover from B. So in express, it will be clearly mentioned and stated. However, in implied, it depends on the situation. Now, there are parties that are involved. Indemnifier is the party that is promising to indemnify. So, this person here, A, is the indemnifier. Next, indemnified or indemnity holder, the person whose loss is to be made good. So, now here, this person's losses are supposed to be made good, and hence he is the indemnified. Now, so insurance is also a contract of indemnity because the insured will get the benefits from the insurer, where the insurer promises to cover the losses in exchange for a premium. Then coming to the scope under Indian law. The contract of indemnity is limited to losses caused by conduct of the promisor and any other person. Losses caused by events or accidents not dependent on anyone's conduct are generally not covered under indemnity contracts of India. So if we are saying in case of fire, the goods will be insured, so amount will be given for the insurance of the goods. So in that case, if say the fire is self-led, that is due to the high increased temperature of the fire is happening, the insurance won't be given. But if, say for example, there was a worker who did not follow safety protocols and that's why the fire was set, in that case, indemnity gets covered. Yes, example. So A, B, C. A is the creditor, that is the person to whom amount has to be paid. B is the principal debtor who will be paying the amount, and C is the guarantor who would have promised A that if B does not pay the amount, I will pay it for you. A advances a loan of rupees 5,000 to B. C promises A that if A does not repay the loan, C will repay it. This constitutes a contract of guarantee. So instead of, you are guaranteeing the payment of amount by B, and if B does not pay the amount, then in that case, you will take up responsibility to pay the amount. Now, what are the roles? So there is principal debtor, the person who has received the loan, primarily responsible for paying it. So principal debtor is the person who has to pay. Then creditor is the person who has the right to receive. Then we have surety or guarantor, that is the person who promises to repay the loan. So in this case, it is C. So we have three parties involved here. So we have principal debtor. Then in this case, it is B. Then we have creditor. In this case, it is A. And then we have the surety or guarantor. In this case, it is C. So I hope until here everything is cleared. So if any point you have any doubts, please drop them in the comment section below and we will be happy to help you out with them. Now, since we're talking about the contracts of guarantee, let us look at what are the various essential elements of a contract of guarantee. So, a contract of guarantee must satisfy all essential elements of a valid contract. So, whatever is applicable for valid contract, the same will be applicable to a contract of guarantee as well. So consideration, there's a special feature here that is in a contract of guarantee. The consideration received by the principal debtor is deemed sufficient surety for C, because C has provided as guarantee for 5,000 rupees, and if B has made that payment of 5,000 rupees already, then that should be sufficient for C. Section 127. Anything done or any promise made for the benefit of the principal debtor may serve as a sufficient consideration for surety to provide the guarantee. So similarly, here it is not only limited to money, but also any action that can be taken up. So now, what is the difference between a contract of indemnity and contract of guarantee? So in a contract of indemnity, there are only two parties. So there is an indemnifier and the indemnified. Here there are three parties, that is surety, principal debtor, and a creditor. In a contract of indemnity, the liability of the indemnifier is primary. Here the liability of the surety is secondary, because in the first place it will be the principal debtor paying the amount, and if the principal debtor does not pay, then in that case the surety will have to pay, because the surety is liable only if the principal debtor makes default in the payment. The indemnifier need not necessarily act at the request of the debtor. The surety gives guarantee only at the request of the principal debtor. So if a person approaches another person and requests him to give surety for this particular contract, then that will become a contract of guarantee. Then, in case of indemnity, the possibility of any loss happening is the only contingency against which the indemnifier. So there should be a possibility of a loss. In case of a guarantee, there is an existing debt or duty, the performance of which is guaranteed by the surety. So here it is already decided, it is pretty certain as to what will be the condition under which the guarantee will have to be enforced. Next, the indemnifier cannot sue third parties in his own name unless there is an assignment. He must sue it in the name of the indemnified itself. However, the surety on payment of the debt when the principal debtor has failed to pay is entitled to proceed against the principal debtor on his own. So because there are three parties involved here, there is a possibility to sue the principal debtor. Okay, so we are moving on to the next prominent topic of the chapter, that is the law of agency. So as we all know, agency is wherein there will be two parties that will be involved. So one will have the principal and the other one will be the agent. So agent is someone who will be representing the principal and performing the duties and obligations that are entrusted to him by the principal. So let's understand with this definition. So an agent is employed to bring the principal into contractual relation with third parties. An agent acts as a connecting link between the principal and the third party. So we have principal and then we have the third party. So agent is the binding authority between both of these parties. Now, while acting for the principal, the agent is clothed with the principal's capacity. So entirely what the principal has the rights, the same will be available with the agent as well. So formation, there's a clearly stated agreement that, hey, you will be the agent for my business and I will be the principal. And this is your responsibility. All the required responsibility, expected responsibility should already be listed up prior. Implied, inferred from conduct or situation. Consideration is not an essential element in contract of an agency. So this is something very important to remember. Agency formation can arise by estoppel, necessity, or ratification. So now, what are the different types of agencies? So first one is the express agency. A contract of agency can be made in orally or writing. So power of attorney, the usual form of a written contract of agency. That is, I entrust this person with the power to represent me in the court of law. And it gives the authority to act on behalf of the principal as per the terms and conditions specified. For transferring immovable property, the power of attorney must be registered. So again, what are the types of power of attorney? General and special. So grant special power, general power is overall level, you give them a power. When it comes to specific or special power of attorney, it will be only for a single or a specific transaction or a time period. Next, implied agency or agency by estoppel. So estoppel prevents a person from denying the truth of something they have represented as a fact, even if it is not true. So if P allows third party to believe that A is acting as P's authorized agent, then third parties will believe it and this will become an implied agency. Next up, reliance. Third parties rely on this belief and make a contract with A, and consequence, P is stopped from denying the agency even if A had no actual authority. So A had represented himself here, and that's why P understood and entered into the agreement. So this is something that's very important to understand as to what is implied and what needs to be mentioned specifically. Next, again, as a part of implied agency, we have wife as an agent. So wife is presumed to have husband's authority to pledge his credit for purchasing necessities suitable to their standard of living. Husband is not liable if he want tradesmen not to supply goods to credit to his wife, forbade wife to pledge his credit. So he had already given her a warning, and if she's not following that, then the husband is not going to be liable. Supplied wife with a sufficient allowance. Any person held out by another as an agent can hold that person liable for the acts of the ostensible agent, and partners are each other's agents for making contracts in the ordinary course of partnership business. So again, it becomes very, very important to bifurcate it clearly, saying who is the principal, who is the agent, and what is the responsibility of the agent who is coming in. Next, we have agency of necessity. That is, a person entrusted with another's property may incur unauthorized expenses to protect or preserve it. Such an agency is known as agency of necessity. So we have an example here wherein A sent a horse by railway, and upon arrival, there was no one to receive it. The railway company, bound to take reasonable steps to keep the horse alive, acted as an agent of necessity for A. So although there was no express contract that was set, but there was a express need, a necessity, absolute necessity, wherein you had to be the agent. So a wife deserted by her husband can pledge her husband's credit to buy all necessities of life according to the husband's position, even against his wishes. So this is something that the Indian Contract Act gives a power for. Coming to the next part of it, that is agency by ratification. So this is covered under sections 169 to 200 of the Indian Contract Act. So no authority or exceeding authority. So if a person without authority acts as an agent, or if a duly appointed agent exceeds their authority, the principal is not initially bound by the contract, because the principal would have given a certain amount of responsibility and authority. And if the agent has acted outside of it, then the principal is not liable for it. Ratification, the principal may ratify the agent's transaction, accepting liability. So if the agent has exceeded his authority, then it is at the option of the principal or that ratification is possible. Ex post facto agency. Agency by ratification is also known as ex post facto agency, meaning it arises after the event, because only after the authority is exceeded will you be able to ratify it. Effect of ratification, it makes the contract binding on the principal as if the agent had been authorized beforehand. So if you are ratifying it, if you are saying, okay, my agent has exceeded the authority, but I am okay with ratifying it, then it will be treated as though you have authorized him beforehand itself. It relates back to the original making of the contract, making it effective from the moment the agent first acted, not from the date of ratification. Again, ratification is effective only if the following conditions are satisfied. So the agent must expressly contract as agent for a principal who is existence and competent to contract. The principal must be competent to contract not only at the time of agent, but also when they ratified the agent's act. So if he becomes incompetent to contract before ratification, in that case, ratification will not be possible. Because in that case, if the principal is ratifying, the principal becomes liable, and if the principal is not competent to contract itself, then there is no point of the liability occurring of the principal. The principal at the time of ratification has full knowledge of material facts and must ratify the whole contract within a reasonable time. Ratification cannot be made so as to subject a third party to damages or terminate any right or interest of a third person. Only lawful acts can be ratified. So if the agent outside of their authority has done something illegal, then that cannot be ratified even at the principal's choice. Now, let's understand the classes of agency. So we have a special agent and a general agent. So as the name itself suggests, a special agent is an agent who is appointed to do a specified act or perform a specified function. General agent is someone who is appointed to handle transactions within the authority given by the principal, either in odd transactions or transactions related to a specific trade or matter. A special agent has no authority to perform outside the specified task, but in case of general agent, they will have, because they have been given an array of tasks. Third parties cannot assume the agent has unlimited authority because it is a special agent. Third parties may assume that the agent has power to do all that is usual for a general agent in business. Any act beyond this authority does not bind the principal because the principal has very specifically assigned responsibility. Private restriction on agent's authority do not affect the third party. So these are the primary differences when it comes to a special agent and a general agent. Coming to the next one, that is a sub-agent. So as the name suggests, sub-agent is the agent who is appointed by the agent. He is appointed by the agent to whom the principal's work is delegated. So section 191 defines a sub-agent as a person employed by and acting under the control of the original agent. So first, there will be delegation of work by the principal to the agent, and then this authority or work will be delegated by the agent to the sub-agent. Now, sub-agent is the agent of the original agent. The relationship between the sub-agent and the original agent is that of agent and principal. So here in this case, this person becomes the principal and this person becomes the agent. The sub-agent is bound by all the duties of the original agent itself because the actual agent only has delegated the power. The sub-agent is not directly responsible to the principal except for fraud and willful wrong. Next, sub-agent is responsible to the original agent and not principal. The original agent is responsible to the principal. So, sub-agent will be responsible to the agent and agent will be responsible to the principal. And the principal is bound and responsible for all acts of sub-agent as if the sub-agent were originally appointed by the principal. Because anytime the agent is also delegating the work to a sub-agent, the principal will be well informed in advance. Coming to the next one, that is mercantile agent. So under section 2, subsection 9 of the Sale of Goods Act. So we were in the beginning when we were understanding Contract Act, we saw that the Contract Act is not exclusive. It does not diminish the other laws. Other laws can also exist in parallel with the Contract Act. So in this case, in Sale of Goods Act, it defines a mercantile agent as an agent with the authority in the customary course of business to sell goods, consign goods, buy goods, raise money on the security of goods, and this includes factors, brokers, auctioneers, commission agents. So let's understand all of these types one by one. So when we are talking about mercantile agents, we just understood the meaning. So the first one is factor. So factor is a mercantile agent who is employed to sell goods that are placed in his possession, contract to buy goods for his principal. So sell and buy. And there's an apparent ownership here that the factor is the apparent owner of the goods in his custody and can sell them in his own name and receive payment. Apparent owner, why? Because the real owner is the person who appointed the agent. Then we have insurable interest. A factor has an insurable interest in the goods. And general lien, a factor has a general lien on goods for any claim arising out of the agency. So that is what a factor does. Next up is the broker. So broker is a mercantile agent whose ordinary business involves making contracts for sale and purchase of goods and securities. He receives a commission, which is brokerage, and he acts in the name of the principal. Here, in case of a factor, they could act independently as well, but in case of broker, he acts in the name of the principal. He does not have the possession of the goods because in this case, if you see, factor is someone who has the goods in his possession, but in case of broker, they do not have the possession of the goods with them. Lien, they have no lien over the goods because he is not in possession of them. So if you see here the difference between factor, the responsibility is to sell the goods, but for factor, it is to sell the goods which are in his possession where he has a lien over the goods. In case of broker, they do not have the possession of the goods and also there will be no lien on the goods. Next is del creditor agent. A del creditor agent is a mercantile agent who, for an extra remuneration, guarantees to the principal that purchasers who buy on credit will pay for the goods. So this is again something like a guarantee contract, wherein if I am an agent, I am saying if I have sold it to customer A and if customer A does not pay the money to me, then in that case, I will pay the amount that customer A, and in this way, principal will be insured against any losses. So if a third party fails to pay, the del creditor agent is bound to pay the principal the amount owed by the third party. Next is auctioneers. An auctioneer is an agent who sells goods by auction to the highest bidder in public competition. So we would have seen quite a few auctions, especially for like antique articles. Again, a very Very common example that we all see is the IPL auction, wherein players are chosen by team, and this goes to the highest bidder, and the competition is public. That is, they can take part and auction for the players. They have no authority to warrant the principal's titles to the goods, acts as an agent for the seller during the auction. So if there's any auction and if you are representing the principal, then you are an auctioneer agent. After the goods are knocked down, acts as an agent for the buyer for the purpose of the evidence that the sale has taken place. So now we saw so many types of agent, but what is it that it's their duty? So an agent must act within the scope of authority that conferred upon him and carry out the instructions of the principal. In the absence of express instructions, he must follow the custom prevailing in the same kind of the business. So firstly, either first thing, the principal would have chalked down the authorities for him. And if he does not have done, then something that is reasonably prevalent in the related markets. He must do the work with reasonable skill and diligence, whereby the nature of his profession, the agent purports to have special skill. He must exercise the skill which is expected from members of the profession. So if you are an agent, then you must make sure that you are utilizing all the skills available with you to fulfill the agency contract to the fullest. He must disclose promptly any material information coming to his knowledge which is likely to influence the principal in the making of the contract. So since agent has been given complete authority by the principal, if there is anything that will change the principal's mindset to take up the decision, then it is the responsibility of the agent to inform it to the principal. He must not disclose confidential information entrusted to him by his principal. He must not allow his interest to conflict with his duty. That is, he must not compete with his principal. So he should not start a similar business while he is the agent of that particular principal. And the agent must keep true accounts and must be prepared on reasonable notice to render an account. So that is, the minute the principal asks for the account, the agent should be in a position to produce that before the principal. He must not make any secret profit, means that as a part of selling. So say for example, the principal has instructed to sell the goods at rupees 50, but if the agent is selling it at rupees 55, then the 5 rupees is secret profit because that was not authorized by the principal, and in that case he must disclose any extra profit that he may make or has made. When an agent is discovered taking secret bribe, etc., the principal can dismiss the agent without notice, can recover the amount of secret profit because anyways the amount of goods is already being given by the agent to the principal, refuse to pay the agent his remuneration. He may repudiate the contract if the third party is involved in secret profit and also recover damages. Next, an agent must not delegate his authority to a sub-agent. So sub-agent is a person employed by and acting under the control of the original agent. So this rule is based on the principle delegatus non potest delegatur. A delegate cannot further delegate. So in this case, unless the permission of the principal is available, the agent cannot delegate his authority. Now, if there are duties, then there are obviously going to be rights. That is what the agent deserves as a part of this particular contract. So contractual authority, there have to be terms of appointment saying how many months, how many years this will go on for, what is the benefits that the agent will get as a part of this agency. Implied authority, authority to do things incidental to carrying out real authority, also known as apparent or ostensible authority. Emergency authority, authority to take necessary action in emergencies to protect the principal from loss, similar to what the agent would do for their own property. That is, example, a station master sold butter becoming useless due to delay in transit as it was not possible to get instructions from the principal. The sale was binding on the principal because the station master exercised emergency authority. That was what was suitable to that particular situation was authorized by the agent. Next, termination of agency. So when does an agency terminate? So first one is by the performance. So if the agency is being performed completely, by an agreement, so there has to be mutual consent in agreement, by expiration for the period fixed. So if we had decided that the agency is going to be for 6 months, then upon expiry of 6 months, the contract terminates. By the death of the principal or the agency, by the insanity of either. Why is this? Because then the competency to contract will go because lunatics cannot contract. By the insolvency of the principal, in some cases that of the agent, where the principal or agent is an incorporated company by its delusion. So similarly, in case of individual, the death, and in case of a company, the dissolution. by the destruction of the subject matter itself, so the goods itself have been destroyed, by the renunciation of his authority by the agent, that agent says that I will no longer be serving you as the agent, by revocation of authority by the principal. So maybe the agent did not fulfill some certain conditions, and that's why the principal itself revoked the agency. So we are at the last part of the chapter of laws and the general laws that we need to understand. So that is e-contract. So e-contract, as the name suggests, they are not paper-based contracts, but they are in electronic form, addressing the need for speed, convenience, and efficiency. So in this era of digitization, everywhere electronic medium is taking prominence, because to ensure speed, convenience, and efficiency. So transactions can be completed in seconds with digital signatures affixed to electronic copies of contracts. So digital signature is basically a signature which will be affixed to a document upon entering of a password, and that signature will be as valid as a physical signature. And in addition to this, the digital signature is also timestamp, that is on which day and at what time this particular signature was affixed. Initial apprehension by legislatures regarding recognition of electronic contract has been addressed by many countries. Conventional contract law is often insufficient for issues arising in electronic contracts. So in India, the IT Act, the Information Technology Act 2000, addresses specific issues relating to formation and authentication of electronic contracts. So in addition to the Indian Contract Act, the Information Technology Act is something that also governs the provision of e-contract. Example, online sale and purchase transactions like Amazon, Flipkart are covered by both Indian Contract Act as well as the Information Technology Act. So now, like our regular contracts, there are certain necessities of electronic contract. So first one, offer needs to be made, offer needs to be acknowledged, there has to be a consideration, again, intention to create lawful relation, competency to contract, pre-consent, object should be lawful, and there must be certainty and possibility of the performance. So this brings us to the end of part 1 of chapter 2, that is our Indian Contract Act. So I hope everybody is clear with all the provisions that we read. So after the initial discussion, we picked up agency, where we understood the various types of agency in depth. What are the rights and responsibilities of an agent? What is it that the principal can do? We also had a look into wagering agreements, void agreements, illegal agreements, how subsequent agreements also become illegal. So that's it for part 1 of chapter 2. So the next part will be the law relating to torts, which we will take up now. Thank you so much. So now we will be understanding the part 2 of chapter 2, that is law relating to torts. So as a part of the part 1, we understood the entire Indian Contract Act and the provisions that were given in our module. So now we will proceed with understanding the law relating to torts. So when we say tort, to understand it, tort is basically derived from the French word, which means wrong. So tort basically means wrong, and the Latin word tortum. So tort is a civil kind of wrong as opposed to a criminal wrong. So as we all know, we have two codes that are there in place. So we have the Civil Procedure Code and the Criminal Procedure Code, and tort is something that constitutes a civil wrong. So, wrongs in law are either public, that is violation of public laws or crimes, or private, that is breaches of private law or torts. Public wrongs are offenses against the state and punishable under the penal law. A tort is a civil wrong that is not exclusively a breach of contract or a breach of trust. Section 2M of the Limitation Act 1963 defines tort as a civil wrong that is not exclusively a breach of contract or a breach of trust. So there is no contract or trust that has been, there is a breach in it, but it is a civil wrong. Just a minute, please. Yes. So coming to Salmon's definition, so a civil wrong for which the remedy is a common law action for unliquidated damages, not exclusively a breach of contract, trust, or other equitable obligation. So this is what tort means. So it could be as simple as hitting someone, causing an injury to someone. So this is a civil wrong. There cannot be any criminal charges against it, but it is still a wrong. Next, so general conditions for liability of a tort. So there is no fixed catalog of circumstances that permanently define the limit of what constitutes torts. Certain situations have been held to be torts and will continue to do so unless repudiated by the state. Other situations have not been torts. So general condition for a tortious liability. A tort generally consists of an act or commission by the defendant, that is the tortfeasor. So plaintiff will put a case against the defendant. So defendant is a tortfeasor, the person who has conducted the tort. The defendant must have caused harm to the plaintiff without just. So harm to the plaintiff without just cause or excuse. So now there has to be a wrongful act or omission by the defendant. The wrongful act must result in causing legal damage to another, and the wrongful act must be of such a nature so as to give rise to a legal remedy. So there has to be a wrong, there has to be a damage, and there has to be a remedy. So three things very important for tort is there has to be a wrong, there has to be a damage, and there also has to be a remedy for it. Next, so coming to damnum sine injuria. So in case of the law of torts, there are two terms that are very important. So one is damage and second one is injury. So damage is something that is, there is some loss that has happened, some damage that has occurred to one of the party, and injury means damage in the eyes of law. So not all damages will be injury. So in the sense that damage, there may be a loss, but it may not be necessarily an injury in the court of law. So to understand this, damnum means harm, loss, or damage. Example, money, comfort, health. Injuria means infringement of a legal right. So this is what injuria means, that is infringement of a legal right. So meaning, a person may suffer damage but have no action in tort if the damage is not to an interest protected by the tort law. Principle, causing damage, however substantial, is not actionable unless there's also a violation of a legal right. So for there to be a tort, there needs to be a damage plus violation of a legal right as well. So now example, legal exercise of rights. So if you open a shop near mine and I lose customers and profits as a result, I cannot sue you because you are exercising your legal right. So what happens is, if I have a grocery store and another person opens a grocery store right in front of my store, my business is going to go down. But I cannot sue him because he is not doing anything that is not permitted by law. Opening a business is something that the law permits. So this is given in the Gloucester Grammar School case also, wherein it illustrates that the principle that loss due to the legal exercise of another right is not actionable. So say for example, A stores 100 liters of spirit legally, B leaves his goods on the barrel overnight and the goods are spoiled. B suffers damage, but there is no legal injury because the A was just using his right to store the spirit, which is again legally. Only B left his goods overnight. So there is nothing that A has done that has infringed the right of B. Both were exercising their individual rights. Next concept is the opposite, wherein injuria sine damnum, which means that there is an injury but not necessarily damage. So injury without damage, where there is injury or wrong in tort without resulting damage. So principle is that infringement of a legal right not resulting in harm is still actionable in tort. So say for example, trespassing on another land is actionable even if it causes no harm. So trespassing is something that is legally not allowed. So if you are trespassing a land, even though you're not causing injury to the person's land, you are still said to be committing a tort because it is injuria sine damnum. Some rights or interests are so important that their violation is an actionable tort without the proof of damage. Absolute rights. An absolute right is the one whose violation is actionable per se without the proof of damage. So if you have trespassed, if there's any evidence of you trespassing, then there is a tort that has been committed. A casts his vote and the returning officer illegally cancels it. Even if the candidate A voted for wins, A can still sue the returning officer because there is a legal injury. So although it wouldn't have made a difference to the large pool of votes that the person's already got, A still has lost his legal right, that is to vote. So this is injuria sine damnum. Next, legal remedy. So when we were talking about tort, so there has to be a wrong act that has to be committed. There has to be some sort of injury and there has to be a legal remedy. So the wrongful act must come under law to constitute a tort. Action for unliquidated damages. So other remedies could be injunctions or specific restitution in case of chattel detention. Self-help remedy allowing the injured party to act without legal intervention. That is, without any legal intervention, they should be able to get the help. Example, in cases of trespass to land, such as removing a drunken stranger from one's use using necessary force. So you are not necessarily involving any legal authority or body here, but you are using your own force to remove the person from your room. Next, mens rea. So mens rea is the presence of a guilty mind for commission of any offense. So there is a principle which says actus non facit reum nisi mensit rea, meaning an act does not create guilt without a guilty mind. So the minute we think about mens rea, we need to get the term guilty mind in our mind. So application and tort, not necessarily evil motive. The act must be done with wrongful intention or negligence, not necessarily with an evil motive. So for a crime, mens rea is a primary requirement, but for a tort, it is not. The mind must concur in the act, that there must be a concurrence of mind in the act. Cases of absolute or strict liability do not require a guilty mind. So we will also be understanding what is absolute or strict liability going forward. So now to understand the differences between a tort and a crime. So tort is infringement of private or civil rights. Crime is a breach of public rights. The tort's objective is to recompensate the plaintiff for the loss, and crime is to punish the accused. So in case of a tort, you are not going to punish the tortfeasor. So here, again, in case of tort, the person who is being accused is the tortfeasor, and here it is the accused. So here it is to punish the accused. Here it is to just get the compensation from the tortfeasor. Now, difference between tort and a breach of contract. Here it is a breach of duty which is fixed by the law. So there is already existing by the law. But in case of contract, it is something which is fixed by the contracting parties. In case of tort, the damages are generally unliquidated and are determined by the court. And here in case of contract, this would have been preset in the condition of the contract. That is, damages are fixed according to the contract itself. Now, coming to strict or absolute liability. So we have strict or absolute liability, and then we have vicarious liability. So in some torts, the defendant is liable even though the harm to plaintiff occurred without the intention or negligence on part of the defendant. So without intention. So this is very important. So like we were saying, in case of a crime, the guilty mind or presence of mens rea is very important. But in case of a tort, the defendant could be liable strictly or absolutely, even without their intention or negligence. So say, let's have a look at the examples. So these cases fall under the following categories. Liability for an inevitable accident arises when damage is caused by escape of dangerous substances bought or kept by someone on their land. So even though you did not intend to release the substance has released out of your land, and hence you will be strictly or absolutely liable. The person is made by law an insurer of others against the result of their activities. Liability for inevitable mistake occurs when a person interferes with the property or reputation of another. Next is vicarious liability for wrong committed by others. So responsibilities imputed by the law based on the social policy or expediency involves liability of a master for the acts of their servant. So when we're talking about strict or absolute liability, you are liable even though you did not intend to perform it or you did not intend to be negligent. And in case of vicarious liabilities is the liability that you have when the tort is committed by another person. Now, the rule in Rylance versus Fletcher. So this is a very, very important case when it comes to the law of torts, that is Rylance versus Fletcher. It establishes that the person acts as their peril and is the insurer of safety of their neighbor against accidental harm. This duty is absolute and independent of negligence on the part of the defendant. The case held that if a person brings or accumulates anything on their land which it escapes may cause damage to their neighbors, they will do the same at their own risk. If it escapes and causes damages, the person is responsible regardless of the care taken or the precautions implemented. So even though you did not intend to cause the damage, you had been cautious all this while, but still if that particular substance escapes your land and enters another person's land, then in that case, you will be liable. And this was given in the landmark case of Rylance versus Fletcher. So now, a case fact. So parties involved. So there was a mill owner B and the plaintiff who was an adjoining landowner. So in this case, independent contractors were employed by B to construct a reservoir on their land. So there's a mill owner B and there's a plaintiff who is the landowner. Now this B has employed independent contractors to construct a reservoir on his land. Now, old mining shafts. The site had old disused mining shafts that were filled with earth, which contractors failed to notice and did not block. So these independent contractors did not block these mining shafts. So now when the reservoir was filled, water burst through the shafts, flooding the plaintiff's coal mine. So this particular, the adjoining landowners' coal mines were flooded. So now B, who did not know of the shaft was not negligent, was held liable because the contractors were negligent. So although B did not intend to do this and B was fully careful, but the contractors were not careful and hence we will still be held liable. Judicial observation. Blackburn J says that the person who for his own purpose brings on his lands and collects and keeps there anything likely to do mischief if it escapes must keep it as his peril, and if he does not do so, prima facie answerable for all the damage which is the natural consequence of its escape. So it is your responsibility to make sure that it does not escape, and if it escape, it does not cause harm to the other person. Next, later in the case, just a minute. Yes. Later, in the case of Red versus Lyons, it has been explained that two conditions are necessary in order for the rule of Ryland versus Fletcher to apply. So once Ryland versus Fletcher was held as a landmark case, Red versus Lyon also gave two conditions that are absolutely necessary for Ryland versus Fletcher to apply. So one of them, that escape from a place of which the defendant has occupation or over which he has control, which is outside his occupation, likely to do the mischief if it escapes. So once again, let's have a look at this. Escape from a place of which the defendant has occupation or over which he has control. So the defendant should have control over the place which is outside his occupation or control. And non-natural use of land. So defendant is liable if he makes a non-natural use of land. If either of these conditions is absent, the rule of strict liability will not apply. So both of these are extremely important for the rule of strict liability to apply. Now, exception to the rule of strict liability. So the first one is damage due to natural use of land. So when we were saying if you're using non-natural use of land, that has to be a mandate for strict liability to apply. Now coming to natural use of land. So non-natural use in Rylands versus Fletcher, the large quantity of water was deemed a non-natural use of land. And in case of natural use, so ordinary activities such as water pipe installations, mining, lighting, fire, wiring, so these are all natural use of land which is bound to be done, and consent of the plaintiff. No liability with consent. So if the plaintiff consents to the accumulation of dangerous substances on the defendant's land, liability will not arise because the plaintiff himself is aware. Why would he go and complain against it? Common benefit. Consent is implied if the dangerous condition benefits both the plaintiff as well as defendant. Now, act of the third party. So there is no liability for acts of strangers. So if the harm results from actions of a stranger whom the defendant does not control. So in Rylands and Fletchers, the independent contractors were appointed by the defendant, so they were under the defendant's control. But here, if a third party is not under the defendant control, then the defendant will not be liable. For example, in Box versus Jaguar, the defendant was not held liable for an overflow caused by a stranger blocking a drain. So in this case, there is no relationship between the defendant and the stranger, and hence the defendant will not be liable. Foreseeable acts. If the defendant could foresee the stranger's actions and prevent the resulting damage with due care, they are required to do so. Failure to do will prevent such foreseeable liability, can result in liability. So here it basically means that if defendant could see the stranger's action and still he does not take any action, in that case he will be liable. However, if he has taken reasonable amount of action, then he will not be liable. Coming to statutory authority, so in case of public bodies storing water, gas, electricity may be exempt from liability if they have performed a statutory duty and have taken reasonable care. So this is very important. That is the presence of reasonable care. Example, in Green versus Selzy Waterworks, a water company was not held liable for flooding caused by a burst main as it was fulfilling a statutory duty to maintain a continuous water supply. Next, again, act of God. Obviously, this is something that is outside the control of the defendant as well. So the defense of act of God applies when the escape is caused by natural events which are beyond human control, which could not be anticipated or prevented by reasonable human foresight. So even though you were aware that this might be happening, but still the control of it is not in your hands, and hence this is an exception to the rule of strict liability. Escape due to plaintiff's own default. So plaintiff's intrusion. If the damage results from the plaintiff's own default or intrusion into the defendant's property, the plaintiff cannot claim damages. So this was again in the Rylance versus Fletcher case itself that it was decided. So say for example, a scenario wherein A, who intended to commit theft, entered XYZ Limited premises and upon changing his mind, mistakenly drank a glass of transparent spirit stored by the company, mistaking it for water. This resulted in severe illness and hospitalization. So again, if you see here, there was a spirit stored by the company, but it was A who came in with the intent of theft. So since A's harm resulted from his own actions, that is, he is the one who drank the spirit, specifically his unauthorized entry. So it is not only the fact that he drank the spirit mistakenly for water, but how did he enter the premises? It was an unauthorized entry and subsequent consumption of the spirit. His claim for damages under the law of torts is not valid. The damage was due to plaintiff's own default or mistake. So XYZ is not liable for the harm that is suffered by A. Now, coming to applicability of the rules of Rylance and Fletcher in cases of enterprises which are engaged in hazardous or inherently dangerous industry. So now there was another case of MC Mehta versus Union of India, wherein the principles of liability for hazardous industries in India were redefined, adapting them to the context of modern industrial hazard. So here, the court recognized that the rule of Rylance versus Fletcher might not be sufficient to address the complex issues arising from hazardous and inherently dangerous industries in contemporary settings. So now, absolute and non-delegable duties. So first case here there is that enterprises engaged in hazardous or inherently dangerous activity owe an absolute duty to the community to prevent harm. That is, they have to take the entire responsibility to make sure that there is no harm that is caused. This duty cannot be delegated, meaning the enterprise is responsible for ensuring the safety, even if it employs contractors or other parties. So this is something that is entirely the responsibility of the enterprise. High standards of safety. So first we saw that it is not delegable. Secondly, there has to be high standards of safety, which means that such enterprises must conduct their activities with the highest safety standards. They are required to take all possible measures to prevent harm, regardless of the level of care taken. So it is their responsibility entirely. Then there is an absolute liability as well, which means that the enterprise is absolutely liable for any harm resulting from its hazardous activities. This liability exists even if the enterprise has taken all reasonable care and the harm occurred without negligence. So that is the level of liability any enterprise involved in hazardous goods is that is applicable. The traditional requirements of proving non-natural use and escape of a dangerous substance as established in Rylance versus Fletcher was not necessary. So here there is no concept of non-natural use or natural use. It is entirely the responsibility of the enterprise to make sure no harm is caused by the hazardous substance. And outcome, the ruling shifts the focus from traditional tort principles to a more stringent standard of liability for industries, especially the ones involved in dangerous activities, emphasizing the need for strict safety measures and unconditional responsibility for harm. So coming to the next type of liability, that is the vicarious liability. So vicarious liability refers to a situation where one person is held liable for the torts committed by another person, typically due to their relationship. So when we saw strict or absolute liability, it was that the defendant will be held liable even if they have no intention to conduct the tort. In case of vicarious liability, one person will be liable for the tort committed by another. So again, this is the relationship wherein we have the employer and employee, master servant, principal agent, and the partners inter se. So now, principal and agent, the first one. So here there is this thing of This is the one that we just saw in the Indian Contract Act as well. That is, if a person is acting through another, then he is acting through himself. Qui fecit per alium fecit per se, which means that he who acts through another is acting himself. Therefore, the principal is liable for the torts committed by the agent during the performance of their duties. So in Lloyd versus Gray, Smith and Co., a managing clerk fraudulently induced the client to transfer property. The principal was held liable because the fraud was committed within the scope of the agent's employment. So as a part of the employment itself, the agent had induced the client to transfer property, and hence the firm will be held liable. Next comes about partners. So first one we saw was principal and agent. Second one is partners. All partners are jointly and severally liable for torts committed by any partner in the course of the partnership business. This means that each partner can be held liable to the full extent of the damage, whether or not the person was involved in the tort or not. So now in case of Hamlin versus Houston and Co., one partner bribed a clerk to divulge a confidential information. Both partners were held liable for the tort, even though only one partner committed the act. So this is irrespective of whether you were involved in the act or not, you will still be held liable. Next is master and servant. So this is an authority by relation, wherein there is a general principle that a master, that is an employer, is liable for the torts committed by his servant while acting in the course of employment. So this is very important, while they are in the course of employment. Liability is joint and several, meaning both the master and servant can be held responsible. So what are the key aspects? Independence of wrongful intent. The master's liability is independent of their own wrongful intention or negligence as long as the servant has committed it. Joint and several liability, both the master and servant are liable for the tort and each can be pursued for full extent. So this is something that is extremely important because here both the master and the servant will be liable. Vicarious versus strict liability. So vicarious is from the relationship between master and servant, and strict is the person who does the wrongful act directly. Now, master and servant, the master is liable for both authorized and unauthorized act performed by the servants. So there are two maxims here, respondeat superior. Let the principal be liable, that the principal that the master is responsible for the servant's torts. Qui fecit per alium fecit per se. Again, this is the act of the principal and agent. Acts against instructions. The master is liable even if the servant acted against express instructions as long as the act was performed in the course of employment. So if the master cannot escape the liability stating that he had instructed the servant, he will still be liable if the servant goes against the instructions. Next, we have the employer and the independent contractor, wherein an employer is vicariously liable for the servant's tort in the course of his employment. Employer is not liable for the independent contractor's tort. So, servant, yes, but as the name suggests, these are independent contractors and hence the employer is not liable. Servants are under the employee's control. However, independent contractor work independently without the employer's control and hence there is no vicarious liability here. There is no vicarious liability in case of an independent contractor. Degree of control by the employer. So in case of a servant, there is complete degree of control. In case of a contractor, there is no degree of control. Now, where employer is liable for the acts of the independent contractor, merely due to the occurrence, they are not. But employer can be liable if employer himself has authorized in cases of strict liability and employer's own negligence in hiring or supervising the independent. So just because an independent contractor is appointed does not mean the employer's responsibility ends. The employer is supposed to perform their own diligence before appointing the independent contractor. Now, employer is not liable for independent contractors' torts if they have taken care in appointment. If they have not, then they will be this thing. In case of Philip versus Britannia Hygienic Laundry Co., the owner of a lorry was not liable for damage caused by negligent repair by a garage proprietor. So, if you see here, the owner had taken all the precaution, but the repair was by a garage proprietor. Employers of independent contractors are liable for collateral negligence. That is, employer will be held liable when these servant negligently placed a tool on the windowsill, causing harm to a bypasser due to the work being there on the highway. Because in spite there was no negligence on the part of the employer, it is done by the servant, and hence the employer will also be liable. Next up, liability for the act of the servants. So employer will be liable when servant commits a tort in the course of employment. So act is deemed in the course of employment if it is wrongful act which is authorized by the employer, and wrongful and unauthorized mode of doing some act which is authorized by the employer. So example here is in the case of Century Insurance Co. Limited versus Northern Ireland Road Transport, wherein the employer was held liable when a petrol lorry driver caused damage by striking a match while transferring petrol, an unauthorized mode of performing his task, because the lorry driver also did not follow the required instructions. There is another example of Bailey versus Manchester, where an employer was held liable when a portal forcibly removed a passenger mistakenly. So in most of the cases, the employer is liable in case of a servant's torts. Next, vicarious liability of the state. So, how is the state and to what extent is the state liable? So, when we talk about the position in England, the crown could not be sued in the torts for wrongs authorized by it or committed by the servant. So, this is in the case of England. Crown Proceeding Act 1947. The crown is now liable for the torts committed by its servants. So, earlier it was not, but with this, so this is something that is very important. With the Crown Proceedings Act 1947, the state will also be liable for the torts committed by its servants. Now the crown is vicariously liable for the torts of its servants. Now when it comes to the position in India, there is no statutory provision which says the state is liable, but courts consider whether the government activity was sovereign or non-sovereign function. So if it is a sovereign function, then there will be immunity from tort. If it's a non-sovereign function that is not a part of the state, then there will be no immunity. Activities of commercial nature or those executable by private individuals are non-sovereign functions. So in this case, there will be no immunity to the state. So three principles for state's vicarious liability for the torts committed by its servants. Responded superior, let the principal be liable. We face it per alium facet per se, he who acts through another does through himself. Socialization of the compensation. So here there is a mention of the article of the constitution, that is article 300, which says that the government of India may sue or be sued as Union of India. Government of a state may be sued as the state. Now, the government may sue or be sued in the same way as the Dominion of India and corresponding provinces or state. So ours, although we don't have a specific proceeding like in case of England, but still these are the conditions based on which the vicarious liability of the state is determined. So when we talk about Article 300 of the Constitution, Government of India may be sued as union, state may be used as sued as state, government may be sued in the same way as the Dominion of India and subject to any act of the Parliament or state legislation by the virtue of powers conferred by the Constitution. So to quickly summarize what we have seen and read so far, so we understood what is a tort, what are the essential elements of a tort, wherein there has to be a wrong, there has to be a damage, and there has to be a legal remedy that is available. Then we understood strict liability, exceptions where strict liability is not applicable. Then we saw vicarious liability and especially the landmark case of Ryland versus Fletcher. So now here there are a certain sections of torts wherein each type is explained. So we will be taking those up and then we will proceed to conclude with this chapter. So torts or wrongs to personal safety and freedom. So battery. Battery is basically any direct application of force to another person without consent or lawful justification. So now if you push a person, then that will constitute a battery. So firstly, there is a use of force, even a trivial force without the plaintiff's consent. So two things which is important, there has to be a force and there has to be no consent by the plaintiff that is given. Without lawful justification, that is no legal reason for the force used. The wrong of battery is committed even if the force is trivial and does not cause harm. Example, touching a person in anger without lawful justification is battery, because firstly, the force is trivial, it is still fine, and you have not taken the plaintiff's consent. Coming to a slightly higher degree of a tort, that is assault. So assault is any act by the defendant causing the plaintiff to immediately apprehend contact with the person. So firstly, there has to be an apprehension, that is, there has to be a battery in the plaintiff's mind. That is, there is some, without a trivial force that is applied without the plaintiff's consent. Now the defendant intends to commit battery and the plaintiff apprehends it. Now, assault involves apprehension of contract, not the contract itself. So, pointing a loaded gun at someone or shaking a fist under someone's nose can constitute assault. So, in case of battery, there is a direct contract. There is a direct contact with the plaintiff. But in assault, you are creating an apprehension that okay, there is a contact that is going to be created. So, battery and assault often occur together, but assault can occur even without battery. So, you are threatening someone that you will perform a battery on them. So, battery will be contact and assault will be without contact as well. Next is bodily harm, a willful act or statement of defendant calculated to cause physical harm to the plaintiff, and in fact causing physical harm to him is a tort. So that is, you have willingly committed a tort in a way wherein there is a physical harm that is being caused to the plaintiff. Next up is false imprisonment. So false imprisonment is basically imposition of a total restraint on a person's liberty for any period without sufficient lawful justification. So what are the essentials? There has to be total restraint. That is, you have to confine the person within certain limits. No justification. So arrest cannot be false imprisonment because you are giving them a justification saying why the person is arrested. But in case of false imprisonment, there is no justification and you are still confining the freedom of the person. There has to be a false imprisonment, that is confinement within physical boundaries, that is like example within four walls, prevention from leaving a place, and serious violation of a person's right and liberty, because as we were reading in the constitution chapter, freedom to move around is a fundamental right of the constitution, freedom to liberty, and then that is why false imprisonment will constitute a tort. Next up, we have malicious prosecution, wherein instigating judicial proceedings against another maliciously and without reasonable cause, which terminate in favor of another, resulting in damage to their reputation, personal freedom, or property. So basically, you must have prosecuted. There has to be no reasonable cause, and you want to, you're doing this with an improper motive. So without any cause, if you are putting a prosecution or an allegation on another person without any justification, then it amounts to malicious prosecution. So again, the plaintiff must have suffered damage and the prosecution must have ended in the favor of the plaintiff. That is, the plaintiff's reputation is under cost. So coming to malicious prosecution, so damages are that the plaintiff must have suffered damage due to the prosecution, and favorable termination, that is the prosecution must have ended in the favor of the plaintiff. Now, what is the actionable requirement? The actionable requirement is that the proceedings must have been instigated by the defendant. So the defendant must have filed for the proceedings. Simply stating facts to a policeman or magistrate does not make the defendant responsible for any resulting proceedings initiated by the officer's own decision. So what has to happen is that the defendant must have instigated the proceedings, and if the officer is proceeding in by its own motion, then it will not amount to malicious prosecution. The next tort or wrong to the personal safety and freedom is nothing but the nervous shock. So this is comparatively a new concept when we compare to all the other types of torts that we were discussing. So this branch of law is comparatively new. The relief that is provided is that for physical injury caused not by impact but by nervous shock from what one has seen or heard. So when we were talking about battery, there was physical injury that was involved, there was a physical contact that was involved, but in case of nervous shock, there is not necessarily any physical contact, but it is like a mental shock that because of what one has seen or heard. So criteria for an actionable tort, the nervous shock alone is insufficient. Because of the nervous shock, there should have been some injury or illness due to emotional disturbance, fear, or sorrow. That is when a tort will said to be a nervous shock. The next one is defamation. So defamation is an attack on a person's reputation through statements or actions affecting how others perceive them. So if any person is making comment about another in a way wherein they want to bring down the person's reputation in the eyes of the general public, then that will be known as defamation. So let's have a look at the general definition. Defamation is the publication of a statement which tends to lower a person in the estimation of right-thinking members of society, which generally or makes them shun or avoid that person. So this is what is important, that you will generate an opinion in a manner wherein people will start to shun or avoid that person. So again, there are two types of defamation. So first one is libel and second one is slander. So libel is the more serious form because this is the permanent form of defamation. So this could be written words, pictures, caricatures, cinema films, effigy, statue, or recorded words. So these are something that will stay in the memory for a longer period of time because they have been documented. Cinema films, again, both photographic parts and synchronized speech are considered as libel. However, when it comes to slander, it's like opposite of it. It's the temporary form, and of course, it is going to be the oral form. So, libel is something that stays in the memory for a longer time, and hence it is permanent in nature. And slander is something that is said in an oral form, and hence it is more of a temporary defamation. Now, what are the legal consequences of defamation? So first one is severity. That is, punishment for libel is generally more severe than that of slander because libel is something that is permanent and slander is something that is temporary. Now, there is a dual nature. So, defamation is not only a tort, but also a crime. So, this is something that is very important. So, if we want to understand which tort is also a crime, then that is defamation. Criminal law. Section 499 of the IPC treats both libel and slander as offenses. So, it is not like just because libel is of the more serious nature, only that is a crime. Either libel or slander, both are crimes as per section 499 of the Indian Penal Code. Comparison, torts in criminal law are stricter than in law of torts because the penal provisions will be higher in case of a criminal law. Now, what are the judicial remedies available to any person in torts? So this is not only related to defamation, this is the torts in general. So there are three types of judicial remedies that are available. So first one is damages. The court may award damages against the wrong cause to any person. So the court can award damages. So that is the first one. Second one is injunction, wherein a person may be prohibited to act in a particular way or compelled to do a certain act under the remedy of injunction. So damages is mainly payment or providing of a consideration or like a compensation. Injunction is prohibiting a person to do something or compelling them to do a certain thing. Last one is specific restitution of property. A person may be asked to restore a property under the specific restitution of property. So these are the three primary judicial remedies that tort gives. However, there are a few extrajudicial remedies as well. So in addition to damage, injunction, and specific restitution of property, there are a certain extrajudicial remedies also that is available. So the first one of this is self-defense. So it is lawful for any person to use reasonable force to protect himself or any other person against any unlawful use of force. So if we are talking about a reasonable force here, we saw in the case of battery, we saw in the case of assault, wherein without the person's or the plaintiff's consent, the person is getting into a physical contact in a way which will harm the plaintiff. So in that case, the plaintiff could use self-defense, and this is one of the extrajudicial remedies that the law of tort gives. Next is prevention of trespassing. So an occupier of land or any person with his authority may use reasonable force to prevent trespassers entering or to eject them, but the force should be reasonable for the purpose. So your force should be limited to the extent that you are, removing the person out of your property. Next is re-entry on land. So a person wrongfully disposed of land may retake possession of land if he can do so in a peaceful and a reasonable manner. So if you see here, all of these extrajudicial remedies, there is one word that is commonly used, that is reasonable. So even if you're using self-defense, it has to be of a reasonable amount. Prevention of trespassing, how are you going to prevent? You should be able to do that in a reasonable manner. Again, re-entry on land, if you are taking possession, you need to take it in a reasonable manner. Then we have recaption of goods. So it is neither a crime nor a tort for a person entitled to possession of a chattel to take it either peacefully or by the use of reasonable force from one who has wrongly taken it. So if some person has wrongly taken your goods, then you can use reasonable force to regain the goods and take it back to yourself. And then we have abatement of nuisance. The occupier of land may lawfully abate, that is, terminate by his own act any nuisance injuriously affecting it. Thus, he may cut overhanging branches as spreading roots from his neighbor's trees. So now if there are two houses and the neighbor's house trees branches are coming into this house, then the person may cut it, but there has to be a notice that has to be given, and you have to do it in the least mischievous method and avoiding unnecessary damage. So in the name of branches, you cannot cut the trunk. So if the branches are entering your compound, then that part you can cut. You cannot cut something that is there in the neighbor's compound. So these three things are very important in abatement of nuisance. You have to give a notice, you have to choose the least mischievous method, and you have to avoid unnecessary damage. So why do we say least mischievous method? So that in the shadow of law, nobody does something that is beyond what is required. So that's why in the least mischievous method. And the last one that we have is distress damage reason. So an occupier may lawfully seize any cattle or any chattel which are unlawfully on his land doing damage and detain them until the compensation is paid for the damage. So if there is a land and another person's cattle is coming into the land, then in that case, they will lawfully seize it. They are allowed to lawfully seize it. The right is known as that of distress damage reason, that is to restrain things which are doing damage. So what are you doing? You are not causing damage upfront, but there is something that is causing damage to you and you are avoiding that particular damage. So these are all the judicial and extrajudicial remedies that are available for commission of any tort. So with this, we have come to the end of chapter 2, wherein we saw both Indian Contract Act and the law of torts. So in Indian Contract Act, we understood the meaning of contract, the essentials of a contract, different types of contract. And in tort, we understood the meaning of tort, the different types of tort, the strict liability, vicarious liability. And lastly, we also understood what are the remedies available in case of any tort. Thank you so much for being a part of this class. We will be back with chapter 3 soon. If you have any doubts, any questions, please feel free to drop them in the chat box below. Thank you so much. Hi all, welcome back to another class of CSEET, Legal Aptitude and Logical Reasoning. So in today's class, we will be learning chapter 3, which is the elements of company secretaries legislation. So now that we have understood the basis of our constitution and the law relating to contracts, the next part of this subject is understanding the functions of a company secretary, which is the governing body, what are the rules and regulations that are applicable, what is the scope of work of any CS. So that is something that we will be understanding in this chapter. So to begin with, we need to understand the institute which has established the profession of company secretaries, and that is none other than the ICSI, that is the Institute of Company Secretaries of India. So it is a recognized professional body for CSs in India, and it is established under the Company Secretaries Act 1980. So CS Act 1980 is the act by way of which this particular institute has been established, and it functions under the Ministry of Corporate Affairs, better known as MCA. So the ICSI functions under the MCA, which is a Ministry of the Government of India, and it provides high quality education to over 4 lakh students, and it sets standards for CS members with currently over 50,000 members. So members are basically students who have qualified and obtained their membership number, that is their CS membership, and there are around 4 lakh students studying under this particular institute. It is headquartered in Delhi with 4 regional offices and 70 chapters across India. So chapters are basically bodies established by the institute to help impart the functions of the institute better. It contributes to the government of India initiatives for social and economic growth as well. So ICSI is the founding body by way of which the profession of CS has been recognized. So now let us understand the vision, mission, and core value of ICSI. So what are the guiding principles? The first one is the vision. Vision is to be a global leader in promoting good corporate governance. So when we talk about corporate governance, it is basically how the companies function, how compliant are they with the applicable rules and laws. So the vision of CS is to be a global leader in promoting good corporate governance. Coming to the mission, mission is to develop high caliber professionals facilitating good corporate governance. So vision is like the long-term goal, that is you want to promote good corporate governance. Mission is how you will get there. You will get there by developing high caliber professionals who will facilitate good corporate governance. The motto of the institute is speak the truth, abide by the law. So in Hindi, it is also known as Satyam Vada Dharmam Chara, which means speak the truth and abide by the law. So it is Satyam Vada Dharmam Chara. So this is the Hindi motto, that is speak the truth and abide by the law. And then moving forward, there are certain core values of the ICSI, which is integrity, ethics, reliability, ownership, being stakeholder centric. We will also be understanding these in detail. And these values guide ICSI and its member in their professional behavior and conduct. So we understood the vision, mission, and motto of ICSI. Coming to ICSI vision, yes. So again, to be a global leader in promoting good corporate governance. So the first quality that we're learning about here is integrity, and it represents a commitment to the nation. How is this a commitment to the nation? You are committing and promoting good corporate governance. So this is something that you're committing to your country. So ICSI and CS must deliver this promise with objectivity and integrity. So when we say integrity, it means that there has to be no compromise or middle path. So if there has to be compliance with any particular law, you have to comply with it in its entire sense. There has to be no compromise on that front. The etymology, to understand where this word is derived from, it is derived from the Latin word integer, meaning whole or complete. So it means that there is no middle path, no compromise. It has to be followed in its absolute sense. So this is important. Latin word integer, from this integrity has been derived. It implies personal inner sense of wholeness from character, courage, and consistency. That is, so say for example, there is a situation where the board of directors of the company are insisting on taking the easier route than the compliance route. So in that case, as a CS, it is the responsibility of the CS to maintain integrity and take the compliance route, even though that is the more difficult route. So this is where integrity of a CS comes into picture. The second quality that is required is ethics. So again, to understand the etymology, it is derived from the Greek word ethos. So when we spoke about integrity, it was the Latin word integer. And when we speak about ethics, it is the Greek word ethos. It means character or custom. So it refers to a distinguishing character, moral nature, or guiding beliefs of a person, institution, or a group, that is doing the right thing. Definition in the simplest form is possessing a sense of right or wrong. So if you are ethical, it means that you are right. So here, being ethical also means that not only doing the right thing, but also being able to distinguish between the right and wrong. Consciously, right actions are ethical and wrong actions are unethical. It includes a desire to do good for someone. How is ICSI committed to ethics? It is built on the principle of ethics. Members strive to promote ethical practices, and it is essential for maintaining the quality and reputation of ICSI and its members. So two qualities. First one was integrity. Second one was ethics. Third one, it is being stakeholder centric. So what exactly is a stakeholder? Stakeholders are all parties or individuals that are related to the institute. So it could be your members, it could be your students, your faculty, your authorities. So ICSI is stakeholder centric. Commitment to ethics and values, like we just saw, uphold principle of professional ethics, values, and standards, promote honesty and transparency in behavior, practices, and processes, and stakeholder focus. So stakeholders are the most valued constituency for achieving your goals. It emphasizes on constant stakeholder consultation. That is, say if any new amendment is being taken, any new amendment is being brought into force, then in that case, stakeholder consultation is very important, because stakeholders are the ultimate beneficiaries of this particular law, of this particular amendment. So ICSI believes on consulting the stakeholders, translate stakeholder aspirations into achievable goals, maintain a transparent and stakeholder focused approach, foster a trustworthy and collaborative relationship with the stakeholders. So if you see here, it is not like ICSI wants to be authority in its entirety, but it also wants to consult its stakeholder and promote like a collaborative relationship with the stakeholders. Future endeavors activate new channels and pathways to exceed stakeholder expectations, and it is aimed for sustained performance and growth through stakeholder engagement. So this is how ICSI is stakeholder centric, wherein it not only takes consultation of stakeholder, but also promotes transparency so that the decision making is more informed, and it also fosters a collaborative relationship with the stakeholders. Next up is reliability. Reliability is how reliable is the institute. So it delivers an assurance of quality, service, and commitment. Emphasis on stringent processes for predictability and reliability. So why are we saying that stringent processes are important? Because only when there is a process in place, you will know that that particular action is being performed as per the process that is there in place, and hence it will become all the more reliable. Core value integral to work culture and sustainable growth, commitment to quality and value added services, and continuous improvement to ensure reliable services to the stakeholders. So these are all the founding principles based on which the ICSI is set up. Lastly, we have ownership, wherein ownership is nothing but responsibility, accountability, and empowerment. So if you have taken ownership of any task, of any activity, then you have to be fully responsible for that. And if the activity is not completed, you also have to hold yourself accountable. Goes beyond accepting criticism to setting priorities and obligations, involves always doing the right thing for the stakeholder and public. So whenever we are talking about right things, it is ethics that comes into picture. Values the trust and confidence of stakeholders, commitment to keeping promises and correcting mistakes. So it is not only like doing everything right, but if there are any mistakes, then it is the duty and responsibility to correct those mistakes. Reduces risk, increases efficiency, enhances goodwill, reputation, and brand image. So these are all the characteristics that we focus on as an institute. So we have integrity, ethics being customer centric, reliability, and ownership. So these are the 5 key principles based on which the ICSI is set up. Now coming to a CS. So let's understand how is a CS recognized in the Act and what are the functions and responsibilities of a CS. So CS, like we said, the ICSI is established by the Company Secretaries Act 1980, and this is the act which provides for the definition of a CS. So as per Section 21C, so this is very important to remember. Section 21C, a company secretary means a person who is the member of the Institute of Company Secretaries of India. So when we were understanding about ICSI, we saw there were around 4 lakh plus students and 50,000 plus members. So you will be called a CS if you are a member of the ICSI. So to be called a CS, you need to be a member of the ICSI, and this is as per Section 2, subsection 1, clause C of the CS Act 1980. Yes. So in Companies Act also there is a mention of company secretaries. So Section 2, subsection 24 of the Companies Act states that a CS or a secretary refers to a company secretary as defined in Section 21C of the Company Secretaries Act 1980, who is appointed by a company to perform the functions as mentioned under the Companies Act 2013. So the functions of company secretary is also listed in the Companies Act 2013, which we will be taking up next. So roles and responsibility. So CS is recognized as one of the KMP under the Companies Act 2013. So now if we talk about KMP, who exactly is a KMP? So as per Section 203 of the Companies Act 2013. So these sections are very important to remember. So we saw the definition of a CS in Companies Act in Section 2, subsection 24, and that states that the CS is as defined in Section 2, subsection 1, clause C of CS Act 1980. So also CS is a KMP, and it is a KMP as per Section 203 of the Companies Act 2013. So this section read with Rule 8 of Companies Appointment and Remuneration of Managerial Personnel Rules. So every time in Companies Act, if there is a clause that is vague, if there is a clause that is not defined, that will be defined in the respective rules. And the rule here is the Rule 8 of the Companies Appointment and Remuneration of Managerial Personnel Rules 2014. So it is Rule 8 of Companies Appointment and Remuneration of Managerial Personnel Rules. So again, as per this, every listed company and certain public companies must have a whole-time key managerial person. So when we talk about key managerial person, who forms a part of KMP, it has to be the MD, CEO, manager, and if in case all 3 of these are not there, then in that case, a full-time director, a company secretary, and a chief financial officer. So if you see, there are 6 primary designations that fall under a KMP. So we have MD, CEO, CFO, manager, CS, or a whole-time director. So these are all the KMPs that are defined as per the Companies Act, and Company Secretary also forms a part of that. Now, coming to the functions of the company secretary, what is it that the company secretary is expected to do? So the functions of the CS shall include to report to the board about compliance with various provisions of this act, rules made thereunder, and other applicable laws. So if we are talking about this act, this is as per the Companies Act 2013. Companies Act, the rules that are made thereunder, and any other laws that are applicable to the company, to ensure that the company complies with the applicable secretarial standards. So in addition to the Companies Act, secretarial standards also prescribe the mode of functioning of any given company and to discharge such other prescribed duties. So these are the functions of company secretary as provided for in the Companies Act. In addition to the function, what are certain duties of the CS? So to report to the board about the compliance, this is again a part of the function. To ensure the companies complies with the applicable secretarial standards. So these two are similar to what we saw in the functions. To provide to the directors of the company, collectively and individually, such guidance as they may require with regard to their duties, responsibilities, and powers. To facilitate the convening of meetings, attend board meetings, committee general meetings, and maintain minutes of these meetings. So if any meeting is happening, it is the responsibility of the company secretary to convene this meeting. So three types of meeting that any given company holds. First is board meeting, that is the board of director. Second one is committee meetings. So Companies Act also provides for constitution of certain mandatory committees to applicable companies. So it could be like audit committee, nomination remuneration committee, corporate social responsibility committee. So if any committees are being constituted by a company, then it is the duty of the CS to conduct the meetings of that particular committee. And general meetings. General meetings is nothing but shareholder meetings. So we will also understand that as a part of shareholder meetings, there are two meetings. One is the annual general meeting, and the second one is the extraordinary general meeting. So these three types of meeting, it is the responsibility of the CS to convene this meeting and also maintain minutes. Minutes are basically proceedings. That is what happened in the minutes, whether or not any particular resolution was approved by the board committee or the shareholders. To obtain approvals from the board, general meeting, the government, and such authorities as required under the provisions of the Act. So if you see here, the role and responsibility of CS is not only restricted within the company, but also outside of the companies, any external stakeholders, any authorities, your shareholders. So this way, it is a stakeholder-centric focus, even in the duties of a company secretary. To continue to represent before various regulators and other authorities under the Act in connection with discharge of various duties under the Act. So one of these examples could be your National Company Law Tribunal, wherein if there is any case going on with the company, then the company secretary can be a representative for the company to assess the board in conduct of the affairs of the company, to assist and advise the board in ensuring good corporate governance. So if we saw this, this was a part of the vision of ICSI, and this is something that is the duty of the company secretary to take this forward, and in complying with the corporate governance requirement and best practices, to discharge such other duties as have been specified under the Act, and any duties as may be assigned from board by time to time. So not only what the Act prescribes, but even if the board of directors has specifically outlined the responsibility of CS, then the CS will also have to abide by those duties and responsibilities. Yes. Coming to company secretary in practice. So now there are two types of options available for work under the CS profession. So we have a company secretary in employment and company secretary in practice. So to give a brief overview, company secretary in employment is someone who is employed as a part of any company or a corporate. That is, they will be responsible for the compliance of that particular company only. When it comes to company secretary in practice, this is like a consultation wherein you take up the compliances of multiple companies. You are not appointed in any given company, but you are providing consultation, you are taking up the compliance of multiple companies. So company secretary in practice is a independent setup, a firm type setup, whereas company secretary in employment is somebody who is specifically appointed and they will be a KMP to the board. So employment will be a KMP to the board and company secretary in practice will be more like a consultant. So as per section 2 subsection 25 of the Companies Act. So 2 subsection 24 was CS, 2 subsection 25 was a CS in practice. It means a company secretary who is deemed to be in practice under section 2 subsection 2 of the CS Act 1980. He engages himself in the practice of profession of company secretaries or in relation to any company. They offer to perform services in relation to promotion, forming, incorporation, amalgamation, reorganization, reconstruction, and winding up of companies. Holds himself out as a company secretary in practice. That is, you are not in employment, but you are in practice. That is, you have set up your own individual practice. Renders professional services or assistance with respect to matters of principle or detail relating to practice of CS, and renders such other services as in the opinion of the council or as rendered by the company. So council is there is a council established by the CS Act, and this is the council which is being referred to here. So this is a company secretary in practice where you are publicly declaring that you are in practice and you take up various assignments, especially the ones that are listed down here. Yes, further, it offers to perform such services as may be performed as an authorized representative of company for filing, registering, presenting, attesting, or verifying any documents, a share transfer agent and issue house. So share transfer agent is something that has to be appointed mandatorily by a listed company. Now, this can be in-house or this can be outsourced, and in that case, a CS will be available here. An issue house, a share and a stockbroker, a secretarial auditor or a consultant, an advisor to the company on management, including any legal or procedural matters, and issuing certificates on or behalf for the purposes of any given company. Now, a CS in practice have also been authorized by government as well as regulatory bodies, including RBI, SEBI, NCLT, NCLAT. This is nothing but the National Company Law Tribunal and National Company Law Appellate Tribunal, IRDA, Competition Commission of India, Real Estate Regulatory Authority of India, and stock exchanges. And it can act as an authorized representative and issue various certifications and undertake secretarial audit of bigger companies. So it is not only the CS Act 1980 and the Companies Act 2013 that recognizes the profession of a company secretary in practice, but various other laws and governing bodies which also recognize the functions of a CS. Now, as a part of this chapter, so far we understood what is the ICSI, which is the act that brought this particular profession in place. What is a CS? If there is a CS that is appointed, they'll be considered as a KNP. And then we saw about the company secretaries in practice. So as a part of the next part of the chapter, we will be understanding the various fields in which CS can render their services. So let's begin with the first one, that is corporate governance and secretarial services. So this is the foundation on which the profession of CS lies, that is corporate governance and secretarial services. So advising on good corporate governance practices and compliance of norms as prescribed under various corporate securities and other business laws, regulations, and any guidelines that are made thereunder. When we talk about corporate secretarial services, so promotion, formation, or incorporation of companies, filing, registering any documents as an authorized representative, maintenance of secretarial records, books, and registers, arranging board or general meetings and preparing the minutes thereof, and all work relating to shares, their transfer, and their transmission. So transfer is when the share is being transferred from one person to one member to another person. And transmission is in case of death of any member, then the share will automatically transfer to the legal heir. So these are like a few examples of services that as a part of the corporate secretarial function that a CS has to undertake. Yes, coming to secretarial audit. So just like how we have statutory audit, we also have a secretarial audit wherein a PCS, that is a practicing company secretary, will be appointed as a secretarial auditor who will perform a check of the secretarial functions and issue a secretarial audit report. So let's get into the specifics. So this is applicable to every listed company, every public company with paid up share capital of rupees 50 crore or more, or turnover of rupees 250 crore or more, and outstanding loans or borrowings from public banks and financial institutions of rupees 100 crores or more. So these are exclusively for public companies. So here, listed company, irrespective of these thresholds, they have to mandatorily undertake secretarial audit. And in case of public company, paid up share capital 50 crore or more, turnover 250 crore, borrowings 100 crore or more. One important factor to understand that this is or, which means that if any one of these conditions are also met, then in that case, secretarial audit becomes mandatory. So secretarial audit report. So the requirement is given in section 134 of Companies Act 2013, which says that the company must annex a secretarial audit report along with the board report. It has to be prepared by a company secretary in practice or a PCS, and the prescribed form is form number MR3. So this is very important. So whenever we are talking about secretarial audit, we need to understand the limits. We need to understand that it is a requirement as per section 134 subsection 3, and the form in which this will be issued is MR3. So secretarial audit, again, this is a very important scope because only company secretaries in practice can perform secretarial audit, not CS in employment. So what are the duties of the company? So if any audit is being undertaken, then it is the duty of the company to provide all necessary assistance and facilities to the CS for auditing the secretarial and related records, which means that if any audit is happening, you will have to produce all your records, and it is your duty as a company to provide all these documents to the CS. Then in their report, the board of directors must fully explain any qualification, observation, or remarks made by the PCS. So as a part of the MR3, if there are any observations, then the board will have to give a justification for them or explanation for them in their board's report. And if this section is not complied with, then in that case, the company or any officer, or if the CS in practice as well, if they contravene the provision of this section, they are punishable with a fine which is not less than 1 lakh rupees and go up to rupees 5 lakh. So again, this is an important amount to remember. That is, if either as a company you are not extending assistance, or as a board you are not mentioning the explanation for qualification, or as a CS you are not following the norms, then in that case a fine of rupees 1 lakh to 5 lakh will be levied. Yes, so the next field. So we saw corporate governance, we saw secretarial practices. The next one is corporate laws, advisory and representation. So advising the companies on compliance of legal and procedural aspects particularly. So these are like a list of acts wherein the CS can provide their advice. The SEBI Act 1992, SCRA, that is Security Contract Regulation Act, and any rules and regulations made thereunder. Insolvency and Bankruptcy Code 2016. So this deals with basically your insolvency resolution process, your liquidation of the company, winding up. Foreign Exchange Management Act, Consumer Protection Act, the Depositories Act, Environment Pollution Control Laws, Labor Industrial Laws, and Cooperative Societies Act. So not only, so the functions of the company secretary is not only restricted to the Companies Act 2013, but these are certain additional acts wherein there is scope for work of a CS. Then further fields wherein a CS can contribute and provide their consultations: mergers, amalgamations, that is M&As and strategic alliances, foreign collaboration and joint ventures, setting up subsidiaries abroad, competition laws, IPR protection, management valuation and audit, Real Estate Regulation and Development Act, Arbitration Conciliation Act, and drafting of legal documents. So these are also areas wherein the scope of CS is very high. So we were also saying how company secretaries can act as a representative before various authorities. So what are these authorities? Those have been listed down here. So ROC or the RD, so this is as a part of the Companies Act 2013 that this authority has been established. The National Company Law Tribunal, this is nothing but NCLT, and we also have the NCLAT, that is the Appellate Tribunal. Competition Commission of India, so this is established as a part of the Competition Act. Securities Appellate Tribunal established by the power of SEBI. Consumer Forum, so there will be a district forum, state forum, national forum. So you can, a company secretary can represent any corporation or any case before these forums. Telecom Dispute Settlement and Appellate Tribunal, Trademark Authority, SEZ authorities, tax authorities, and any other quasi-judicial bodies and tribunals. So these are like a representative list of where a CS can represent the company or can represent any given case. Next, arbitration and conciliation services. So arbitration and conciliation basically encourages a friendly or amicable settlement between parties instead of going to the court of law. So a person who is independent of both the parties will be appointed as an arbitrator. So this is something that we had understood in the first chapter as well, wherein we saw that arbitration and conciliation. So conciliation is a settlement in a better friendly manner. So CS can perform these services. So acting as an arbitrator or conciliator in domestic and international commercial disputes, advising on arbitration, negotiation, and conciliation in commercial disputes between the parties and the agreement or the clause. Then moving on, the next one is the financial market services. So when it comes to financial market services, what is it that the CS can do? Public issue listing and securities management, advisor or consultant in issue of security. So whenever any company is going for issue of the security, say they are going for an IPO, then advice or consultation of a CS can be taken. Preparation of project reports and feasibility studies, syndication of loans from banks and financial institutions, drafting of prospectus, offer of sale, letter of offer, other documents. So we saw that how legal documentation also is a strong forte of the company secretary. So they can also contribute here. Loan documentation, registration of charges, status and search reports, listing of securities, delisting of securities. So listing is for the first time if you're going for an IPO, that is from a public company, you are going listed. Delisting is if you have already listed and you want to delist your securities, that is you do not want your securities to be listed any longer on any stock exchange. Private placement and other securities. So private placement is basically issue of shares to a select group of people. So this is mostly taken up by private companies, also practiced in public and listed companies, but primarily for private companies wherein it is not to the public at large, but to a specific set of people who are already identified. Buyback of shares and other securities. So buyback is basically buying back of shares from the shareholders. And lastly, raising of funds from international markets such as ADR, GDR, and ECB. So these are nothing but securities that are issued either in the denomination of any foreign country or in the markets of a foreign country. Takeover code and insider trading. So takeover code is nothing but the SEBI substantial acquisition of securities code. So this is nothing but the SAS code 2011, wherein if you are taking over any company, if you are acquiring any company, then takeover code has to be followed. And next up is insider trading. So insider is basically a person who has access to like price sensitive information. So if I am a part of the board of the company, then I will have access to all the price sensitive information. And with this price sensitive information, I should not be trading in the securities of my company because the public does not have the information. I have the information. So I am an insider. So for this, there is a SEBI prohibition of insider trading regulations, which regulates how trading will take place in case any individual is in possession of the unpublished price sensitive information. Securities compliance and certification services. So compliance with rules and regulations for internal audit of depository participant, certification under any SEBI regulation, audit in relation to reconciliation of shares, certificate in respect of compliance of private and unlisted public company, certification of annual returns. Annual return is nothing but a form that is filed by the company, that is MGT 7. So certification of annual return will be given by the company secretary in form MGT 8. That is, it satisfies all the compliances are up to date. Quarterly share capital reconciliation certificate under SEBI DP regulations, certification under IFSCA regulations, due diligence report and certification under delisting. So there are various acts under which the company secretaries can issue certificates wherein they will certify the contents of the certificate and also provide for their signature wherein they will be liable in case the content of the certification is wrong. Next. Finance and accounting services. So it is not only related and restricted to compliance, but also finance and accounting in terms of internal audit, secretary to the audit committee, working capital liquidity management, determination of an appropriate capital structure, because the CS is well aware of the implications of the different types of capital, be it equity, be it debt, be it preference, analysis of capital investment proposals, business valuation prior to merger and acquisition, loan syndication, budgetary controls, and accounting and compilation of financial statements. So wherever in any company, a CS is appointed. So in addition to the board of directors, so two directors, of which one has to be managing director, and if there is a CS in place, it is their responsibility to sign the financial statement. So CS also signs the financial statements, and that is why a understanding of the financials of the company is very important, and hence this is also a service which the CS can render. Next, coming to taxation services, advisory services to companies on tax management and tax planning under the income tax, GST, and custom law. So, if you see even the course of company secretary, so as a part of your next level, that is your executive and professional, tax is a prominent subject, and the reason being that in addition to advisory on compliance matters, if the company secretary also wants to take up taxation as their area of practice, then they will be well aware about it even before they start their practice. So that's why taxation forms a part of our curriculum and the course syllabus as well. Preparing and reviewing various returns and reports required for compliance with tax laws, representing companies and other persons before the tax authorities and tribunals. Then, next one is international trade and WTO services. So this is a trademark organization wherein advising on all matters related to IPR and the TRIPS agreement. IPR is basically intellectual property rights, and intellectual property are like intangible property that any given person or a company holds. So this includes your trademark, that is how your company is being, like we all know Coca-Cola is a trademark company, Pepsi is a trademark, and then any copyrights or any patents. So in all of these matters, company secretary can be an advisory body. Then advising on matters related to anti-dumping subsidies and countervailing duties, international commercial arbitration, advising on and issuing certificate on FTP and the related procedures, advising on intellectual property licensing and drafting of the agreement, and acting as a registered trademark agent. So within the IPR, there is a lot of scope, that is many areas in which a CS can practice. Next, coming to management services. So company secretaries not only have the responsibility of like compliance and advisory, but also management. So it can be advising on the legal structure, business policy strategy, formulating the organizational structure, and acting as a management representative to obtain ISO certification. So ISO certificates are basically certificates provided wherein the procedures of the company are as per the standard. So depending on what procedure are you getting it certified, you will get a ISO certified number. Corporate communication and public relation. So like we were saying, the responsibility of company secretary is not only limited to within the company, the board, but there is also a lot of communication with your shareholders or members, stakeholders, government, regulators, authorities, etc. So communication is a very, very important skill that any CS should develop. Advisory services for brand equity and image building. Then we have human resource management, wherein we talk about manpower planning and development, audit of the HR function, performance appraisal, motivation and remuneration strategies, industrial relations, office management, work studies and performance standards, and also advising on industrial and labor laws. And a last field that we will discuss about here is the IT field, that is compliance with cyber laws. So with the increasing use of information technology, with the increasing use of digitization, a lot of threat has come into place, especially from a cyber security point of view, and hence a lot of laws are also there in picture, which impose stringent measures to maintain compliance with the security and cyber laws, and it is the duty of the CS to abide by these laws. Conducting board meetings through video conferencing and teleconferencing. So as per the Companies Act 2013, it is an option to conduct the board meeting through other audiovisual means. So audiovisual means is something that the Companies Act provides, and it is a duty of the CS to conduct these meetings. That is to ensure that all the logistics are available, that no person has access to the meeting apart from the board of directors, so on and so forth. Advising on software copyright and licensing, development of management reports and controls, maintenance of statutory records in electronic form. So again, as per section 120 of the Companies Act provides for an option wherein all the records that have to be maintained by the company can be maintained electronically, subject to compliance with the act and the rules. sending notices to shareholders by electronic mode, and filing of forms, documents in electronic form with the ROC and statutory authority. So if you see here, IT has also gained a lot of prominence, and this is a field in which the work of CS is constantly increasing. So this was it with the chapter of the elements of the company secretary's legislations, wherein we saw about the foundation and setting up of the ICSI, company secretary and his function, company secretary in practice, who are the companies that are required to appoint a KMP or a company secretary, and then secretarial audit. And we saw the various fields in which CS can practice and provide their consultation on. So that's it with this chapter. Thank you so much for being a part of this class. If there are any doubts, any questions, any suggestions, please feel to drop them in the comment section below. Thank you so much. Hi all, welcome back to another class of CSEET Legal Aptitude and Logical Reasoning. So in today's class, we will be understanding chapter 4, which is one of the most important chapters, not only for this subject, but for any given CS student, because this is the foundation based on which we will be understanding the further subjects. So the the topic that we have today is elements of company law. So company law or the Companies Act is the primary governing foundation for any given company, which describes about the structure of the company, formation, how it is supposed to be functioning. So without further ado, let's begin. So firstly, let's understand what is the origin of the word company. So it is basically from a Latin word cum, which means with or together, and panis, which means bread. So it is basically coming together to earn bread or even dine together. So now, as per the modern definition, it refers to a joint stock enterprise where capital is contributed by many individuals. A company denotes an association of like-minded individuals for business purposes. So there have to be like-minded individuals to make sure that everybody is thinking about the same business in the same manner and for the same purpose. Corporate body. So company is a corporate body with a distinct legal personality separate from its members. So why do we emphasize on distinct legal personality? Is that although company is formed by its members, it has a own personality that it is legally separate from that of its members. Body corporate signifies the legal incorporation and personality. So one thing that we need to remember here is that it is a corporate body. Next is corporation. So corporation is derived from the Latin word corpus, which means body. So now we had company, which was derived from cum plus panis. And then we have corporation, which is corpus. So both are Latin words itself. A legal person created through incorporation is also known as artificial legal person. So now we all know that a company cannot be a natural person, but if we need to give it a separate legal identity, then in that case, we need to call it an artificial legal person. Capable of holding rights and liabilities similar to that of a natural person. It is not the same, but similar to a natural person. Now, legal definition. So under section 2, subsection 20 of the Companies Act, a company is incorporated under this act or any other previous companies law. So when we talk about this act, it is the Companies Act 2013. So why are we saying any other previous laws? Because 2013 is not the first company law that has come into existence. There have been other company laws prior to 2013. So it is not required that only those will be called a company which have been incorporated under Companies Act 2013. Prior to that also, the companies that have been incorporated under company law will be classified as a company as per section 2, subsection 20 of the Companies Act. It is a legal entity separate from its member, capable of existing beyond their lives. So here, just a very basic example. So we will be studying further that to form a company, at least 2 members are required, a private company. So now if one of the member dies, it does not mean that the company along with it also dies. So it is capable of existing beyond lives. However, in case of a partnership firm, what we would have understood that if there are 2 partners and one of the partner dies, then the partnership is going to dissolve because the partnership firm does not have its separate legal entity, but company does. Non-profit associations. So certain companies can acquire corporate status under Section 8 of the Companies Act. So Section 8 talks about not-for-profit companies. So it says that you can establish a company without the objective of earning profit. And if you are doing so, it will be covered under Section 8 of the Companies Act 2013. So now, understanding the nature of a company is basically a legal device for achieving social or economic objectives. So we can talk about social as not-for-profit companies, and economic objectives are all the other types of companies. Combined political, social, economic, and legal institution. It is described as a mean of cooperation and organization in the business. So Lord Justice James definition, an association where many contribute money or value to a common stock. So basically there will be one purpose for which all of these people will be working. It engages in trade or business and shares profits and losses. Now, capital is denoted in money and members own shares proportional to their contribution. So basically, capital is like the initial money that with which you start your company, and members will be the one contributing to that capital. So what are certain features of the company? Separate corporate and legal personality, that is, it exists beyond its members and it is a distinct person. Centralized economic and administrative structure managed by professionals. So company basically are governed by none other than their board of directors, who will be a board of qualified individuals capable of running the company. Legal entity capable of owning property, suing, and also being sued. So company in its own capacity can own property. That is, any property can be in the name of a company. The company can sue and the company can also be sued in the court of law. Yes. So now, talking about the corporate personality of the company. So this is in continuation of what we've been discussing so far. So it is, like we said, it is a distinct legal entity. Upon incorporation, a company gains a corporate personality separate from its members. This is very important that it does not share its personality with its members. It has a separate corporate or legal personality. It operates under a corporate name and has its own seal. So it operates under a corporate name and has its own seal. So there will be at the end of the name of the company, there could be private limited or limited. So say, for example, if we are talking about Reliance, then the name of the company is Reliance Industries Limited, which means that it operates under the name of Reliance Industries Limited. Its assets are distinct from those of its members. So, like in case of, say, a partnership firm, if the assets of the partnership firm are insufficient, then the partner becomes personally liable. But in case of company, there is a clear demarcation between the assets of the company and the assets of its members. Next, legal capacities. A company can own property, incur debt, borrow money, have a bank account, employ people, enter into contracts, sue and be sued. Members are not liable for Companies Act. They are not agents of the company. So when we are talking about the partnership firm, all the partners would be liable for each other's actions. But in case of a company, it is very distinct. That is, whatever has been done in the capacity of the company will be liable for it. The members can never be directly liable for it. And a company is considered a juristic person with rights and obligations. So this way, why are we understanding so much about why a company is a corporate legal person? Because based on this premise itself, there are a lot of provisions in the Companies Act based on how a company is supposed to follow, what are the responsibilities of the board of directors, and how exactly we'll also be understanding how exactly company form of a structure is different from the other forms that we have seen, like our limited liability partnership, a partnership, Hindu undivided family. We'll also be understanding all of those. Yes. So now there is a landmark case of Salomon versus Salomon and Company Limited case, wherein it was established that company is a legal entity, and it was illustrated by Salomon forming a company, selling his business to it, and the company running into difficulties without affecting Salomon personally. So here, if you see, Salomon is the member here and it is the company here. So it is not the same person. So here it is Salomon in the capacity of the member, and here it is Salomon and Co Limited in the capacity of a company. So although the company ran into losses, Salomon will not be affected personally. Then we have Lee versus Lee's Air Farming Limited case, wherein Lee formed a company, appointed himself as a managing director and the chief pilot. Upon his death, his widow claimed compensation, and it was held that Lee and his company were distinct entities. The Privy Council ruled that Lee was both an employer and an employee, highlighting the separate legal personality of the company. So although it was Lee's company itself, we need to understand that Lee is entirely different from Lee Air Farming Limited. Then RE Kondoli Tea Limited case. So it recognized the principle of a company separate legal entity, and the Calcutta High Court rejected the claim that a transfer property to a company by its shareholder was not a conveyance, affirming the company's separate entity. So here in all of these three cases, what fact is being emphasized on is that company is separate from its members, even though it is being set up by its members. That is, company has a separate legal personality. Now, coming to limited liability. So when we talk about limited liability, this is one of the main advantages of setting up of company. That is, let us understand again with the example of a partnership firm. So in case of partnership firm, we were discussing that if the assets of the partnership firm are not sufficient, then in that case, a partner will become personally liable. That is, they will have to bring in their assets as well. But in case of a limited liability partnership, limited liability company, what happens is that the members will be liable only to the extent of the share capital that has been contributed by them. Members can never be personally liable in case of a company. So let us have a look at this. Privilege of limited liability. Limited liability for business debts is a major benefit of operating as a corporation. Company as a separate legal entity owns its assets and is responsible for its liabilities. Shareholders' liability is limited to the unpaid value of the shares. So say, for example, if I am a shareholder of a company and I have agreed to give a total contribution of rupees 1 lakh, of which I have already made a payment for 60,000 and 40,000 is balance. So in this case, I will be liable only to the extent of this. That is because 60,000 I have already paid, I am no longer liable, but 40,000 is remaining to be paid. Then that is the only liability that I will have. Say the company goes into losses and it says that instead of 40,000, please give us 60,000. That is not possible because as per the act, there is a limited liability on the part of the members. Next is shareholder liabilities. Shareholders are only liable to contribute to the company's assets up to the nominal value of unpaid shares. So here, this unpaid shares. Even if the company's liabilities exceed its assets, shareholders' liability does not extend beyond this unpaid amount. So if there is no unpaid amount, then the shareholders' liability stops there. Example, if A holds shares worth 1,000 and has paid 500, A cannot be asked to be paid anything more than 500. So whatever is remaining only can be asked out of A. Next, fully paid up shares. Shareholders with fully paid up shares have no further liability even if the company becomes insolvent. So like we were discussing, if this 40,000 is also paid off, then there will be no liability that exists on the part of the shareholder. And this is even if the company goes insolvent. Yes. So now company limited by guarantee. So here in company limited by guarantee. So when we are talking about share capital, it is a company limited by shares. In case of a company limited by a guarantee, it will not be to the extent of the unpaid amount of share capital, but it will be any amount that is guaranteed by the shareholder. And this liability will be mentioned in the memorandum. So memorandum is a founding document of the company. Fully it is known as the Memorandum of Association. Memorandum of Association, often known as the MOA, wherein all the clauses which are important. So what will be the capital of the company? What is the name of the company? What is the object for which the company has been set up? Where is the registered office of the company? All of this will be mentioned in the MOA. So again, if there is a company limited by guarantee, then the amount till which you are giving the guarantee will be mentioned in the MOA. Now, statutory exceptions. Under the Companies Act 2013, members may become personally liable if the membership fall below the minimum prescribed number and the business continues for more than 6 months thereafter. So here in a case, so again, we'll be understanding two types of companies going forward. So we have private companies and then we have public companies. So the basic criteria for a private company is that there should be at least 2 members. And in case of public company, there should be 7 members. So at any given point of time, if the number, say in private company, there's only 1 member that is remaining, and in public company, there are only 5. And in spite of knowing that this is not the minimum requirement, if you continue your business for 6 months or more, then all of these people will become personally liable. So when is the personal liability applicable? That is, if the minimum number of members has gone below the required number and still you have continued the business within 6 months. So the members falling below the criteria is below the category is not the criteria. Below the category and continuing business for 6 months is the criteria. So having a look at the historical perspective, Buckley J highlighted the impact of limited liability statuses on commercial prosperity and public utility and aggregation of capital. So limited liability encourages the pooling of small investment into large capital, benefiting investors and public and contributing to the country's wealth. So what happens is shareholders will have maybe like small amounts that they would be willing to invest. So they could invest this amount, and all of these small amounts from shareholders can act as a pool wherein the company accumulates it and it forms a capital of the company in its totality. Now, coming to the concept of perpetual succession. So if we know the meaning of perpetual succession, it is something that goes on forever. So company itself is something that goes on forever. That is, it is not affected by the status of its members. So an incorporated company does not die except when wound up legally. So wound up is basically closing the company, and there is a separate provision for this. So these are all provided for in the Insolvency and Bankruptcy Code 2016 and the Companies Act 2013. The company remains unaffected by the death or departure of any member. So just because a member is leaving the company, that is, it is surrendering its shares or selling or transferring its shares, or if the member has died, it doesn't mean that the company is also going to die. The company is going to continue the operation the same way as it did earlier. It remains the same legal entity despite the changes in membership. So this is something that we need to remember. Life of the company, it is determined by its memorandum of association, can be perpetual, that is, there can be no fixed time as such, or for a specified duration to achieve certain objectives. So certain companies are set up. So say, for example, take up any real estate company. So a real estate company is set up to work on a project, and that project is completed and it is being handed over to someone else. So in that case, this company that was set up for creating that building can be closed. So in that case, for a specified duration to achieve certain objectives. Now, membership can change due to transfer of shares. So basically, if A and B are members of the company and A has transferred his shares to me, so it means that B and I become the members of the company. A is no longer the member. So there has been a change in membership. And then shares devolving on legal representative upon a member's death. So what happens is there will be nominees that will be appointed. That is, if any member dies, who is the person who will be receiving that member shares? So in that case, it will go to the legal representative. And then there are quite a few other. So this is nothing but transmission. The term that is used for this is transmission, and the term here is transfer. And there are other provisions in the Companies Act as well, such as surrender of shares, reduction of share capital, so because of which membership can change. Now, perpetual succession. What is the nature of it? It ensures companies' existence through constant succession of new members. New individuals replace those who cease to be members, and companies' continuity is maintained regardless of change in membership. So this is the whole rationale behind perpetual succession. So now, Professor LCB Grover's example, during the war, all the members of the private company were killed in the meeting, but the company survived. So this is an example that we were similarly discussing earlier. That is, even though all the members die, company will not die, company will continue. It emphasizes that even in extreme events, it cannot be, company's legal existence cannot be destroyed. That is, if you see here, this is again a very famous example, Professor LCB Gover, which says that even though all members of a private company died, the company continued to exist. Next, separate property. So like we were saying, company is a distinctive legal person who is capable of owning his own property, its own property. So a company is a legal person distinct from its members. It is capable of owning, enjoying, and disposing of property in its own name. The company is the real person in which all its property is vested, controlled, managed, and disposed of. So it is not held in the name of the members or the directors. It is held in the name of the company itself. Now, members cannot claim ownership of the company's property during its existing or winding up, because this property belongs to the company and not members, although they hold shares in the company. Members do not have an insurable interest in the property of the company. Next feature of a company is the transferability of shares. So we were talking about how membership can change if the shares are being transferred. So here there is a similar example. So capital of a company is divided into parts called shares. So say for example, if we have a capital of rupees 1 lakh and I am saying there are 10,000 shares of rupees 10 each. So this is the share capital of the company. These are the number of shares and this is the value of each share. Shares are movable property and subject to conditions, freely transferable. No shareholder is permanently or necessarily wedded to a company. They can have an option to exit at any time. The objective of joint stock company was easy transferability of shares. Now, Companies Act 2013 provides that shares are movable property and can be transferred as per the articles. So just like how we had the MOA or the Memorandum of Association, we also have the Articles of Association. So Article of Association is also a governing document for the company. So what happens is that in memorandum, there are 6 clauses that are fixed by the Companies Act. In addition to that, if there are any clauses, that will come under the Articles of Association. Next, a member can sell shares in the open market and realize the investment. This provides liquidity to the member and stability to the company. So the member is also not bound to hold shares for a long period of time unless he actually wants, and stability of the company. That is, the company will also have funds available at all the times. Stock exchanges provide facilities for sale and purchase of shares. So they will provide facility if the company is listed on any one of the stock exchanges. Shares in most listed companies are transferable through electronic mode via depository participants. So there is this process which is known as dematerialization. Dematerialization, through which your physical shares are converted into electronic shares, and these depository participants are the one that will be keeping a track of it. So the next feature of the company is the capacity to sue and be sued. So a company being a body corporate can sue and be sued in its own name because it is a separate legal person. Legal proceedings against the company are to be instituted in its own name, that is in the company's name and not the member's name. Now, a company may bring an action against anyone in its own name. A company's right to sue arises when some loss is caused to the company. So the company is entitled to sue for damages even in libel or slander. So like we were discussing, this is a case of defamation. That is what we saw in the law of torts. Next, a company may sue one of its own members for libel because company and the members are separate persons. Company has a right to seek damages where defamatory material affects its business. So video cassettes prepared by workmen showing their struggle against the management are not actionable unless defamatory. So here what happens is there were video cassettes that the workmen had shown, but once it started proving to be causing a lot of loss, that is when it becomes defamatory. Now, contractual rights. A company as a separate legal entity can enter into contract in its own name. A shareholder cannot enforce a contract made by the company. He is neither a party to the contract nor entitled to the benefits. So say, for example, a company is entering into a contract with a partnership firm or any other company. Then in that case, the contract will be between those two companies. It will not be between the member of this company and the member of that company. Company is not a trustee for its shareholders. A shareholder cannot be sued on contracts made by the company. So just as how benefits of the company cannot be reaped by the shareholders, similarly, liabilities of the company cannot be taken up by the shareholders. The distinction between a company and its members permeate the whole law of contract. So if a director fails to disclose a breach of duties and a shareholder enters a contract due to non-disclosure, the shareholder cannot resign the contract. So now there are two parties that we need to understand here. So first is the directors who are responsible for management of the company, and the shareholders who are the owners of the company. So shareholders will be contributing to the capital, whereas directors will be the one who will be taking up the day-to-day functioning and management of the company. A member of the company cannot sue for torts committed against the company. It will be the company only who has to sue. A member cannot be sued for torts committed by the company. So it will be only the company that can be sued. Next. Limitation of action. A company cannot exceed the power stated in its memorandum of association. So, say for example, if you are saying the company is established to trade in securities, then you cannot use the company to say build a project, build a residential project. So, you will have to stick to trading in securities itself. So, the power will be stated in the MOA, and you have to limit yourself to that. The MOA regulates the powers and fixes the objects of the company. It provides the foundation upon which the company's entire structure rests. The company's actions and objects are limited within the scope of its MOA. To enable unrestricted actions, sufficient powers are usually granted. So it is not like MOA is to provide a restriction on the company, but it is to provide like a framework and the structure of how the company is going to be functioning. Now, the company cannot exceed these powers unless the MOA is altered beforehand. So, say for example, in addition to dealing with securities, the company also wants into getting a business of providing loans to those in need. Then, in that case, they'll have to alter the MOA, include providing of a loans as an object, and then proceed with it. Now, separate management. So, like I was saying, directors will be the one who will be taking care of the company. So, they are the management. So, members may derive profits without being burdened with the company's management. That is, so basically, this means that management and members are separate. So it is not like just because I am a member, I am also entrusted with the management of the company. No, there are separate board of directors available who will be working with that. Now, members do not have effective and intimate control over the company's working. It is the directors who will have that. Next, members elect their representative to conduct corporate functioning. The company is administered and managed by its managerial personnel. So this could be your directors, your CEO, your CFO, your CS, so on and so forth. Voluntary association for profit. A company is a voluntary association of profit which is formed for the accomplishment of public goals. So this is a company that can be set up under Section 8 of the Companies Act 2013. That is, so usually companies are set up with an object to earn certain amount of profit. But in case it is not for profit, then in that case, you can register yourself as a Section 8 company, which is basically a not-for-profit company. Profits are divided among the shareholders or restored for future expansion. Only a Section 8 company can be formed with a no-profit motive. Then, how does a company terminate? So now, so far what we have understood, so we understood what exactly is a company, how did the term origin, and then we had a look at all the features of the company. So we understood perpetual succession, distinct legal entity, capacity to sue, capacity to own a property, and right to enter into the contract. So these are all the features of the company that we need to understand so that we are able to understand all the provisions also that the Companies Act has stated. So now, so far we were talking about how a company is formed. So now, when will a company terminate? We know it won't terminate when the members change or maybe due to members' death. So what is it that will give termination to the company? Company does not die a natural death. It is created by law and carries on its affairs according to law. Effaced by law generally through winding up. So we were discussing earlier as well, that is winding up is the procedure through which a company closes. To avoid winding up, companies may undergo reorganization, reconstruction, and amalgamation. So when would a company probably wind up? Firstly, when its objects are satisfied, that is if it is open for a specified duration. Secondly, if it is not earning enough profit, it is continuous losses. So instead of actually resorting to winding up, maybe the company could consider reorganization, reconstruction, and amalgamation as well. Now, company is a voluntary association for profit. So now let's summarize everything that we have learned to this one definition. Company is a voluntary association for profit with capital divisible into transferable shares with limited liability, corporate entity, and having perpetual succession. So this definition covers all the features of the company. So now, we were talking about termination. So let's also talk about nationality and residence of a company. So company cannot be a citizen. It can be only a natural person that can be a citizen. So company is an artificial legal person and hence it cannot be a citizen. However, it does have nationality, domicile, and residence. So in this case of GASC versus Inland Revenue Commissioners, it was established that the company's domicile is a place of its place of registration. So say for example, if there is any company, say Infosys Limited, it is registered in Bangalore. So Infosys domicile status will be Bangalore. Company's residence is where its place of incorporation is, where meetings are held, and where its governing body meets. Company is not a citizen under the Citizenship Act 1955 or even the Constitution of India. In State Trading Corporation, it was held that a company is not a citizen but can act through natural persons. And that's exactly what it does. That is, it acts through its board of directors. Certain fundamental rights like the right to equality, Article 14 are available to companies. So as we all know, Article 14 uses the word person and not citizen. So if it would have used the word citizen, it would have not been applicable to the company since the company cannot be a citizen. Now, so again, we are coming back to the concept of corporate personality, wherein even though it has distinct personality, it is an association of persons who are the beneficial owners of its property. A company, being an artificial person, acts only through natural person. Now, lifting off or piercing through the corporate wheel. Corporate wheel is basically the wheel that separates the company from its shareholders. But however, in this case, there are certain cases where this corporate wheel can be lifted. So what happens? This occurs when separate legal entity is misused for fraudulent or dishonest purposes. So now we were seeing that shareholders cannot be held liable for the acts of the company unless, except to the extent of the unpaid amount of the nominal value. However, what happens is that certain shareholders misuse this and conduct fraudulent activities in the name of the company. So ultimately, what will happen? It will be the company whose name will be sued, not the shareholders. So in this case, the corporate wheel may be lifted by the court of law. That is, in this case, the company and shareholders will be considered as one person because the shareholder made misuse of the fact that company is a separate legal entity. So courts may pierce through the corporate wheel to hold individuals or controlling persons accountable for the company's debt. Corporate wheel is lifted if an entity uses its corporate personality to evade tax or any other liabilities. Shareholders cannot seek to lift corporate wheel for their purposes. In Premlata Bhatia versus Union of India, a shareholder's attempt to argue that she and her company were essentially the same person was rejected. So the premise still stands strong that company and the shareholder are two separate persons. But in case it is being used for fraudulent purposes, then the wheel will be lifted and there will be no bifurcation between the two. Now, reluctance to lift the wheel, courts are generally cautious about lifting the corporate wheel. So unless absolutely necessary, courts do not lift the corporate wheel. Now, what are the situations in which the corporate wheel is lifted? So firstly, fraud or improper conduct, that is the shareholders or the directors are conducting activities in a fraudulent manner. Agency instrumentality, when the company is merely an agency or instrumentality, that is, it is representing someone else and it is only established as a company for the sake of representing that person. Public policy, when the doctrine of separate personality conflicts with public policy. If there is anything that the company does which is against public policy, then in that case, the wheel can be lifted. Enemy character. So in Daimler Co. Limited versus Continental Tire, a company controlled by individuals from an enemy country was regarded as having an enemy character. So this is in case of any war or rivalry between countries. Then in that case, there will be enemy character of the company. And in that case, corporate wheel can be lifted. Tax evasion, where a company is formed solely to evade taxes, making individual liable for the taxes they would have otherwise paid. So what happens is, if I am earning a lot of amount and I do not want to pay tax to it, I set up separate companies, transfer all this amount to that company. So for me, my liability to pay tax will be reduced. So if you see here, these companies that I have transferred my money to are formed solely for the purpose of evading tax, and hence it cannot be right, and corporate wheel can be lifted and I can be held liable. Welfare legislation avoidance, when a company is used to avoid welfare legislation such as reducing bonuses to workmen. So in this case, this is not a lawful object. This is something that causes disregard to say like a workman, and hence the corporate wheel can be lifted. Unjust or inequitable purpose, when a company abuses its corporate personality for unjust, inequal or public interest purposes. So here, Companies Act provides that it is a separate legal entity, but in cases where it is absolutely required, lifting or piercing of corporate veil will be done to understand who is the person actually behind all of these activities that the company is doing. Now, so like we were saying, discussing that how companies are different from the other business enterprises, let's have a look at that. So though there are a number of similarities between limited company and other forms of association, there are a great number of dissimilarities as well. In both the cases, individuals are subjects and trading is generally the object. In the following paragraphs or the following slides, a limited company is distinguished from a partnership firm, Hindu joint family business, and a registered society. So first we have the difference between company and a partnership firm. Company is a distinct legal person from whom? From its members. And partnership is not distinctive from the individuals who compose it, that is nothing but partners. Then property belongs to the company, property belongs to the individual. Creditors can proceed only against the company. Creditors can proceed against the firm as well as individual partners. Members are not agents of the company. Partners are agents of the firm. Members can contract with the company, that is member and its own company, but partners cannot contract with the firm. Shares ordinarily can be transferred, but partner shares cannot be transferred without the consent of the remaining partners. Restrictions in the articles are effective for outsiders. Restrictions in partnership contract do not bind outsiders. Liability may be limited by shares or guarantee. Liability is always limited. That is, the partners are also personally liable. Partners are personally liable. Perpetual succession, death or insolvency. So perpetual succession is that no matter what happens to the member, the company will continue to exist. And death or insolvency of a partner dissolves the firm because there'll be a change in partnership and that will lead to dissolution. Account and auditing. So it is legally required to audit annually by a chartered accountant. Auditing is at the discretion of the partners and it is dissolved only as per a legal provision. So we were discussing about winding up, and partnership firm can be dissolved by agreement at any given point of time. Next is the difference between company and a Hindu joint family business. Heterogeneous members, varied or diverse. Homogeneous members, members of the joint family itself. Members do not have authority to contract for the company. Karta, or the head of the family, has the sole authority to contract debts for the business. Other co-partners cannot do. So in case of a Hindu undivided family, there is Karta, who will be the head of the family and also head of the Hindu undivided family business. And then there will be co-partners. So co-partners are the remaining members. Remaining members. Here, membership is not acquired by birth. Individuals can join by acquiring shares or other means. Membership is acquired by virtue of birth within the joint family. So if you are, say, a son of the family, then automatically by birth, you will be a member of the Hindu undivided family or Hindu joint family business. Registration of a company is compulsory. No compulsory registration is required even if the number exceeds 20. Next is the difference between a limited liability partnership and a company. So limited liability partnership is a type of partnership wherein the liability of the partner is limited. So the first feature of a partnership, that is, it is unlimited liability, will not fall under this. So LLPs are established under the LLP Act 2008. So LLP Act 2008, and companies are established by way of Companies Act 2013. Now, legal structure. So LLP is hybrid between partnership and a company, and this is a separate legal entity created by law. Liability of partners is limited to their agreed contribution. No partner is liable for another action. And here, liability is limited to the nominal value of their shares. So since here it is a limited liability partnership, it will be the agreed contribution. Next. Perpetual succession can continue regardless of change in parties. Again, can continue regarding the change in the management. Capable of entering into contracts and holding property in its own name, and capable of entering. So this is not a difference table exactly, but how similar LLP and companies are. Then this is governed by a partnership agreement between the partners, and this is governed by your statutory regulations. No formal management ownership divide, more flexible internal governance because And the persons managing will also be could also be the owner. Distinct separation between management and ownership. Lesser compliance requirements compared to a company. So as per LLP Act, there are just a few compliances, like 1 or 2 forms that need to be filed or so. However, more detailed legal and procedural requirements in case of a company. It provides flexibility and is less regulated, suitable for combining expertise with financial risk. This is less flexible due to statutory regulations. However, the structure is more formal and organized. So this is how company is different from each of these. So from a partnership firm, from a Hindu undivided family or Hindu joint family business, and an LLP. Now, if we are talking about advantages of having a corporate form of existence or advantages of separate legal entity, there are also certain disadvantages that come with the corporate form of enterprise. The first disadvantage of a corporate form of enterprise is the expenses of incorporation and flotation. Basically, incorporation of the company is to be done as per the Companies Act, which we will also be discussing at a later point in this chapter. And this involves quite a few procedures and a lot of legal formalities that need to be followed. So it involves complex and detailed legal formalities and procedures. It requires a considerable amount of time and money. So money in terms of payment of your incorporation fees, and if you're appointing any professional to take up the incorporation of the company, then payment of fees to the professional. After incorporation, the company must conduct its affairs in accordance with the legal provisions. Various returns and documents must be filed with the registrar of companies, some periodically and some upon certain events. So registrar of companies is the one who maintains a register of companies in which all the companies that are incorporated and registered will be reporting to the ROC, better off known as ROC. And regularly, there will be quite a few forms or returns that have to be filed with the ROC for which payment has to be made. So there will be regular expenses that are incurred to ensure compliance with the provisions. Certain books and registers are compulsorily required to be maintained by the company. Approval and sanction from the company law board, government, court, registrar of companies, other appropriate authorities are necessary for some corporates. So company law board was there under the Companies Act 1956 that was there earlier. Now it is the NCLT, which is the National Company Law Tribunal. So now the authority which is set up instead of the company law board is the National Company Law Authority. Next, corporate disclosures. So notwithstanding the elaborate framework designed to ensure maximum disclosure, the members of the company comparatively have restricted accessibility to internal management and day-to-day administration of corporate working, because the directors will be taking up the management of the company. Separation of control from ownership. Members of a company lack effective and intimate control of its operations. So if a member is of the view that since they have contributed money and capital to the company, they want to have control over the operations, it will not be possible unless they have been appointed to the board of the company. This is especially true in large companies with many members, unlike in other business firms such as partnership firms where control can be more direct and personal. Greater social responsibility. So we will also be understanding the concept of corporate social responsibility, wherein if the company meets a certain threshold, then they have to contribute to the society as well. So having regard to the enormous powers wielded by the companies and the impact they have on the society, the companies are called upon to show greater social responsibility in their working, and for that purpose are subject to greater control and regulation than that by which other forms of organizations are governed. Greater tax burden. So tax burden is more than tax burden on companies is more than what is there on the other types of business organizations. And detailed winding of procedure. So like we were saying, it does not die a natural death. So again, it provides for a elaborate and a detailed procedure for winding up, which is more expensive and time consuming than what is applicable to the other form of business organization. So now, journey of the Indian company law. So we were discussing about how the act refers to the Companies Act 2013, but that was not the first act that came into existence to govern the company law. So let us have a look at how the journey of Indian company law has been right from the beginning during British rule. So origins. Indian company law is modeled on English laws, starting with the joint stock companies, first in 1844 in England. So first act in India was passed in 1850, covering registration and share transferability. Then to this 1850 act, there were a few amendments that came into place. So 1857 Amending Act granted registrations rights with or without liability. 1860, this was applicable to banking and insurance companies as well. 1856, Consolidated Act for Corporation Regulation and Winding Up. 1882, a recast of the 1856 acts with the amendments up to that time. So basically, this act plus all the amendments were consolidated and added in the 1882 act. 1913 Consolidating Act passed with major amendments in 1936. Again, consolidating is basically you are collating all the previous laws with the provisions that are still applicable. 1948 Comprehensive Companies Act was introduced. 1951 Indian Companies Amendment Ordinance gave extensive powers to the central government and courts. So after this is where the landmark act came in, that is the Companies Act 1956, the one that was in existence prior to the Companies Act 2013. So 1956 Act was passed to consolidate and amend earlier laws coming into force on April 1st, 1956. So this is an important date to remember. That is April 1st, 1956. It was based on the recommendation of the Bhabha Committee of 1952 and is the longest piece of legislation passed by the Indian Parliament. So this is also something that is important. So which is the longest piece of legislation passed by the Indian Parliament? It is the Companies Act 1956. So what were the features? It spoke about full disclosures in their prospectus, detailed financial information, government intervention and investigation provisions, restriction on managerial powers, enforcement of duty and protection of minority shareholders. So again, this act has also been amended multiple times from 1960 to 2006. So if you see, all these provisions will also form a part of 2013 Companies Act, and we can understand that these were primarily as a part of 1956 Act. Now, there was a concept paper on company law in the year 2004, and there was also a J.J. Irani report. So what was the objective of this? To frame a law that enables company to achieve global competitiveness and adapt to a fast changing economy. So here, in order to get the companies, Indian companies, in par with the global practice and global competitiveness, this concept paper was introduced and was exposed for public viewing to gather opinions and suggestions. Expert committee, it was constituted on December 2004 under Dr. J.J. Irani. The task was to advise the government on revising the Companies Act 1956. The report was submitted in 2005. So 1956 Act had to be revamped and the report was to be submitted in 2005. Next, recommendations. So what were the recommendations? Aiming for a flexible, user-friendly law while ensuring accountability as well as transparency. Shareholder approval, shift from a government approval regime to a shareholder-based approval and disclosure regime. So if you see, this is the reason why Companies Act 2013 has both board meeting as well as shareholder meeting, because this particular report suggested a shift from a government-based approval to a shareholder-based approval. Private and small companies grant flexibilities and low-cost compliance. So what happens is, if any company is established as private as a small company, there will be certain provisions of the Companies Act which are exempted to it, because these companies usually operate on a smaller scale as compared to the other companies, and hence it will be better if their compliances are low in cost. Public interest companies subject to a stricter corporate governance. Government companies and public financial institutions, similar disclosure and governance pattern as other companies. Now, and it also focused on global alignment. That is, the report aimed to align Indian law with international best practices and simplify the existing Companies Act. And now, important committees recommending changes to the Companies Act. So then 1952 was the Bhabha Committee. Shri C.H. Bhabha was the chairman to view and review the provisions of Companies Act 1913. 1957 Shastri Committee, chairman was Sri A.V. Vishwanath Shastri. So if you see, the names of the committee are on their chairman itself. Objective was to address practical difficulties, drafting defects, and improving the Companies Act 1956 overall. 1978 Sachar Committee, headed by Sri Rajinder Sachar. Objective was to propose changes to simplify and enhance the effectiveness of the Companies Act 1956. Next, there was 1997 Chandrate Committee headed by Dr. K.R. Chandrate, rewrite the Companies Act 1956 to support growth in a liberalized and a committee environment. 2030 Iradi Committee headed by Sri Justice V. Balakrishnan Iradi, revised laws relating to winding up proceedings to align with latest development in corporate law. 2002 Joshi Committee headed by Sri R.D. Joshi examined the remaining issues. So until now, whatever were there, if there was anything remaining, then Joshi Committee would have analyzed it. Then we have 2003 Naresh Chandra Committee headed by Sri Naresh Chandra. Objective was to regulate private companies and partnerships. So this brought in the concept of private companies under the Companies Act. 2015 Irani Committee headed by Dr. J.J. Irani advised on proposed revision to 1956 for a simplified and dynamic law. 2005 Vesh Committee headed by O.P. Vesh to streamline the prosecution mechanism under the Companies Act 1956. So if you see here, these committees are either set up to revamp the entire law or to make better the provisions of the law in order to meet the global practices, or in existing provisions itself make some changes. Company Law Committee post 2005, the objective was to examine and make recommendation on the implementation of Companies Act 2013 and LLP Act in 2008. Now, Companies Bill 2012. So this was created with the Irani Committee recommendations. So recommendations were considered by the government. Detailed discussion with stakeholders, including industry chambers, professional institutes, government department, legal experts, and professionals. So Companies Bill 2009, it was introduced on 3rd August 2009 in Lok Sabha. It focused on emphasizing self-regulation, minimizing regulatory approvals, greater shareholder democracy, stricter corporate governance norms, and enhanced disclosures. So Parliamentary Standing Committee review, the date of the report finally was 31st of August 2010. Then we have the bill of the year 2011. So it introduced quite a few amendments from the standing committee, and for further review, it was sent back to the committee. Now, when we talk about Companies Bill 2012, Lok Sabha approval was given on 18th December 2012. Rajya Sabha approval was given on 8th August 2013. And hence it was retitled as the Companies Bill 2012. So after this bill was passed, only the Companies Act 2013 came into existence. So once this bill was enacted, so Companies Bill 2012, Companies Bill 2012, it was enacted and that became the Companies Act 2013. So this is once we had received the Lok Sabha and Rajya Sabha and the President's approval as well. So Companies Bill 2012 became the Companies Act 2013. Assent of the President was received on 29th of August 2013. Notification in the Official Gazette of India was 30th August 2013. Amendments, so there have been various amendment acts, Act of 2015, 2017, your IBC 2016, Finance Act. Numerous circular notification order are issued for a smooth functioning of the companies. Now, what were the new concepts that were introduced in Companies Act? So we have associate company. So we will be learning all of these as a part of this chapter to understand what is it that the Companies Act 2013 introduced. So the next part is applicability of the Companies Act 2013. So now let's see to what entities do Companies Act apply. So according to Section 1 of the Companies Act 2013, the Act extends to the whole of India and the provisions of the Act shall apply to the following. So entire India Companies Act is applicable. So the provisions will apply to companies incorporated under this Act or any other previous company law. So what this means, it is either under the Companies Act 2013 or say for example, if a company is incorporated prior to 2013, that is under say Companies Act 1956, then the act will be applicable to those companies as well. So just because a company has been incorporated prior to 2013, it does not mean that Companies Act 2013 is not applicable to it. Next, insurance companies, which are under the provision of the Insurance Act 1938 or the IRD Act 1999. So since these already have a recognized status under the respective act, we have separately mentioned it here. Then we have banking companies, again registered under the Banking Regulation Act 1949. Companies engaged in the generation or supply of electricity, except in so far as the said provisions are inconsistent with the provisions of Electricity Act 2003. So what do all of these mean? It means that the provisions should not be inconsistent with the respective act. That is, provisions of Companies Act should be in line with the respective act. Any other company governed by any special act for the time being in force, except in so far as the said provisions are inconsistent with the provisions of such special act, and then such body corporate incorporated by any act by the time being in force, as the central government may by notification specify in this behalf, subject to such exceptions, modifications, or adaptations as may be specified in the notification. So these are all the companies to which Companies Act 2013 will apply. Next, what is the requirement for incorporation? So incorporation is basically like birth of the company, beginning of the company. So section 464 of Companies Act, again a very important section. Associations or partnership with more than a prescribed number of person, which is currently 50, must be registered as a company under the Companies Act. So it says that if there is a partnership or association of persons with more than 50 members, then that has to be registered as a company. The maximum number of persons that may be prescribed is 100. So currently the prescribed as per the rule 10 of the company's miscellaneous rule is 50. So max 50, but that maximum limit also cannot exceed 100. So at any given point of time, if they want to increase the limit from say 50 to 60, it will be permissible. But if you're increasing the limit from 50 to 120, that will not be permissible, because the maximum that the government can also prescribe is just 100. Now, what are exceptions? So exceptions are that this does not apply to HUF regardless of the number of members. Second one, professional associations, that is the ones that are governed by special act like chartered accountants, lawyers, company secretaries. So these two, HUF and professional association, this is where it is not applicable. Next, illegality of unincorporated entities. So unincorporated companies, associations, or partnerships exceeding the prescribed number of persons are declared illegal if they are not registered under the Companies Act. So if you are an association of person or partnership with more than 50 members, and if you have not registered it, then you will be declared illegal. So now, under the Companies Act, there are various types of companies that have been prescribed. So these differ with the number of people that are there as members, the number of directors, their functioning, so on and so forth. So let's understand each type of company. So the first one that we have is private company. So you would have heard names of companies with private limited in the end. So it means that that is a private company. So let us understand what is a private company. Private company means a company having a minimum paid up share capital as may be prescribed, and which by its articles restricts the right to transfer its shares. So as the name indicates, it is private, that is, shares cannot be freely transferred. The shares cannot be freely transferred. Like say, for example, in case of a listed entity wherein the public can deal with the shares, like they can buy any listed company shares, sell any listed company shares. In case of private company, the transferability is restricted. So this is the first thing that we need to understand. And except in case of a one-person company. So one-person company is a company with just one member. So we'll also be looking into that. Limits the number of its members to 200. So the maximum number of members that a private company can have is 200. So why does it say except in case of one-person company? Because one-person company has to have one member only. They shall, for the purposes of this clause, be treated as a single member. So now, provided that where two or more persons hold one or more shares in a company jointly, they shall, for the purposes of this clause, be treated as a single member. So now, if there is one share and two people are holding it, then it will still be counted as one member only. It will not be counted as two members. So this is for the purpose of calculating the total number of members. Then, provided further that persons who are in employment of the company, persons who have been formally in employment of the company, who were members of the company while in that employment and have continued to be the members after the employment cease, shall not be included in the number of members. So who should not be included? Anyone who is in the employment of the company, has been in the employment of the company, and even after ceasing to be an employee, they've continued to be members. So these will not be counted as members to calculate the overall limit. Then, In addition to this, it prohibits any invitation to public to subscribe. So if we are saying private, then it means that it is very restricted. That is, public cannot subscribe to the securities of the company. So this is how a private company is. Firstly, it restricts the right of transfer of its shares. And where does it have to be mentioned? In the article. Secondly, limits the number of members to 200. Again, this is not applicable for one person company. Thirdly, if there are joint shareholders, they'll be counted as one. Anybody in the employment or had been in the employment continuing to be the member will not be counted in the total number of members, and prohibits any invitation to the public to subscribe for any securities of the company. So this is what is a private company. Moving on to public company. So the definition of a public company is very simple. It means that the company which is not a private company has a minimum paid up share capital as may be prescribed, provided that a company which is subsidiary of a company, not being a private company, shall deem to be a public company for the purpose of this act, even when such a subsidiary company continues to be a private company. So now, to distinguish, like by name, if we have to identify, say there is a company ABC. So if it is ABC Limited, it means that it is a public company. And if it is ABC Private Limited, it means that it is a private company. Now, say for example, this is a holding company. Holding company, nothing but the parent company, wherein say for example, ABC Limited is the holding company of ABC Private Limited. It means that they hold more than 50% of the share paid up share capital in ABC Limited, and this is subsidiary company. So now, here in this case, holding company is public, subsidiary company is private. Even though subsidiary company is private as per its articles, for the purposes of compliances, it will be considered as a deemed public company. Just a minute, please. Yes. So even though the subsidiary is a private company, but as long as the holding company is a public company, the subsidiary company will known to be as deemed public company. That is, all the public company compliances will be applicable to this company. Although in its articles, it continues to be a private company. So that's why the word deemed is used, that it is not actually by its articles a public company, but because it is the subsidiary of a public company, this will also be considered as a deemed public company. Next, we have one-person company, which means a company which has only one person as the member. So again, this has to be a private limited company. It cannot be a public company. Next is companies with charitable objects. So a person or an association of person registered and licensed under Section 8 of the Companies Act 2013. So in Companies Act 1956, it was Section 25. So it is also broadly known as Section 25 companies. But when it comes to Companies Act 2013, it is a Section 8 company. So a person or an associated person, association of person registered and licensed under Section 8 of the Companies Act 2013 as a limited company, if it has in its objects. So if its object is promotion of commerce, arts, science, sports, education, research, social welfare, religion, charity, protection of environment. If so, firstly, it has to have in its objects either one of these 10 options that are given here. Next, intends to apply its profits or any other income in promoting its object. So you are not going to utilize the profit, but you are going to add it for the promotion of these objects only, and intends to prohibit the payment of any dividend to its members. So what are the three things? Your objects should be for the promotion of any one of this cause. Any amount or income that you earn will be used in promoting this cause, and you do not pay any dividend to your members, because then that it becomes like a profit, right? Dividend is a return on the investment that you get by investing in the share capital of the company. So that's why no dividend payment as well. So if all these three conditions are satisfied, then you will be declared a Section 8 company. So no dividend payment. Yes. Next is a government company. So again, as the name suggests, government company means any company in which not less than 51% of the paid up share capital is held by central government. So how much? At least 51% has been held by whom? Either central government, state government, or a combination of both of these, and includes a company which is a subsidiary of a government company. So even if you are not a government company by registration, if you are a subsidiary of a government company, then you will also become a government company. So here the catch is to understand that it is 51%, not less than 51%, which means it could be 51 or higher. Foreign company. Foreign company means any company or border corporate incorporated outside India, which has a place of business in India, whether by itself or through an agent, physically or electronic mode. So it means that it is incorporated outside India, but it is has a place of business in India, and that could be either by itself, through agent, physically or electronically. Either one of the mode is fine as long as they have a place of business in India. Next, we have associate company. So these are related concepts. So associate company, subsidiary company, and holding company. So let's understand associate company first. Associate company in relation to another company means a company in which that other company has a significant influence. So there is another company that we're talking about. So say company A is the other company and company B is the associate company. So yes, it means that A has a significant influence in B, but which is not a subsidiary company of the company having such influence and includes a joint venture company. So B cannot be, if B is a subsidiary company of A, it cannot be the associated company of A. So what is the keyword here to remember when it comes to an associate company? It is the significant influence. So significant influence is the one that determines whether a company is associate company or not, and it also includes joint venture or JV companies. So JV companies are basically two companies coming together, say for a particular project. So Maruti Suzuki is an example of a JV wherein Maruti and Suzuki have tied up specifically for manufacturing of cars. So that is how a JV company works. So now, what exactly is significant influence? It means control of at least 20% of voting power or control or participation in business decisions. So at least 20% of this control should be with the other company. So here, this is very important, 20%. And then the expression joint venture means a joint arrangement whereby the parties that have joint control of the arrangements have the rights to the net assets of the arrangement. So firstly, let's quickly understand associate company, wherein one company has significant influence over another, then that company becomes an associate company. It should not be a subsidiary company, but however, it includes a joint venture company. And the criteria to determine significant influence is the 20%, that is at least 20%. So it can be greater than or equal to 20%. And this could be of the total voting power, the control, or the participation in business decisions in an arrangement. Next is holding company. Holding company in relation to one or more company means a company of which such companies are subsidiary companies. So now we have A and B and C. So if B and C are subsidiary companies of A, it means that A becomes the holding company. A becomes the holding company. Now, let us understand subsidiary company. So subsidiary company or subsidiary in relation to any other company. So which is this any other company? This is nothing but the holding company. Any other company means a company in which the holding company controls the composition of the board of directors. So first criteria is board of directors exercises or controls more than 1/2 of total voting power, either at its own or together with one or more of its subsidiary companies. So how much voting power? 1/2 or more. More than 1/2 of the total voting power. So if 100% will be the voting power. So at least 50%, greater than 50% voting power has to be with the holding company. Provided that such class of holding company as may be prescribed shall not have layers of subsidiaries beyond such number as may be prescribed. So this number that is prescribed is 2 currently. So say we have A, which is the holding company. Then we have its subsidiary B. Then B can have a subsidiary C. So A has indirect control over C as well. But C cannot further have subsidiary D because there are only 2 layers of investment that is permitted. So it's only 2 layers of investment. So this is associate, holding, and subsidiary company. Subsidiary company is where the holding company holds more than one half of the voting power. Associate company, where the other company has significant influence over it, does not include subsidiary company, includes a joint venture. And then holding company is the company that holds more than one half in the subsidiary company. Now, there are a few further explanations that are given here. For the purpose of this clause, a company shall deemed to be a subsidiary company of the holding company, even if the control referred is of another subsidiary company of the holding company. So it basically means that here. So now this is a subsidiary of the holding company. So this is not directly controlled by the holding company, but it will still be a subsidiary of A because it is a subsidiary of B and B is a subsidiary of A. So the 50% criteria that is there, it could be by A or any of its subsidiaries. The composition of a company's board of directors shall be deemed to be controlled by another company if that other company, by exercise of some power, can appoint or remove all or majority of directors. So if I am saying A is my holding company by way of virtue of control over the board of directors, then in that case, A should be able to appoint or remove all or majority of directors of my company. Now, company includes any body corporate, and layer in relation to holding company means its subsidiary or further subsidiaries. Then we have a small company. So small company means a company other than a public company. So what does it imply here? So public company cannot be a small company. Public company cannot be a small company. So it means a company in which paid up share capital does not exceed 50 lakh rupees or such higher amount as may be prescribed, but that maximum amount also cannot exceed 10 crore rupees. So currently this such higher amount is rupees 4 crore. Currently, this is what is applicable, and turnover of which, as per profit and loss account for the immediately preceding financial year, does not exceed 2 crore or such higher amount. Again, this has been increased to rupees 40 crore. And that higher amount cannot be more than 100 crore. So as per this definition, what is it? 50 lakhs or 2 crores. So your paid up share capital and your turnover has to be 50 lakhs, but actually it is 4 crore and 40 crore, and the maximum limit cannot exceed 10 crore and 100 crore. Provided that nothing in this clause shall apply to holding company, subsidiary company. So if you are a holding or a subsidiary company, you cannot be a small company. If you are a company registered under Section 8, or if you are a company that is governed by any special act. So this is how we need to understand small company. So why is there a separate company called a small company? Because given the minimum capital and turnover that they have, the level of compliance will be much lenient for them because they are not a very big company. Next type of company is a dormant company. So dormant means something that is inactive or something that is not functioning. So where a company is formed and registered for a future project or to hold an asset or any intellectual property and has no significant accounting transaction. This is very important, no significant accounting transactions. Such a company or an inactive company may make an application to registrar for obtaining the status of a dormant company. So it is the company that will have to apply to the registrar saying, I want the status of a dormant company. So firstly, if it is for a future project, so what are the various options available? So firstly, it could be for a future project or to hold an asset or intellectual property and no significant accounting transactions. So these are the three main criteria that is required wherein this company can go to the ROC to obtain the status of a dormant company. So inactive company means a company which has not been carrying on business and has not made significant accounting transaction during 2 financial year and has not filed a financial statement and annual returns during 2 financial years. So inactive company, 2 years is the criteria. So what should have happened in the 2 years? That is no significant accounting transactions, no significant accounting transactions, and no filing of financial statements and annual return. So this is a document that has to be filed by the company every year once their AGMs have been held. That is, the annual general meetings have been held. Next, In case of a company which has not filed financial statement or annual returns for 2 financial years consecutively, the registrar shall issue a notice to the company and enter the name of the company in the register maintained for dormant company. So the registrar, like we were discussing earlier, that maintains a register of all the companies that are incorporated and registered. Similarly, they also have a register maintained for dormant companies. So if any company for 2 financial years, if they have not filed any financial statements and annual return, the registrar will move them to the list of dormant companies. Next, a dormant company shall have a minimum of 3 directors in case of a public company. So actually, this is just a company. Yes, a company shall have a minimum number of 3 directors in case of a public company, 2 in case of private company, and 1 in case of a one-person company. So this is the basic applicability, not only to a dormant company. So what is the minimum number of directors? So in case of public, it is 3 directors. For private limited company, it is 2 directors. And for OPC or one-person company, it is a one single director. Now, provisions of the Act in relation to rotation of auditors shall not apply on dormant companies. So as we move ahead with the syllabus, we'll also be learning what exactly is rotation of auditors, rotation of directors. So that is something that is not applicable. To dormant companies. Now, the registrar shall strike off the name of a dormant company from the register which has failed to comply with the requirements. So this is what a dormant company is. Firstly, it was inactive, no significant accounting transactions. And then we also saw that what is inactive company? For 2 years, no significant accounting transactions and no filing of financials and your annual return as well. So the next type of company is a Nidhi company. So Nidhi means a company which has been incorporated as Nidhi with the object of cultivating the habit of thrift and saving. So this is the most important term that we have to learn for Nidhi company is to promote thrift and savings amongst its members, receiving deposits from and lending to its members only for their mutual benefit. So if you see here, first of all is thrift and savings. Second one, it is for members. And third one, it is for mutual benefit and which complies with such rules as may be prescribed by the central government. Next, we have producer companies. So according to section 378A subsection 1 of the Companies Act, producer company. So what exactly is producer company? Means a body corporate having objects or activities as specified in section 378B and registered as a producer company under the Companies Act or any other, or the 1956 Act. So in terms of section 378B, so what are we saying? The objects have to be covered in 378B and whatever is there in that is only something that the producer company can take up. So now, what are the matters? Production, harvesting, procurement, grading, pooling, handling, marketing, selling, export of primary produce. So basically dealing with the primary produce of the members or import of goods or services for their benefit. Provided that the producer company may vary and carry on any of the activities specified in this clause. Next. Processing include preserving, drying, distilling, brewing, vinting, canning, and packaging of produce for its members. So this is something that the producer companies are allowed to do. Further, we have manufacture, sale, supply of machinery and related equipment, providing education on mutual assistance principles. So if you see here, the word mutual has been used quite a few times, which means that it is for the benefit of the members. Rendering technical services, consultancy services, training and research and development, and all other activities for the promotion of interest of its members. Then we have generation, transmission, distribution of power, revitalization of land and water resources, their use, conservation and communication relating to primary produce. Then insurance of producers or their primary produce, promoting techniques of mutuality and mutual assistance, and welfare measures that facilitate the members. So this is something that the Nidhi company is required to do, wherein it solely focuses on its members. Further, any other activity ancillary or incidental to the activities referred to in clauses A to I. And then lastly, we have financing of procurement, processing, marketing, and other activities, which include extending of a credit facility to any other financial service to its members. So these are all the types of activities that is permitted as per section 378 for a producer company. Next up, we have non-banking financial companies. So as the name suggests, there is a financial component that is involved, but it is non-banking. So let us understand this. It is registered under the Companies Act itself. Engaged in the business of loans, acquisition of shares, leasing, hire purchase, insurance business, chit business, and excludes the institutions with the principles of agriculture, industrial, purchase or sale of goods, providing services, sale of immovable property. So this is something these are a few criteria that is not included in your non-banking financial companies. And residuary non-banking company, principal business of receiving deposit under any scheme or arrangement. So this is how a non-banking financial company works, whereas it is established as a company, but it is not a bank technically. So next, let's have a look at how companies are formed. So according to the Companies Act 2013, a company may be formed for any lawful purpose. So firstly, the purpose has to be lawful. By how many people? By 7 or more person where the company to be formed is a public company. Okay, so in public company, the minimum number of people will be 7. Then by 2 or more person where the company is a private company. So private company, the number of minimum number of members will be 2, or 1 person where the company to be formed is 1 person company, that is nothing but a private company. So 1 person company, that is a private company, it will be 1. A company formed above may either be a company limited by shares, limited by guarantee, or unlimited company. So limited by shares, like we were studying earlier, which means that it will be limited only to the extent of the unpaid share capital. Guarantee is the amount that they have provided a guarantee for. Unlimited company becomes similar to your partnership firm, wherein there is an unlimited liability. Now, company limited by shares means a company having the ability having the liability of its member limited by the memorandum to the amount if unpaid on shares. So what is their liability limited to? Only to the amount that is unpaid on the shares. Unpaid on the shares. Next, company limited by guarantee is a company having the liability of its member limited by memorandum to such amount as may the members may respectively undertake to contribute to the assets of the company on the event of its being wound up. Wound up is basically the last step, that is the dissolution, where the company ceases to exist. So at that time, how much ever money the member has taken up a guarantee to pay, they will be liable only to that extent. Unlimited company means a company not having any limit on the liability. So not having any limit on the liability. So in case of company limited by shares, it is how much amount is unpaid on the share capital. In case of guarantee, it is how much money they will be giving at the time of the company being wound up. And in case of unlimited company, it means the company which does not have any liability on its, does not have a limit on the liability. Now, how does a company actually get incorporated? So there are a few application forms for incorporation. So there is a SPICE form that is recently introduced, which is nothing but simplified pro forma for incorporating a company electronically. Plus, again, this form is known as INC 32. So this is very important, one of the most important forms when it comes to incorporation. This is used for incorporation application. E-Memorandum of Association, INC 33, E-Article of Association, INC 34. So like the name itself suggests, it's SPICE, EMOA, EAOA. So the entire application can be done electronically. So application for incorporation. So this has been brought about to promote the goal of the ease of doing business in India. Now, for Section 8 companies, EMOA is INC 13 and EAOA is INC 31. So we have INC 13 and 31, that is the MOA and AOA for Section 8 companies. What are Section 8 companies? The not-for-profit companies. Next, additional requirements. So director identification number, application for up to 3 directors you can apply. So what is a director identification number? So every individual who wants to be a director in any company has to apply for a DIN. They will be allotted a DIN and that will be the identification that will be given to them at the time of becoming a director. Reservation of name to be included in the SPICE form. So you can reserve up to 3 names. So there is a reserve unique name run form. This is a reserve unique name or run form, wherein you can apply for the top 3 preferred names, and depending on their availability and comparison with the existing names and unfavorable names, all of that will be analyzed by the registrar of companies, and accordingly a name will be allocated to the company. Now, incorporation and appointment of directors has to be filed with the registrar along with an additional fee of 500. So whenever we are talking about incorporation of the company, the first form that should come to our mind is SPICE, that is Simplified Proforma for Incorporating the Company Electronically. EMOA, AOA, INC 33, INC 34. In case of Section 8 company, INC 13 and 31. And then we need to have a DIN, a run form, and also an additional fee of rupees 500. Now, further, there has to be a declaration by a professional. So now, as a if I want to incorporate a company, I am furnishing the information. Then they also have to get a certificate or a declaration from a professional. So who can this professional be? Any one of these four. So this has to be a practicing. So this has to be a practicing advocate, or a chartered accountant, or a cost accountant, or a CS. So this has to be somebody that is in practice who can certify this. And what will be they certifying? They will confirm the compliance with all requirements of Companies Act and associated rules in the formation of the company. So what happens? This performs like an additional check. So prior to incorporation itself, if we are getting this declaration by a professional, the processing of these forms becomes easier for the ROC, because there is a professional who has taken up responsibility for this. Next, declaration by proposed director, manager, or secretary that they are not convicted, that the individual must declare that they have not been convicted of any offense relating to promotion, formation, and management of a company. So who? Themselves, that is the director, manager, or the company secretary. And no fraud or misfeasance, that is they have not been found guilty of fraud, misfeasance, or any breach of duty under the act or previous company law in the past 5 years. So firstly, they should have not been convicted, then no fraud or misfeasance case in the past 5 years, and accuracy of documents, that is whatever documents that you have filed with the registrar are all correct, complete, and true to the best of their knowledge and belief. So why are these declarations important? So not only in incorporation, but any form that the company files. So we will be learning about multiple forms as we progress in the CS course further that the company has to file. Say, for example, change in director, there's a form DIR 12 that has to be filed. Increase in authorized share capital, there's a form SH7 that needs to be filed. So towards the end of the form, there is always a declaration by the directors, and wherever required also by a professional saying the content of this is true. And wherever the professional is declaring, they will check that whether or not the company has complied with the compliance requirements. Now, the application for incorporation of a company shall be accompanied by e-form Agile Pro S, that is INC 35. So let's quickly go through. So we had INC 32, that was the SPICE plus form. Then we have INC 33, that is the EMOA. Then INC 34 is EAOA. And now we have Agile Pro S INC 35, that is Agile Pro S. And prior to that, we also had INC 31, that is the EAOA for Section 8 companies, and INC 13, that is the EMOA for Section 8 companies. So these forms are very important to remember from an incorporation point of view. Now, what will Agile Pro S contain? It contains an application for registration of the following numbers. So GSTIN, EPFO, ESIC, so Employee State Corporation, professional tax registration, opening of bank account, and shop and establishment registration. So all of these ancillary registrations that will be required by the company upon incorporation, the same has to be applied through Agile Pro S. So if you see here, multiple registrations can be obtained within one single form itself, that is Agile Pro S, or also known as INC 35. Now, the registrar, on the basis of the document and information filed above, shall register all the documents in the register and issue a certificate of incorporation. So certificate of incorporation is equivalent to a birth certificate in case of a human being. So certificate of incorporation is the document which will contain the SIN of the company and also the incorporation date. So if we are talking about certificate of incorporation, it will include SIN. So SIN is basically the corporate identification number. corporate identification number, and the incorporation date as well. So this will be included in the certificate of incorporation, and this is issued by the registrar of companies or ROC. Now, on and from the date mentioned in the certificate of incorporation, the registrar shall allot to a company a corporate identification number, which shall be a distinct identity for the company and which will also be included in the certificate. So here they are talking about SIN. The company shall maintain and preserve at its registered office copies of all documents and information as originally filed in point number 1 till the dissolution. So whatever documents that we were talking about will be required for incorporation. It is the company's responsibility. So company should preserve these documents at its registered office address. So registered office address is again applied for at the time of incorporation itself, wherein all the correspondence relating to the companies, all of it will be available at the registered office. Next. If any person furnishes any false or incorrect particulars of any information, so any false or incorrect information, or suppresses material information of which he is aware. So either you are furnishing something which is false and incorrect, or you are suppressing something that is material, that is you are not disclosing something that is material, then he shall be liable for punishment for fraud under section 447. So section 447 again is a landmark section because it provides the punishment for fraud in under the Companies Act 2013. So this is how we need to understand the entire incorporation procedure. That is, first we have the forms that we had a look at, and then the registrar will have a look at all the documents, and if there are any gaps in the documents, they may give the forms for resubmission, and upon resubmission, they will grant you a certificate of incorporation, which will consist of the SIN. And all of these documents are to be maintained by the company at the registered office address until the dissolution. And if any person has, furnished false information or suppressed material information, they will be liable under section 447 of the Act. So now let us understand a few basic things when it comes to forming a company. So first one is share capital. So we may have heard the shares of this particular company are trading at so and so amount, that share price has gone down, share price has gone up. So what exactly is share capital? So firstly, capital. So when we talk about capital, again, for it again depends on the context. So for economists, the capital is different, accountant, businessman, but for a layman, it is seen as money raised by issuing shares. So say, for example, I am incorporating a company. For my company, I want capital. So what I will do, I will issue shares of my company. So say I am issuing 100 shares of rupees 10 each. Of rupees 10 each, or let's take a bigger number. So say, for example, let's take a number of 10,000. 10,000 shares of rupees 10 each. So I am raising a capital of rupees 1 lakh. And say out of 10,000, 5,000 is being held by person A and 5,000 is being held by person B. Then in that case, what happens is A becomes the holder of 5,000 shares and B becomes the holder of 5,000 shares. So this is the money that I have raised by issuing shares to A and B. Now, use of capital. It is used for acquiring assets like business premises and stock in trade. So mainly it will be used for the business operations of the company. Now, share. Share is a unit of ownership in the company. So if I am a shareholder, then I have a certain percentage of ownership. So say here in this case, there are 10,000 shares and A and B have 5,000 each. So A and B have 5,000 each. So A becomes 50% shareholder, B becomes 50% shareholders. So they are owners up to the extent of 50%. It includes stock unless specifically distinguished. Then coming to share capital. So share is this unit. Share capital is the amount. So in this case, it will be 10,000 into 10. That is rupees 1 lakh. So the funds raised by the company through issuing shares is nothing but share capital. It represents the ownership interest in the company, and composition, it includes the numbers and types of shares that forms the company's share structures. So there are different types of share capital that are there, like equity share capital, preference share capital. The company may issue both. So all of this combined will become your share capital of the company. So now, what are the types of share capital? So first we have the nominal authorized or the registered share capital. Nominal authorized or the registered share capital. So this is nothing but the maximum amount of share capital a company is authorized to raise as specified in MOA. So like I was mentioning earlier, MOA will have specific clauses. So capital clause will be one of that. And in the capital clause, if I am saying that my authorized share capital is rupees 10 lakhs, then at no given point of time, I can issue shares worth more than 10 lakh rupees. And if I have to do, first I have to amend the memorandum, increase the authorized share capital, only then issue further shares. So this is like the maximum amount that the company can raise by issue of shares. Next one is issued capital. The portion of nominal capital that the company issues for subscription, it is calculated at the face or nominal value of shares. So issued is basically the company is issuing these share capital that if any person wants to purchase the shares, then we are issuing. So this could be an amount equivalent to the authorized share capital or even lesser to the share capital. So we can have, say, I am issuing shares worth 8 lakh rupees. So issued share capital. So I am issuing worth rupees 8 lakh rupees. Now, subscribed capital. So subscribed capital is basically that part of the issued capital that is subscribed by the members. So not all issued capital may be subscribed. So now maybe I offered shares worth 8 lakh, but actually the subscribed part was only 6 lakh. So I could get applicants only for 6 lakh rupees. So in that case, the subscribed share capital will be 6 lakh. And lastly will be called up capital, the portion of subscribed capital that has been called for payment. So now the applicants have said that, okay, we are ready to subscribe to 6 lakh. But company is saying, okay, we will keep this in mind. But for now, we want only 4 lakh rupees. So 4 lakhs becomes the paid called up capital of the company. So 4 types of share capital. First one is authorized. That is the maximum that you can raise as a company. Then we have issued, how much the company is offering for subscription. Then we have subscribed, how much the members or the persons have opted to subscribe for. And lastly will be called up, that is out of the subscribed portion, how much it is that the company actually wants the money for. So this is how we need to understand share capital and its types. Now, paid up share capital. Finally, after called up capital, it will be the paid up capital. That is the total amount of money credited as paid up in respect of the shares issued. So if you remember the definition of a company limited by shares, the liability will be only to the unpaid amount. So now we had, in the last example, we saw that the last called up part was 4 lakh rupees. And say shareholders have paid, so paid up capital is 3 lakh rupees. Now, so 1 lakh becomes the amount that is unpaid. And in case of a company limited by shares, this is the only extent to which the shareholders will have a liability. Not beyond this, not even 3 lakh, because they have already paid that. So paid up share capital is the total amount of money credited. So money that is credited, and it includes amount received as paid up or any other amount credited for paid up shares. So now, like we were talking about equity and preference share capital. So first, let's understand preference share capital and then we will go to equity. So preference share capital is the part of the issued share capital that carries the preferential right. So like the name suggests, there is a preference over the other shareholders. So what will be the preference in two things? First one, it will be the dividend payment, that is there is a fixed amount or rate of dividend that will be paid to them, and also it will be paid prior to the equity shareholders. And second one, repayment on winding up, that is amount of share capital paid up or deemed to be paid up with or without preferential rights to premium. So now what happens is, at the time of winding up, the company pays back the shareholders all the amount. So in that case, preference shareholders will be paid first prior to the equity shareholders. So that's why there is a name given to it saying it's a preference share capital. So two things, dividend payment and amount at the time of winding up. So now equity share capital is all the share capital that is not preference share capital. So next, board of directors. So in simplest of the words to understand, board of directors are persons who are entrusted with the management of the company, managing the affairs of the company. So having a look at the definition, Section 2, subsection 10 of the Companies Act defines board of directors or board as the collective body of directors of a company responsible for directing, controlling, and supervising the company's affairs. So they will be responsible for driving the company's affairs. Now, individual directors only. So, as per section 149, the board of directors must consist of individuals only. So, only natural persons can be a director. No body, corporate, association, or firm can be appointed as a director. However, in case of a shareholder, a company can be a shareholder. So, that's where the holding company, subsidiary company, associate company comes into picture. So now, when we are talking about the minimum number of directors, in public company, it is 3. In private, it is 2. In OPC, it is 1. So when we are talking about shareholders and directors, so in case of a private company, the number of shareholders minimum are 2. Directors are also 2. In case of public company, number of shareholders are 7. Number of directors are 3. In case of OPC, both are minimum 1. So let's keep this bifurcation very clear, because since these numbers are similar, there might be a confusion as to the minimum number of shareholders and the directors. So now, if there's a minimum limit, there has to be a maximum limit. So as per the Companies Act 2013, you can have a maximum of 15. So earlier 1956 Act gave us a maximum limit of 12, but now we have 15. Exceeding 15 directors. So you can appoint more than 15 directors, but you need to pass a special resolution in a general meeting. So general meetings are basically shareholder meetings. So general meetings are your shareholder meetings. And in your shareholder meeting, so what is a resolution? So resolution will basically be a text that approves the decision that you have taken up at a meeting. So it serves as a evidence of the decisions that are taken at the meeting. So now there are two types of resolutions that need to be passed. So let's understand this. We have ordinary resolution and special resolution. So say ordinary, we have 5 members. Let's say we have 10 members in the company. So ordinary resolution is just a simple majority. So more than half of the members should have voted for the resolution. It becomes an ordinary. So your votes for should be greater than votes against. So this is a simple rule in case of ordinary resolution. So out of my 10 members, if 6 have voted for and 4 have voted against, then your ordinary resolution is said to have passed. In case of special resolution, your votes for should be greater than 3 times your votes against. So say for example, if 8 people have voted for, so 8 people have voted for, so how many have voted against? 2. So 3 times of 2, so 8 is greater than 6. So in this case, special resolution will be passed. These are better known as OR and SR. So in case of OR, there's a simple majority that is required. That is, your votes for should be greater than your votes against. And in special resolution, your votes for should be greater than 3 times of the votes against. So in case of maximum number of directors, you have to pass a special resolution at a general meeting. So you need 3 times the votes as against how many are passed against the resolution. Exception, the maximum limit does not apply to section 8. Minimum does apply, the maximum of 15 limit does not apply. And out of this, there's a resident director requirement also. So section 149 subsection 3 states that at least one director must have stayed in India for a total of at least 182 days in the previous calendar year. So that is the resident director. So at least one director should have stayed in India for at least 182 days in the previous calendar year. So this is calendar year and not financial year. So these are certain very basic things to remember, but when it comes to interpretation, it becomes very important, because say for example, a company is saying that we do have a resident director requirement, but they've satisfied the 182 days in the previous financial year and not the calendar year. So then the requirement is not fulfilled actually. So these are the small. So in law, no matter how small the detail is, it becomes essential, especially when there is a non-compliance or a violation of the provision. Now, how do we appoint directors? So first, initially in the at the time of incorporation, so as per section 152, if the articles of association do not provide for appointment of first directors, the subscribers to the memorandum who are individuals are deemed to be first directors. So subscribers to memorandum will basically be the initial members. So if no directors are provided for, no directors appointment is provided for, then subscribers to memorandum become the director. Appointment procedure, it is in a general meeting. So basically that it means that it requires shareholder approval. Next, we have director identification number again. So this is a unique number that is allotted to every director. So a person must not be appointed as a director unless they've been allotted a DIN or any other prescribed number. A declaration. Every person proposed for appointment as a director must furnish their DIN or the other prescribed number and declaration stating that they are not disqualified. So Companies Act provide for a list of disqualifications that any person who wishes to be a director must not be disqualified. So even when you're applying, you have to give your DIN and also a declaration saying that you are not disqualified to be appointed as a director. Now, consent to act as a director. A person appointed as a director must give consent to hold the office, and this consent must be filed with the registrar within 30 days of appointment. So this is very important. So what happens is that the company in its power will pass a board resolution and a shareholders resolution saying this director is appointed. But is the director willing to get appointed? That is something that needs to be documented, and that is a consent that has to be given in form DIR2. So form DIR2 is the form in which the directors will give their consent saying, I give my consent to be a director of this company with effect from so and so date. And once the director has given this to the company will have to file this within 30 days of appointment. Not within 30 days of receiving the consent, but within 30 days of appointment. Now, for public company directors, there is a provision of retirement by rotation that is applicable. That is, if the AOA do not specify otherwise, at least 2/3 of total number of directors will be subject to retirement by rotation. So how many? 2/3 of total directors are subject to retirement by rotation. It means that they will have to retire at the upcoming general meeting. These directors must be appointed by the company in the general meeting. Next, remaining directors. The remaining directors not subject to retirement by rotation, so this is nothing but 1/3, are also appointed by a company in a general meeting. So these are just introductory concepts that are there in CSEET, but when we move to CS Executive, we have a separate subject dedicated to company law, and therein we'll be able to study all of these in detail. So this is just to give an introduction to company law. So that's why we will not be, taking up these provisions in detail, because that forms a part of the next level of the exam. Next, retirement at the annual general meeting. So again, when we talk about shareholder meetings, there are two types of meetings. So we have AGM, that is the annual general meeting, and EGM, which is the extraordinary general meeting. So AGM is like an annual meeting that has to be held every year, and there are 4 businesses that we will have to take up at this AGM. So apart from these 4, if there is anything during the year that has to be taken up by the company, that will be done in the extraordinary general meeting. So annual general meeting happens once in a year, and if there is any requirement to pass a shareholders resolution in between the year, then you take up an EGM. So at the first AGM held after appointment of the first directors, and at every subsequent EGM, 1/3 of the directors who are subject to retirement by rotation must retire. So it is not 1/3 of total directors. So how many are subject to retirement by rotation? We understood that 2/3. So there is 2/3. And of this 2/3, 1/3 will retire. So it is 1/3 of 2/3. So how many are not liable to retire by rotation? It is 1/3, but this 1/3 is not that. This is 1/3 of the 2/3 that are liable to retire by rotation. How will now if we are saying 2/3, how will the sequence of retirement be determined? So directors are to retire by rotation are those who have been in the office the longest since their last appointment. If the directors were appointed on the same day, the order of retirement will be determined by a lot. So that is like a random picking if they have been appointed on the same day. If not, it will be a first person to retire will be the one who has been the longest in the office. Then filling of vacancies. At the AGM where the director retires, the company may fill the vacancy by reappointing the retired director or another person. So it does not mean that the director mandatorily has to leave the board, but it just means that they will have to be reappointed in the AGM. Now, additional director. So the article of association can grant the board of directors the power to appoint an additional director. So why are we saying an additional director? So like we all just discussed, so director has to be appointed by the shareholders, but AOA can also give the power to the board to appoint the directors. And in this case, the board can appoint an additional director. So, the appointed additional director must not be someone who failed to be appointed as a director in a general meeting. So, it means that if the shareholders themselves have rejected the appointment of a person, then the board does not have the power to appoint them as an additional director. So, tenure, the additional director will hold office until the next AGM or last date when the AGM should have been held, whichever is earlier. So, why are we saying AGM? So, like we were saying, board can appoint only additional director, but their appointment as a director will have to be confirmed by the shareholder itself. And that's why AGM is the event wherein they'll have to be appointed. Now, coming to alternate directors. So, the board can appoint an alternate directors if authorized by AOA or by a resolution passed in the general meeting. So, why is an alternate director required? So, here again, like the name suggests, they are not permanent, they're just an alternate director. So, whom will they be replacing? They will be in place of an original director who is absent from India for a period of not less than 3 months. So, at least 3 months. If the original director is absent, then in their place, a alternate director can be appointed. And the alternate director's tenure is limited to the period of the original director's absence. So the minute the original director returns back, the tenure of alternate director expires. So this is just in place of the original director who's outside India for at least 3 months. This appointment is required. Now, we spoke about we spoke about appointment of directors, but we also need to understand when can a director be removed. So now, there is a general removal. That is, a company can remove a director who is not appointed by NCLT by passing an ordinary resolution. So we are saying that for removal, ordinary resolution is required. And what is the requirement? That it should not be a director who has been appointed by the NCLT, because in that case, the removing authority will be NCLT only. So apart from this, whichever directors are there can be removed by the board. Now, the company must give a reasonable opportunity to be heard before the resolution for removal is passed. So this is a very practical and a procedural thing, that is, before removing someone, you need to give them an opportunity of being heard. Next is independent director. So like the name suggests, independent director is someone who is independent of the company. So independence could be in terms of not having share capital or not being another director in the company or director of a holding or a subsidiary company. So Companies Act outlines the requirements of an independent director. So now, removal of an independent director can be removed only by passing a special resolution. So for any other director, it's an ordinary resolution. But for an independent director who is reappointed for a second term, can be removed by passing a special resolution only. And then the director again must be given a reasonable opportunity of being heard. So now, again, in addition to opportunity of being heard, a special notice also has to be given. That is, it is required for any resolution aimed at removing a director or appointing a new director in place of the removed director. Now, coming to filling of vacancy. Now, if the removed director was appointed by a company in general meeting, the vacancy can be filled by appointing another director at the same meeting. So, in one meeting, you may decide to remove the director. In the same meeting, you can pass a resolution for appointment of another director, and the newly appointed director will hold office until the end of the term where the removed director was originally appointed. So if you see here, we are talking about filling of vacancy and not appointment in specific. So that's why the tenure was until when the original director had to be in the office. Now, meetings of the board. So now if we understood what is the board of the directors, how a board is appointed, how directors can be removed, what are the eligibility for any number of directors, and also the minimum number of directors. So now let us talk about meetings of the board. So meetings are significant for efficient, effective running of the company, and this is mandated by the Companies Act. So first board meeting has to be taken up within 30 days of incorporation. So in this meeting, you will be taking note of all your share certificates, your director appointment, your subscribers to the memorandum, your registered office. So first board meeting has to be done within 30 days of incorporation, and minimum of 4 board meetings every year. So the act says that 4 board meetings have to be held every year, and between two meetings, there has to be a 120 days time gap. So why is this time gap given? So what happened if this time gap was not there? Then in that case, company would have held all 4 meetings as a stretch just to comply with the requirements. But however, the whole purpose, that is the efficient and effective running of the company, would not have been satisfied, because the company, directors are not meeting regularly, not discussing on the affairs of the company. So that's why 4 board meetings every year, and with a maximum gap of 120 days. So if, say for example, I am holding a meeting today at 1st of August 2024, or any other date, then in that case, say the next meeting has to be held by 1st of December. Then this is how the time gap between the board meeting needs to be determined. So this is to make sure that there's only a reasonable time gap, not something that cannot be justified. Next, for one person company, small company, and dormant company, at least one board meeting in each half of the calendar year. So this is one board meeting in each half of the calendar year. So basically, it means that every 6 months, one meeting has to be held. So every 6 months, one meeting has to be held. Now, gap between two meetings shall not be less than 90 days. So as against 120 days in case of a one person small company and dormant company, it is 90 days. And provision is not applicable to OPC with only one director, because the purpose is to meet all the directors. And if OPC is having one director, then provision for meetings of the board is not applicable. And then for Section 8 company, one meeting within every 6 calendar months, and director can participate in person or video conferencing. So this is just for general, not only for Section 8 company. So directors can participate in person or via video conferencing, audiovisual means. So this provision was there always, but after the advent of COVID is when this provision was used majorly by the companies. And quorum is 1/3 of total strength, or two directors, whichever is higher. So basically, it means that 1/3 of your directors have to be present, or two, whichever is higher. So let's say my board of directors has 9 members. So what is 1/3 of 9? It is nothing but 3. So it has to be 3 or 2, whichever is higher. So 3 directors at least have to be present in every board meeting. This is to ensure that all the directors are participating in the meeting, and resolutions are not passed without the consent of the other directors. Next, so just like board meetings, we also have shareholder meetings, wherein minimum at least 2 persons are required. So like we were saying, AGM and EGM. So here at least 2 persons would be required to attend the meeting. One person may constitute a meeting, but there are certain exceptional cases. Then they must adhere to the Companies Act 2013 and rules. And general meeting is a meeting of the company members for decision making. Now, coming to AGM that we were talking about, so it is held once every calendar year and must be within 6 months of closing of the financial year, and the gap should not exceed 15 months. So if we are saying within 6 months of closing of financial year, so Companies Act says that April to March is the financial year, but if the company follows a Jan to December, then they'll have to apply separately to the register. So for the case of April and March, if we are saying within 6 months of March 31st, it means that by 30th September, the AGM should be held, and the the AGM for the next year has to be held within 15 months. So if I am saying 30th September, then I can hold the meeting in next year, 31st December. No, both of these conditions should be satisfied. So it does not mean that you can have a maximum gap of 15 months. Yes, maximum gap can be 15 months, but it has to be within the due date of 30th September, or 6 months of closure of financial year. And then so it also gives us specifics, that is when can the meeting be held. So it is during business hours, that is 9 a.m. to 6 p.m. only, and it should not be on a national holiday. So if you saw, in case of board meetings, these provisions are not there. So it is very flexible that way. But in case of shareholder meetings, because the number of shareholders may be large, the number of people attending, we have to make sure that the meeting is only during business hours, that is 9 a.m. to 6 p.m. and not on a national holiday, at the registered office or within the same city, town, or village where your registered office is situated. And unlisted companies can hold AGM anywhere in India with prior consent. So there has to be a consent from a certain percentage of members. If it is there, then you can hold the AGM anywhere in India. So now, special business. So according to section 102 Subsection 2, subsection A, AGM special business includes any other business other than. So, like we were discussing earlier, AGM is held specifically for 4 set of agenda items. So, those are here. So, these are all ordinary business. Now, let's understand that ordinary business, special business is different from ordinary resolution, special resolution. So, ordinary business are only these 4. So, what are these? Firstly, is your consideration of financial statements and reports. So, your accounts basically. Second one, declaration of dividend. Appointment of directors. So, we saw that all the directors retiring will have to be appointed in AGM. Any additional directors that are appointed will have to be reappointed in the AGM by the shareholders. And lastly will be appointment and remuneration of auditors. So these are the 4 ordinary businesses that have to be taken up in the AGM. In addition to this, so say for example, I want to increase my share capital, then that will become the special business. So again, increase for authorized share capital is a special business, but according to Act, ordinary resolution is sufficient. So let's not get confused between special resolution, ordinary resolution, and special business, ordinary business. Ordinary business is the list of these 4, that is your financials, dividend, director, auditor. Anything apart from this becomes special business. Ordinary resolution is a resolution where simple majority is sufficient, and special resolution is the one where your votes for should be greater than 3 times of votes against. So now section 99 provides for penalties for default and holding meetings, which includes up to 1 lakh rupees and continuing defaults of rupees 5,000 rupees per day. So say for example, I had to hold my AGM by 30th September, but I have not held it. So outright there is going to be a fine of 1 lakh. And say I hold it, but on 31st of October, then until then the fine of rupees 5,000 will be applicable. So these are the provisions that are related to your appointment of board directors, holding of board meetings, and holding of shareholder meetings. So now we will be looking into the last part of this chapter. So we have 3 topics to go. So first one is corporate social responsibility, business ethics, and ethical dilemma. So we'll quickly move to the module to understand this. So when we speak about corporate social responsibility, so we were seeing when we were understanding company structure, that social responsibility is something that the Act mandates for any given company to take up. So what exactly is corporate social responsibility? So it's basically giving back to the society that you are operating in. So according to section 135 of the Companies Act 2013, every company having a net worth, okay, so there is a threshold requirement, net worth of rupees 500 crore or more, turnover of rupees 1,000 crore or more, or a net profit of rupees 5 crore or more during the preceding financial year, okay, during the preceding. So it is a or condition here. So if you see here, or turnover or net profit. So even if one of these is satisfied, then the company is mandated to constitute a CSR committee, a corporate social responsibility committee of the board, which consists of 3 or more directors, out of which at least 1 director shall be an independent director. So now if we are talking about CSR committee, then in case of a CSR committee, there has to be 3 directors, at least 3 or more directors, of which 1 has to be an independent director, and this committee will be known as CSR committee. So let's quickly go through the thresholds once again. Net worth of 500 crore or more, turnover of 1,000 crore or more, net profit of 5 crore or more during the immediately preceding financial year. So now the board's report shall disclose the composition of the CSR committee, saying if you have complied with this composition or not, and if so, what is it? The CSR committee shall formulate and recommend to the board a policy. So first responsibility of the committee is constitution of a policy. Then second one, you will give them an account on the expenditure, that is how much expenditure has to be increased. I mean, how much expenditure has to be incurred, and then you will monitor the policy that you have formulated. So this is the primary responsibility of the CSR committee of any company. Now, the board of every company referred to in section 135 subsection 1. So basically these companies shall ensure that the company spends in every financial year at least 2% of the average net profit of the company made during 3 immediately financial years. So now there is a net profit of 3 immediately preceding financial years. So at least 2% of that you have to spend towards CSR expenditure, that is in pursuance of the CSR policy. Next, in case the unspent amount does not relating to any ongoing project, unspent amount to be transferred to a fund within 6 months of expiry of financial year. So what happens is, maybe you have taken up a project, but it will go on for more than a year, more than 2 years. Then that becomes an ongoing project. But if that is not the case and you still have certain unspent amount left, you have to transfer it to a fund within how much? Within 6 months of expiry of the financial year. Next, in case the unspent amount relates to an ongoing project, then in that case, the unspent amount has to be transferred within a period of 30 days to a special account, which is called unspent CSR account. So, any unspent account, you will transfer it within 30 days of financial year to which account? To unspent CSR account. To unspent CSR account. So what happens is two cases. If it is not relating to ongoing project, you'll transfer it to a fund that is specified under Schedule 7 within a period of 6 months. And if it relates to an ongoing project, then you will transfer it to the unspent CSR account, and this will be within 30 days of end of financial year. Such amount shall be spent by the company in pursuance of its obligation towards CSR policy within 3 financial year within the date of such transfer. And if you have not, then you will transfer it to the Schedule 7 fund within 30 days from date of completion of third financial year. So this is basically saying that for ongoing project, you have transferred this amount within 30 days of financial year. So that has to be spent within the next 3 financial years. If not within 30 days of third financial year, you have to transfer it to the fund. So two things, account and fund. Fund will be in case of unspent account not relating to any ongoing project, and account will be unspent amount for an ongoing project. Now, penal provision for non-compliances are as under. So the company which is will be liable to pay a penalty of twice the amount required to be transferred by the company in fund, as the case may be, or 1 crore rupees, whichever is less. So 2 times the amount to be transferred, 2 times of the amount to be transferred, or rupees 1 crore, whichever is less. This is what the company has to pay. And every officer of the company who is in default, 1/10 of the amount required to be transferred, or 2 lakh, whichever is less. So 1/10 of the amount that is required to be transferred, or rupees 2 lakhs, whichever is less. So these are the two penalties that are applicable in case of your company and also your officer in default. So now, there are a list of activities that the Companies Act has given, saying you can spend for any of these activities in pursuance of your CSR policy. So what is this? First one, hunger, poverty, malnutrition, promoting healthcare, including preventative healthcare and sanitation, contribution to Swachh Bharat Kosh, set up by the central government for sanitation and making available safe drinking water. So Swachh Bharat Kosh is one. Promoting education, including special education, employment enhancing vocational skills, especially among children, women, elderly, and differently abled, and livelihood enhancements projects, promoting gender equality, empowering women, setting up hostels and homes for women and orphans, setting up old age homes, daycare centers. Then next is ensuring environmental sustainability, ecological balance, protection of flora and fauna, animal welfare, agroforestry. So if you see, each of these points relate to a particular topic, problem area. So this is hunger, then we have education. So let's just summarize and write it here. So we have hunger, then we have education, then we have gender equality, then we have the environment. So again, there is a mention of a fund here. So first we had the Swachh Bharat Kosh, which was for sanitation and drinking water. And then we have the Clean Ganga Fund, again for rejuvenation of the river Ganga. Protection of national heritage, art, culture, including restoration of buildings and sites of historical importance. So this is basically focusing on the architecture. Then measures for benefit of armed forces, veterans, war widows, and their dependents. So this is for your army personnel, armed police forces, and central paramilitary forces, veterans, and their dependents. Training to promote rural sports, nationally recognized sports, Paralympic sports, and Olympic sports. So this is for sports. Contribution to Prime Minister's National Relief Fund, Prime Minister's Citizen Assistance and Relief in Emergency Situation Fund, that is the PM CARE, Citizens Assistance and Relief in Emergency Situation. So this is a very important fund, or any other fund set up by the central government for socio-economic development and relief and welfare of the SC, ST and other OBC and minority and women. Next, contribution to incubators or research and development projects in the field of science, technology, engineering funded by central government or any other state government. So this is basically for your research. This is your PM CARES. Then contribution to public funded universities, Indian Institute of Technology, then all our national laboratories, autonomous body established under the Department of Atomic Energy, Department of Biotechnology, Department of Science and Technology, Pharmaceuticals, Ayurveda, Yoga, Naturopathy, Unani, Siddha and Homeopathy, Ministry of Electronics and IT, then Defense Research and Development Organization, Indian Council of Agricultural Research, Medical Research, industrial research, and any of these institutes which are conducting research in science technology aimed at promoting sustainable development goals. So this is basically institutions, contribution towards your institutions. And then we have rural development projects, slum area development, and lastly will be your calamity or your disaster management. So these are the areas that the Companies Act has provided for, that, saying that if a company is taking up any CSR activities, then they can take up by contributing to any one of these fields. Next, so to quickly summarize the whole CSR concept. So first one, we understood which companies are the one that are supposed to set up a CSR committee. So it is net worth of 500 crore or more, turnover of 1000 crore or more, and a net profit of 5 crore or more in the immediately preceding financial year. They have to set up a CSR committee consisting of 3 directors at least, of which one will be a independent director. So the committee's responsibility will be to formulate a policy, recommend your expenditure, and also monitor the policy. And if there is any unspent amount, so what is the amount that has to be spent? So you have to first calculate the average net profit of the 3 preceding financial years. If the company has not been in existence for 3 years, then pro rata basis you'll have to calculate, and at least 2% of that should be spent towards pursuance of your CSR policy. If it is not spent, if there is an unspent amount, and if that unspent amount is not for an ongoing project, you have to transfer that to a fund under Schedule 7 within 6 months of end of financial year. If it is relating to an ongoing project, then you have to transfer that within 30 days to an unspent CSR account. Then the amount in the unspent CSR account has to be spent within 3 financial years of the transfer. And if that is not done, then in that case, the amount has to be transferred to the fund under Schedule 7 within 30 days of end of the third financial year. And what are the penalty provisions? So penalty provision for the company will be 2 times of the amount that was supposed to be transferred to the fund, or 1 crore, whichever is lesser. And in case of an officer in default, 1/10 of the amount that was supposed to be transferred, or rupees 2 lakhs, whichever is lesser. Then we saw a list of entire activities that the Companies Act has provided for under Schedule 7, saying these are the activities wherein the company can spend towards its CSR policy. So I hope this is clear. So we have just 2 more topics left for concluding this chapter. So without further ado, let's begin. So here, the first topic that we have here is business ethics. So now, why are we discussing business ethics? So anytime we set up a business, or even if we are working, it is very important to have ethical practices in place, because in today's world, with the aim to earn profit, sometimes ethics are compromised on. So we as company secretaries, we as pursuing company secretary course, it is very important for us to understand the importance of ethics, and why is it that we need to always follow ethical practices. So business ethics is nothing but the application of ethics in business. It is the application of general ethical ideas to business behavior. So ethical business behavior facilitates and promotes good to society, improves profitability, fosters business relations, and improves employee productivity. The concept of business ethics has come to mean various things to various people, but generally it's coming to know what is right or wrong in the workplace. So this is the whole concept of business ethics, that is knowing what is right or wrong in the workplace and doing what is right. So if you're aware of the difference between the right and the wrong, then ethics will be when you choose to do the right thing. Now, it is concerned with the behavior of a businessman in doing a business. Unethical practices are creating problems to businessmen and units. The life and growth of a business unit depends upon the ethics practiced by a businessman. So, business ethics are developed over the passage of time and custom. A custom differs from one business to another. So, if a custom is adopted and accepted by businessmen, the custom will become an ethic. So, custom is something that takes time to build. And once that custom has been brought into picture and has stayed for a long period of time, so that is when the custom will become an ethic. Now, business ethics is applicable to every type of business. Social responsibility of business requiring the observation of business ethics. So, it is also a social responsibility of any given organization to be ethical. A businessman should not ignore business ethics while assuming social responsibility. It means, so what exactly is business ethics? It means the behavior of the businessman while conducting a business by observing morality in his business activities. So, according to Wheeler, business ethics is an art and science for maintaining harmonious relationship with the society, various groups and institutions, as well as reorganizing the moral responsibility for rightness and wrongness of business conduct. According to Rogin, uh, business ethics refers to the right or wrong behavior in business decisions. So here we've understood what exactly is it that business ethics is and why is it required in business. Why is it required as a part of your business? So now, these are principles, practices, philosophies that guide the business people in the day-to-day business decisions. It relates to the behavior of a businessman in a business situation. So, impact of the decision on the society within outside or inside of the business organizations. So now, what are the various business ethic principles that have been developed? So first one is sacredness of your means and ends. So what does this mean? The first and foremost important principle of business ethics emphasizes that the means and techniques adopted by the business to serve the ends must be sacred and pure. So if, say for example, if the business is aiming at a profit towards the end of, say, second or third year, then in that case, how the business gets to that profit, those means have to be sacred and pure. So you should not adopt any unethical practices to reach your end. It means that a good end cannot be attained with wrong means, even if it is beneficial to the society. So you have to stick to the right means, not to do any evil. It is unethical to do a major evil to another or to oneself, whether it is evil means or an end. Next one is principle of proportionality. So this principle suggests that one should make proper judgment before doing anything. So there is a fair view that is taken and others do not suffer any loss. So if we are saying principle of proportionality, it means that we are not only considering our good, but also others' good as well. Next. Non-cooperation in evils, it clearly points out that if anybody is doing evil, you should not join hands with them. You should not cooperate with them. So it is not only ensuring that you are doing all everything that is good and nothing that is evil, but also not joining hands with someone who is doing evil. Cooperation with others. So this principle states that business should help others only in the condition when others deserve help. So we need to be cooperative with others. Publicity. So according to W. Wilson, anything that is being done or to be done should be brought to the knowledge of everyone. If everyone knows, then none gets an opportunity to do an unethical act. So if you are aiming, say if you are aiming to spend around rupees 2 crores towards your CSR, so make it known. So there is a track, there is a check in place that whether the company is doing that or not. Because at the beginning of the year, I may have declared that I am going to spend 2 crore towards my CSR policy, but actually towards the end of the year, I've spent only 50 lakhs and the remaining amount is something that has been distributed amongst the directors itself. Then in that case, publicity becomes very important because it has come to the knowledge of everyone. So they will be on, they will keep a check in place. Then equivalent price. So according to W. Wilson, again, the people are entitled to get goods equivalent to the value of the money they pay. So basically, it means that you should not charge exorbitant prices unless you are matching up to the quality and providing a value for the money that the customer is giving. Next, universal value. So according to this principle, the conduct of business should be done on the basis of universal values. Human dignity. As per this principle, man should not be treated as a factor of production and human dignity should be maintained. So this applies especially like in case of daily wage workers, wherein you need to respect the fact that they are a human being, and just because for the nature of work that they are doing, it is something that they should be given equal respect just as any workman, because their contribution to the functioning of the organization is as good as the contribution of any other person. Next, non-violence. So if the businessman hurts the interests and rights of the society and exploits by overlooking their interests, this is equal to violence and an unethical act. So if you see here, if you have a look at all the 10 principles, it focuses mainly on doing the right thing, taking others' perspective also into consideration, and from a customer point of view, being able to justify the price that you are charging, and respecting all the segments. So you are respecting others as well, your company, the work that you are doing, and all the people that are involved, and all the stakeholders that form a part of your company. So next. So the last topic for this chapter is ethical dilemma. So what happens is there is often a confusion in place whether to go the right way or whether to go the profitable or the easier way. So most of the times the right way is one of the hardest ways to go through, because there is a set pattern, there is a set procedure in place. So instead of that, like say for example, in case of compliance, maybe it is easier to go the wrong way, or to do the follow the compliance, but maybe not in the way it is intended by the law. So sometimes the wrong way is the easier way, or in terms of money matters, it is the it is the more cost efficient way. But here is where we have to deal with this dilemma. So ethical dilemma is basically deciding between two given options during your business. So now, dilemma is a situation that requires a choice between options that are or seem equally unfavorable or mutually exclusive. So it's either this or that. So it's either equally unfavorable or it is mutually exclusive. By definition, an ethical dilemma involves the need to choose from among two or more morally acceptable courses of action when one choice prevents from selecting the other, or the need to choose between them becomes equally unaccepted alternatives. A dilemma could be a right versus a wrong situation in which, so first thing, this is a right versus a wrong situation in which the right would be more difficult to pursue and the wrong would be more convenient. It is not so easy to resolve. It involves an apparent conflict between moral imperatives in which to obey one would result in transcending the other. So this is also known as an ethical paradox. So ethical dilemma is also known as an ethical paradox. Yes. So an ethical dilemma involves a situation that makes a person question what is a right or a wrong thing. They make individuals think about their obligations, duties, or responsibilities. These dilemmas can be highly complex and difficult to resolve. Easier dilemmas involve a right versus wrong answer, whereas complex ethical dilemma involve a decision between a right and another right choice. However, any given dilemma needs to be resolved. Now, how do we address ethical dilemmas? So, ethical dilemma consideration takes us into the gray zone of business and professional life, where things are no longer black and white and where ethics has its vital role today. A dilemma is a situation that requires a choice between equally balanced arguments, or a predicament that seemingly defies a satisfactory solution. It is a moral situation in which a choice has to be made between two equally undesirable alternatives. It may arise out of various sources of behavior or attitude, and as for instance, it may arise out of a failure of personal character, conflict of personal value, organizational goals versus social values. So this is especially in a case wherein it's a profit situation, whether it is profit that you are looking at or whether it is the social values that you are looking at. So business dilemma exists when an organizational decision maker faces a choice between two or more options. So this will have impact on the organization's profitability and competitiveness. So if you're looking at a company point of view, this is more important. But if you're looking at the stakeholder, so stakeholder could be anybody, your employees, your members, or your customers or your vendors for that matter. So while dealing with ethical dilemma, one must act out of prudence. So basically, there has to be an analysis of both the options that are available and the one that is more favorable. So ethical dilemma often results in going for the ethical way or the right way, because at the end of the day, business ethics is something that is very important, that has to be followed by every person involved in the business. So this is it with the concept of company law, wherein we understood in detail right from the origin of a company, Origin of Companies Act in India, to various provisions of the Companies Act 2013. So I hope all the topics are clear, and if you have any doubts, please feel free to drop them in the comment section below. We will be happy to answer them for you. Thank you so much, and we'll see you in the next class.
Congratulations, you've completed half of your portions for legal aptitude subject. The remaining 4 chapters will be there in part 2. You can have access to that video by clicking on the description above. Hiral ma'am has conducted the classes beautifully so that you can easily crack your CSEET exam. The most important thing is we are providing the entire syllabus absolutely free of cost on YouTube. But in case you want to have access to any kind of MCQ questions, mock exams and practice questions, you can log in to www.excelacademy.com and have access to all these additional features.